Well, hello everyone, and good morning, and welcome to Uncivil Law. I hope you're having just the bestest of days. I'm your host, Uncivil Law, a licensed attorney in Texas, Virginia, and before the U.S. Supreme Court, and I hope all is wonderful. For today's story, we turn our attention to the U.S. Supreme Court. It is that time of year, the end of June, when flowers are blooming and people are getting married, and the Supreme Court is upending the world. So, the Supreme Court operates its term from the first Monday in October, and then they end all their decisions by the end of June, except for that one time in the last 20 years when they didn't, and stretched into July, and it was a confusing time. But we don't speak of that. Those are the dark times. Otherwise, they end in June, as they will today, because they have four, but really three decisions. They have birthright citizenship. They have, can the transgenders participate in sports other than their birth gender? And the issue that you really care about, the issue that you came here about in order to figure out, can the RNC give unlimited political contributions in coordinations with a candidate? Truly the most important decision, the one that you're here for, I am sure. The Supreme Court will begin announcing decisions at or shortly after 10 o'clock, depending on whether they want to muse about other things going on today. So depending on whether or not there's other business, they may start at 10 on the dot. Well, even then, not really, because at 10 on the dot, well, even then, sometimes not really. 10-ish, the bell rings for them to walk into the door, and then it takes for them some time for them to shuffle into the place. And then sometimes they do admissions and stuff, or whatever, or opinion announcements. Well, no, that's what we're doing. We're doing opinion announcements today. So yeah, they'll probably start announcing opinions around 10:04, give or take. We'll see. In terms of what's decided when, it is done in reverse order of seniority. Of course, the Chief Justice is by definition the most senior, don't you know, because Chief Justice. Otherwise, it's done in reverse order of how long they've been there. So if you're curious about what decision is being announced in what order, that is the order. Predictions for the day. The birthright citizenship case doesn't really feel like the Chief Justice wants a piece of that. I feel like the Chief Justice has enough controversies in his life. The Chief Justice, incidentally, or the most senior person, as the case may be, in the majority gets to decide who writes the majority. So in case you're curious who writes it, it's whoever the most senior person in the majority picks. So since the Chief Justice will almost certainly be in the majority for the decisions, therefore it's up to him on this occasion. So predictions, birthright citizenship, 7-2 or better, that people born here that are from illegal immigrants are A-OK as citizens. Gorsuch to right seems the most plausible. Your only other real bet is the Chief Justice himself, but I'm not sure he wants a piece of that particular nightmare fuel. So we might get that from Gorsuch, 7-2 or better, that, you know, the children are A-OK as citizens. In terms of transgender sports, 6-3, the states can do what they want. Written by, doesn't really matter. Maybe the Chief Justice picks that one. And then the RNC, which, you know, who knows, 6-3, probably that. I don't know which way that goes, actually, to be honest. I don't know whether that goes one way or the other. I actually don't know which way it would go. I mean, if you had to put a prop bet on it, I guess you'd bet that they're going to rule in favor of political parties giving unlimited donations, but, you know, they might hold that one back. So we'll see. So I don't know which way that one goes. No prediction. So we are just waiting with bated breath for the Supreme Court to Supreme Court. And then I will sit here and explain it to you. And then I will try to decide the degree to which they're right or wrong using first principles. And then I'll try to describe how big a deal it is. For example, yesterday, mail-in ballot case, not that big a deal. In your host's humble opinion. Did the Republicans lose the issue? Sure. Does it really matter the way it was decided? Not really. It's a very kind of it's a very moderate thing. My read on it is stop panicking. Will that be the case for birthright citizenship? I don't know. There's also, of course, some possibility that they don't decide the issue somehow, or limit it to the executive order, or make it go away, which is always a very strong non-zero possibility. In fact, if you were taking odds on what is the most likely thing to happen, the most likely thing to happen isn't the 7-2, that the children of illegal immigrants get to be citizens. The most likely thing to happen is the Supreme Court tries to find some way to not decide the issue. Because the Supreme Court doesn't want that piece of reality, and I don't fully blame them. So maybe they figure out a way to just talk about the executive order or something. And they squeeze out like a 5-4 on the executive order itself is bad, but we're not going to actually rule on the underlying issue. So that's the only other way this goes. A 5-4, or maybe even hypothetically unanimous. Yeah, because that could actually happen. You might actually have a unanimous decision that the executive order is bad, maybe with Thomas dissenting, and then a lot of grousing in concurring and potentially dissenting opinions about how the Supreme Court's super evil. So that's the only other way this goes. Unanimous or nearly unanimous, the executive order was a problem. Or not even like we're just going to do a per curum. It's not even going to be written by a justice. It's just going to be in the name of the court because no one wants a piece of that bullshit. It's going to be a per curum. Yeah, that sounds like the most logical thing to me. It's going to be a per curum that the Supreme Court decides not to decide somehow. Yeah, that's the smart money play. Put your bets down now, players. Per curum, the Supreme Court figures out a way not to decide it. Yeah, that's a smart money bet. That's right. Where'd you guys go? You're still there. Don't they have to eventually? Maybe, but not today. Yeah, I can see them trying to kick that can down the road past the Trump administration and hope that a new president somehow takes the issue away from them. Yeah, that definitely feels like a very strong possibility. Do they have to decide? It's the Supreme Court. Not really. Maybe someday, but today, All right. What is it? We got 4 minutes left on the clock. Excellent. How long can they drag it out? At least to the end of the Trump administration, I'm sure. Where there's a will, there's a way. Yeah. How long can they drag it out? I don't know. When does Trump stop becoming president? Yeah, that's pretty much the same answer to that question. 2029? Okay. Yeah, we can do that. Also, in other news, Clarence Thomas was seen walking around the House of Representatives. He said he was going nowhere. Is he resigning? Could be. I mean that non-ironically. I mean, he's been getting old. And he could very well be announcing his retirement. It's old school. They haven't done this in a while, actually. Like announcing that you're retiring on the last day of the term was kind of old school traditional. And then, of course, Thomas is old school, if nothing else. So we might get a retirement announcement from Thomas today, which would be completely unsurprising. So also that. So that could be exciting. And then we can have a fight over who the next Chief Justice is, in which case I'd like to put my name in circulation. I'd be good. I'm available. I'm 45 too. I'm young. Vote for me. Yes, Roberts. Did I say Chief Justice? If I did, I misspoke. Yeah, Thomas is not Chief Justice. Yeah, very much not. Clarence Thomas is an associate justice. Very much so. Sorry if I misspoke. Oops. Do I want to take the pay cut? Sure. And then I'll still find a way to keep my Uncivil Law YouTube show. That'll be good. Decisions from the bench. Yeah, I'll retitle the channel Decisions from the Bench, because, well, they are now. Yeah, good times. Trump has a bad record for selecting justices. The Republicans in general don't do great on it, to be honest. They have a tough time finding people to be dyed in the wool. It's because Republicans have a brain and we think about stuff. So sometimes we change our mind. Yes, as your new Associate Justice, Justice Mueller will be looking to take more Second Amendment cases. They're going to start relatively small fry, but we're going to take more of them so we can start to build out the case law, because it needs some love. So I'm going to start as your Associate Justice by voting to take on cert some relatively minor but relatively easy Second Amendment cases so we can build up some, catalog of cases. That's my pitch. How do you become Chief Justice? By being nominated to be Chief Justice. That's the only trick. Well, first of all, the position has to be open. That'd really help. And then otherwise, by being nominated to be Chief Justice, you don't necessarily have to have any prior experience as a judge, although that would be really weird, but I guess possible. I mean, Kagan wasn't a judge before she became Associate Justice. So, although being Chief Justice isn't necessarily better, and it comes with a lot of administrative responsibilities that are partly a pain in the ass. So I don't know if I'd want to be Chief Justice, to be quite honest. It's not really that great a gig compared to Associate Justice, in my humble estimation. You don't get any more votes, and you don't really have any more power. So Associate Justice is perfectly fine. I don't need to be Chief. Being Chief ain't that great. Doesn't really do very much, so I'll take a pass. All right, guys, we got a case. West Virginia. We got some dealing with transgenders in the sports. Let's get started. West Virginia versus BPJ. The question before this court is, in these cases, whether under Title IX and the Equal Protection Clause of the 14th Amendment, schools may maintain women and girl sports teams. Of course they can, for the biological females. That is, may schools determine eligibility for female sports based on biological sex. In the past 6 years, 27 states have enacted law that maintain female sports should be for the biological females. I know, the horror. In 2021, the great state of West Virginia enacted the Save Women's Sports Act, which prohibits male students from playing on the female teams. The conservatives are really bastards, aren't we? The law specifies that sex is determined by biology. This is just the wrong think in every way. We all know that. The legislature expressly found that prohibiting biological male participants in the female sports is necessary to promote athletic opportunity for women and girls. Respondent, BPJ, who identifies as female, as a biological male as defined by law and, biology. They sought to participate on the girls' cross-country and track and field teams. They sued the great state of West Virginia and relevant officials for the alleged violations of Title IX and the Equal Protection Clause. The U.S. District Court for the Southern District of Virginia granted summary judgment for the state because that sounds like some bullshit. On appeal, the Fourth Circuit reversed and remanded for further fact-finding. Really? How much facts do we need, yo? The Fourth Circuit said we need further facts. I mean, I'm all in favor of further facts too, but we need facts that need to be relevant, right? They have to be relevant facts. They have to matter. Okay, this is a person who says they're a girl. They were born a boy. We don't want to let them on the female team. And the Fourth Circuit says we need more facts. Like what? What else do you need to know? What other things? I'm confused. Moving on. In 2020, the great state of Idaho enacted the Fairness in Women's Sports Act, which prohibits male students from the female teams. The great state of Idaho is a bunch of bastard bigots, just like the great state of West Virginia. The Idaho law says that sex is determined by biology, again with the wrong think, and the law declares that separate sex teams furthers the efforts for sex equality by promoting opportunities for the female athletes. It also recognizes that physical differences might actually be a thing. The law further found that the benefit that natural testosterone provides to the male athletes is not diminished through the use of puberty blockers and cross-sex hormones. Respondent Hecox, really? Seriously? That's the respondent's name? That's just fucking hilarious. You've got to be fucking kidding me. The student's name is Hecox? In a transgender case? Holy shit. Moving on. Respondent Hecox, no, seriously, that's really his name. We're not making that up. That's not a parody or a joke. That's really his name. Her name, what the fuck ever. Respondent Hecox, who identifies as female, is a biological male. Hecox competed for the women's club soccer team and tried out for the women's Division I trap team. Shortly after Idaho enacted its bigoted law, Hecox sued Idaho. I'll make it through this without laughing, I swear. And relevant officials alleging violation of the Equal Protection Clause. The U.S. District Court of Idaho granted temporary injunction barring enforcement of the mean law. Held, Title IX allows schools to provide separate women and male sports teams defined by biological sex. Well, there's a shocker. Holy shit. What a fucking surprise that is to anyone who can't fucking read. Holy shit. Lord have mercy. Title IX allows for the sex sports, not that kind of sex sports. Get your mind out of the gutter. And West Virginia has permissibly maintained female sports should be for the females. Wow. Title IX prohibits discrimination on the basis of sex, blah, 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 blah. The term sex, as defined in the law, regulations cannot be plausibly interpreted to refer to anything other than biological sex. Whoa. When they wrote sex, what they meant was sex. Fucking, this is just cobbling all the dictionaries together like that female host from the Strict Scrutiny podcast would say. We're just cobbling all the dictionaries together. Okay, when Congress wrote the word sex, you know what they meant? Sex. Wow. The shocking revelations continue. My mind is blown. And cannot be plausibly interpreted to mean anything other than that. What the fuck are you talking about? The ordinary meaning of the word sex, means biological sex and not gender identity or some other bullshit. Sex is an immutable characteristic. Thanks for clarifying that. In addition, Title IX allows separate sports teams precisely because of inherent physical differences. Yes, there are some of those. While BPJ agrees Title IX permits schools to maintain the teams and prohibit most biological males, I'm the specials. Because reasons and hormones. Go fuck yourself. Perhaps quite literally, you're a transgender. Is that a thing? You were one sex and are now becoming the other, so you might be able to actually literally fuck yourself. I don't know. Is that how that works? Blah, 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 blah. End of case. Great, moving on. Let's read some more while we're waiting. I think Justice Jackson is currently screeding from the bench because there's no new opinion. So currently, Justice Jackson is probably saying is probably doing screeding from the bench as we speak. So let's read some more about this. Okay. BPGJ argues that if the biology means biology without exception, then that's not reasonable. Uh-huh. The court concludes that it is reasonable because there are actually physical differences between the sex. It says so right there. In assessing the reasonableness of regulations, the courts must recognize the distinctiveness of competitive sports and safety and competitive fairness that can arise from the bullshit. The court rejects the other Title IX arguments and contends that the school policy violates Title IX because the policy effectively excludes them from any competitive sports teams. That's sad. And also it doesn't. You can participate as a male. While it is an unhappy occasion, I love the sarcasm here. I'm not used to this level of sarcasm in Supreme Court. This is great. This is just maximum chef's kiss sarcasm from a U.S. Supreme Court opinion, and I'm not used to that kind of shit. While it is an unhappy occasion, lol, whenever a student who wants to play sports cannot do so, go fuck yourself, perhaps literally. BPJ relies on Title VII of the Civil Rights Act as support for interpreting Title IX from Bostock, but no, not so much, go away. West Virginia and Idaho do not violate the Equal Protection Clause, challenge West Virginia and Idaho laws, say that biological sex is a thing and that's okay. And we're still talking about this for some reason. It's an important governmental objective because we're going to do intermediate scrutiny, which is fine. I have no problem with that. So we're going to do intermediate scrutiny for a while. That's fine. So it's an important governmental objective. I have no problem with that. And the sex-based classifications are substantially related to that interest. That's just straight, no nonsense intermediate scrutiny. I'm here for it. I can work with that. Respondents acknowledge that the states may exclude most biological males and women from sports given general physical differences. The Equal Protection Clause does not prohibit the states from applying the same principle to all males. States are not required to conduct an individual by individual comparison, more blah, 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 blah. Great. Are we still screeding or is there more? We're still screeding. More reading from Supreme Court. Under intermediate scrutiny test, which is the correct test for sex-based discrimination, the validity of the regulation depends on the relationship it bears to the overall problem, not to the extent it furthers government interest in the related case. Patrick Masters for $5 says, you reading these decisions makes me wonder why you don't teach law. I love a job teaching law. I'd be more than happy to bring this flavor to your legal classroom. Talk to your deans. I am available. Intermediate scrutiny permits sex-based classification is not invidious, but rather reasonably reflects the reality that sexes are not similarly situated in certain circumstances. Whoa. You mean that in equal protection land, we treat like things like, but when it comes to men and women, maybe they're not exactly like in every possible context, because just maybe there are actually differences between men's and women's. What those differences could be, I don't know, but maybe. The as permissible sex-based classification is generally permissible, but not as they argue that it's generally okay, but not okay as to me. Because I'm real. Yeah, that's good. I'm so special. I'm literally generating my own case rationale. That's how special I am. Particularly in sports context, determining the effectivity of puberty blockers and hormones and comparing it sounds like some very detailed bullshit. The legislatures and schools are more appropriate entities to deal with this shit. The argument that the competing laws are unconstitutional because discriminating is unavailing. Challenge laws do not classify based on gender identity or status. They don't. They treat all biological males the same and all biological females the same. We don't care about your transgender status. Very literally, we don't care. Are you transgender? Cool. We literally don't give a fuck. Great. Moving on. There are underlying medical and scientific evidence that there's at least some biological males who identify as females, do not retain physical advantages. We don't really care. The exception in this case doesn't prove the rule. Go to hell. The premise is subject to ongoing dispute, and even if true, would not alter equal protection. Kavanaugh delivers the opinion of the court in which Sotomayor, Kagan, and Jackson actually technically concur in part and dissent in part. So I suppose technically this is unanimous, sort of. Moving on. I'm sure the parts that they dissent will not be that material. So technically unanimous. Really, probably not so much. And now I'm just going to spam the refresh button on the Supreme Court until, there's something else at the top of the page. Good morning, uncivilians. Yeah, so long story short here, on equal protection, or for that matter, even really strict scrutiny, when the test does apply, you don't necessarily have to get into the weeds about each individual person. There is a concept like it can be unconstitutional as a person, but you don't need to like go out of your way to make exceptions for a particular person, right? So, yeah. So once you have met the intermediate scrutiny test, which is that there's an important governmental interest to which there is a reasonable relation, then, you can treat it categorically. So it's okay treating it categorically. Once we justify the categories, which we do, you can treat individuals categorically. That's what it says, right? This is a male. Is this male particularly weak? Does this male not have natural hormones for some reason? Is this male for some reason weaker than every girl we've ever met because of natural biology? Be that as it may, it goes into the square hole. Yeah, and Gorsuch clarified Bostock. Yeah, no shit. Gorsuch was right in Bostock. I thought it was brilliant. But Gorsuch clarifying Bostock, yeah, Bostock is what made me a Gorsuch fanboy. I thought that was brilliant. But no shit that he's going to like try to rein that in a little bit because it's like, look, you dipshits. Yeah, no shocker on that one. Yeah. How many do we have left? Issue 2. 2 more. Who wrote this anyway? Kavanaugh did? Okay. Cool. Not sure it really mattered, but neat. No Woke Speaks says Title IX doesn't explicitly ban boys from women's sports. Well, even assuming that that is true, the relevant question might not necessarily be whether Title IX in and of itself creates the ban, but whether a ban is legal under Title IX, right? So West Virginia passed a law. So there are two possibilities. Title IX itself says the answer, or Title IX just doesn't simply forbid West Virginia's answer. So that's what we did today. They didn't say Title IX in and of itself requires segregated sports. They said that West Virginia is allowed to pass a law which segregates sports. So it is not illegal under Title IX. It is permissible, not compelled by Title IX, if that helps. We are still screeding from the bench. I guess we're going to be here for a while. Anyone got any good stories? Any of you guys can come over to my house and make me some tea or something? Looks like we're going to be here for a while with screed. We're still screeding from the bench as we speak. In other news, in my case, in the West Virginia case that I am currently pursuing, the non-government respondents responded to my motion to dismiss, my motion for summary judgment, and it was pretty hilarious. And I was writing a reply to their response earlier today, and I'm having fun with it because I'm kicking their ass. Still screeding. Someone is still at the bench, still talking about this. Holy shit. Should we power read Jackson's dissent? Hey, it's Nate the Lawyer. Good morning, Nate the Lawyer. Your friend and mine, Nate the Lawyer, is here in the chat. Holla to Nate the Lawyer. Recently went to VidCon. He told me it wasn't what it once was. It's a sad memory of itself. But I hope he had fun. Sotomayor's reading? Oh, good. That means we'll get Jackson also reading. Oh, good. Her response is pretty short? Okay. That doesn't mean that she can't go on and on about it for a day and a half, though. Biology is real, says U.S. Supreme Court. Also, amazingly enough, said UK Supreme Court like 2 years ago when the UK Supreme Court said sex was real. I was shocked by that as much as anyone else was. When did the Supreme Court of UK get some balls? Justice Jackson. As Sotomayor, court did not need to hold that Title IX protects against discrimination on the basis of biological sex. And should not have. I mean, I don't really know how you avoid that, to be honest. Title IX is one sentence long. It says you can't discriminate on the basis of sex. So how you're going to avoid talking about what sex means when that's like the only really operative word in the entire sentence, I'm not sure. But Jackson doesn't think we should have decided what sex means or something. As the majority notes, the people here do not argue that sex means anything but biological sex, which then there's nothing to argue about, and we agree with them, so I don't even know what the problem is. Accepting the concession for the purpose of this case, Justice Jackson still doesn't know what a woman is. Seriously. It's not just a meme. She still doesn't know. They don't even argue it's wrong. That's how bad it is. The transgender people arguing at the Supreme Court themselves don't argue that sex means biological sex, and she still can't figure it out. Holy shit. The same is true, however, of any other athlete sorted in the same manner. Okay. In the context of athletic, the sex may be separated. All this is true even though the holding of Bostock plainly applies to Title IX, which no. Under Bostock's reasoning, sex assigned at birth, but the same is true, okay. No. So you just have a problem with sex-based sports completely. Reasoning here to doubt the soundness of the concession means only sex assigned at birth. You just said it did. Wait, no. You said... Hold on. What bullshit did you say? Okay, BPJ does not argue sex means anything but biological sex. That means sex at birth. But there's reason to doubt it means that. My brain hurts. I'm too educated for this. In so much as I went to like kindergarten. Thus, we've recognized that Congress and discrimination tends to strike the entire spectrum of disparate treatment. That is why in the analogous Title VII context, the prohibition against stereotyping is difficult to explain fully by reference assigned at birth. A sex-based stereotype will not often have anything to do with the individual. That's true. It won't, because we're thinking categorically. It's categorical thinking. If you want to call it stereotype, okay, but we call it a category. This is what women are. This is what a woman is. Does it necessarily apply in every possible respect to every member of the group? No, it's a category. That's categorical thinking. Congratulations, welcome to conservatism. Transgender, perceived for being aggressive on the basis of sex, blah, blah, blah. In short, majority is wrong to decide that sex cannot be... This is good. The majority is wrong to suggest the term sex cannot plausibly be interpreted to refer to anything other than biological sex. My brain hurts. I am not stupid enough for this. I can't, 13579 because I can't even. Have they stopped yelling from the bench yet? Somehow, no. Somehow they are still reading from the bench. Holy shit. Are we just doing the one decision today or what? Well, I don't know. What do you guys want to talk about? You guys watching the World Cup? Enjoying that? I have to tell you one thing. I have been enjoying watching all the TikToks from all the people visiting the United States and finding out what the United States is like. That's been endlessly fun. They seem to be enjoying themselves. I've been enjoying that. That's good. I heard the Scots somehow managed to drink all the liquor in Boston, which is amazing. So that's what I heard. The Scottish somehow managed to drain Boston of all alcohol, which is fucking impressive. Also, apparently the Europeans love ranch. Oh, good. There's another opinion now. Oh, good. Something campaign finance. I know this is the case you really came for. The Federal Election Campaign Act restricts a political party's spending on campaign activities in coordination with candidates. In 2001, the court upheld those as consistent with the First Amendment. Petitioners, a group of candidates of political parties, challenged the political party exemption limits under the First Amendment, arguing that that's not good law. In light of the recent, in light of the prior law, the en banc did exactly what the Supreme Court required them to do. So if the Supreme Court's going to change it, it's not on the Court of Appeals. The Court of Appeals had no choice. The Court of Appeals can't change the law, so the Court of Appeals had no choice. So the Court of Appeals did exactly what they were told to do. So no shocker there. In light of that, this court grants certiorari. Held. It violates the First Amendment. Super. The court has jurisdiction. Blah, blah, blah. Congress shall make no law abridging speech. See Buckley versus Vallejo. Blah, blah, blah. This court has determined political parties, as well as candidates, individuals, an outsized group may make unlimited individual expenditures. This case concerns it by political parties in coordination, limits political parties' expenditures, impairs traditional forms of communications. Statutory limits are subject to closely drawn scrutiny. McCulchin versus FEC. Narrow and narrowly tailored to emphasize limits on political party. The court must assess the government interest, recognizes only one permissible interest, which is preventing corruption, and they may only target quid pro quo corruption. We recognize a quid pro quo as apparent when donor is directed. Ultimately, the First Amendment boils down to whether the limits are permissible in order to prevent expenditures or circumvention of the limits. But the relevant precedent deferred scrutiny to Congress's political party expenditure limits. However, the court emphasized that under closely drawn tests, judicial review must be rigorous, so we were wrong. The court agrees that political party coordinating expenditure limits are not proportional. With respect to earmarking laws, the relevant law treats an individual's contributions in a way earmarked or otherwise directed through intermediary to a federal candidate, and thus subject to limits on candidates. Earmarking rules constitute a target and permissive way for the government to permit circumvention-based limits on contributions to candidates. As explained, vigilant enforcement of the earmarking rules is more precise response. With response to disclosure, the relevant law requires that political parties disclose both the contributions they receive and their spending, including on coordinated expenditures. As court emphasized, disclosures become much stronger because internet. Importantly, the combination of the contribution plus earmarking plus disclosure serves the government and circumvention. Kavanaugh delivers the opinion of the court in which Kagan, Sotomayor, and Jackson join. No surprise. It's just Citizens United, but political parties. It's Citizens United, but political parties. Glad we could clear that up. I know that was the one you were really waiting for. That was the case that you just were dying to know the answer about. So what's left is the big boy. Will it be a Roberts opinion? And that was also written by Brett Kavanaugh, interestingly enough. Who will write it? Will they decide the issue? Will they bounce it, which they almost certainly will? Tune in next time. Dragon Ball Z, blah, 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 blah. No, Thomas doesn't write it. No way they give that to Thomas. No way they let Thomas write that opinion. Not a chance. Well, first of all, he's not going to be in the majority, so there's not that. Yeah, Thomas won't be in the majority. It's not going to go. Let me just spoil it for you. Absolutely, it's going to decide. It's going to be one of two things. Either one, children of illegal immigrants are citizens, or two, the executive order itself is illegal and we're totally not deciding the underlying issue. Let me spoil it for you. It's going to be one of those two things. How you guys doing? Yeah, no. They're going to find some way. Well, actually, it isn't that hard, to be honest. It isn't that hard. It's not like they have to go out of their way. It's ducking, but they don't have to get super creative to do it. So yeah, if they want to just kick it by saying that the EO itself is illegal and we're totally not deciding the underlying issue, and then you know that there's going to be so it's a per curm, right? It's a per curm. Yeah, it's a per curm under 5 pages, and then it goes on with other opinions for 200 pages. Yeah, that's probably what it is. It's a 5-page per curm. This executive order is illegal. Talk to Congress with many pages of opining by various people, but for both for and against. Yeah, that's what my bet is. 5-page per curm. Let's go. Am I right? Don't know yet. Still waiting. Five-page per curm. Or they somehow find a way to dig it, which would just be chef's kiss. That would just be this cherry on everyone's parfait. They somehow find a way to dig this. I'm not even sure how they do that, but that's the only way this gets any more fun, is that they dig it and be like, yeah, birthright citizenship case? What birthright citizenship case? We've never heard of it. That's the only way this gets more fun. Who wants to put money on a dig? Yeah, no, they're definitely not deciding this issue. It's a 5-page per curm, or it's a 1-page dig. Technically a 1-sentence dig with many of thoughts. Who wants to put money on dig? What does dig mean? It stands for dismissed as improvidently granted. It's an acronym. Dismissed as improvidently granted. In other words, we should have never heard this case. We didn't hear this case. Oral arguments, what oral arguments? We have no idea what you're talking about. We've never heard of it before. We don't know anything what you're saying. These are strange and confusing words to us in a language we don't recognize. That's dig. Dismissed as improvidently granted. It never happened. It never happened. We should have a poll. We have just enough time to have a poll. All right, we now have a poll. The poll is what happens? Decided on the merits. Some per current BS about the EO or dig until you reach China. It's up. Is it? Yep. Oh, it is decided by Roberts. Okay, guys, let's do this thing. All right, here we go. No more poll. Poll's over. Let's see what we got. This is going to be interesting, guys. Let's see what happened. The question presented is whether the Constitution of these great United States guarantees citizenship to children born in the United States of parents who are unlawfully or temporarily present. Under the citizenship clause of the 14th Amendment, quote, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state in which they reside. On January the 20th of 2025, President Trump issued his executive order entitled Protecting and Meaning the Value of American Citizenship. The order provides that children born in the United States of parents who are unlawfully or temporarily present here are not subject to the jurisdiction of the United States and thus do not qualify for citizenship under the Fourth Amendment of the INA, which uses similar language. A lot of people sued, some in the name of their children, arguing the executive order violates the 14th Amendment and the INA. The district court agreed, certifying a nationwide class. The court grants search. Okay, hell, children born in the United States to parents unlawfully or temporarily present are subject to the jurisdiction and are citizens. Well, they decided it. So there's that. So they decided it. Which, okay, and Roberts wrote it, which actually I take slight surprise at. Roberts had some big boy pants today. And let's see what the vote is on this. Roberts delivers the opinion of the court in which Sotomayor, Kagan, Barrett, Jackson join. Jackson concurs. Kavanaugh files an opinion concurring, in part and dissent in part. Thomas dissents, in which Gorsuch joins. Alito files a dissent in a 6-3 opinion. Did not see that particular split happening. You got Gorsuch. Didn't see that one. Okay, let's go back and, well, I'll tell you what. Let's just skip the headnotes and just read the case. We're not going anywhere. We're going to be here together, you and I. We're going to read this thing. We're going to read the decision and we're going to understand it. And we're going to think. Well, guys, for everyone saying they're wrong, okay, for everyone saying they're wrong, let's give the Supreme Court a chance. Okay? You haven't read it. I haven't read it. Okay? Let's give them a chance. All right, let's open our minds and do the critical thinking and read and see if they're persuasive or not, okay? Right? We're not the left that just screeds at shit and starts, throwing things. We actually read and then we screed and throw at shit. So, let's, take a deep breath, read, and then we'll decide, okay? Like reasoned people. You're reasoned and I'm reasoned. All caps and treason is not helping. All right, let's see if we can read this and understand. Let's think. No breath, it's BS. Well, you might be at the wrong channel then, because we're actually going to think about it for a while. We're going to think. We're going to read. Here's what I'm going to do. I'm going to read it. I'm going to analyze it. I'm going to assess it for its strengths and weaknesses, probably read some dissent, and then I will provide you an opinion. Reading. Good times. The Chief Justice delivers the opinion of the court. At issue in this case is where the Constitution of this great land guarantees citizenship to children born unlawfully or temporarily present. The 14th Amendment provides that all persons born or naturalized in this great country and subject to the jurisdiction thereof are citizens of the United States and of the state of which they reside. On January the 20th of 2025, President Trump issued his executive order entitled Protecting the Meaning and Value of American Citizenship. The order provides that children born of persons unlawfully or temporarily present are not subject to the jurisdiction of the United States and thus do not qualify for citizenship under the INA. Several parents filed suit. To understand the citizenship clause of the 14th Amendment, it's first necessary to understand the context in which it arose and the opinion of this court, Dred Scott. Wow. I mean, we're starting spicy. You got to give the Supreme Court that. The very first case we mention after the preamble, the very first case we mention for like legal support of the merits is Dred Scott. Wow, we are definitely starting spicy this morning. Holy shit. The story of citizenship in the United States begins with the English common law before the Revolution, which may or may not be a civil war per a recent discussion, lol. The American colonists, like all those in the British Empire, were considered subjects of the sovereign. That arose not from royal fiat, but what the common law conceived as the relationship between the sovereign and the people, and God. The king, Blackstone explained, OG commentator, respect, owes those born within the domains a duty of protection. And in return for those protections, those born with domains owe the king a duty of allegiance. Children born without allegiance were naturally born subjects. As Lord Coke put it, so the unborn have rights, abortion? I don't know. We'll get back to you on that. I'm still reading. Thanks for the super chat. I'm not sure how, no, because we're talking about children born, but we'll see if it has any implications for unborn, but one thing at a time. As Lord Coke put it in the celebrated Calvin case, a dual and reciprocal tie thus connects the sovereign and his subjects. Okay. Because the sovereign's power and thus his duty was limited in various respects, so too was the scope of the rule. He could not demand allegiance from, for he could not protect those born in lands he did not control. Sure. Among those group were people born in the king's lost domains, France, Aquadian, Normandy. Shout out to the Normans. Back when you used to be a kingdom. You know, shout out to the Normans. It's been a while since you guys were a kingdom. You did a whole conquest and everything. And then you became part of France. How sad. William the Conqueror is rolling over in, well, not his grave, because his grave has long since been lost to history. But he's rolling over somewhere. The same held true even in discrete areas within the kingdom that were temporarily outside his control. Aquitaine? Sure. I've never heard of it before. Aquitaine. Should I have heard of Aquitaine? Am I just a bad student of history? Or have I just forgotten? What the fuck is an Aquitaine? I know what the fucking Normandy is. What the fuck is an Aquitaine? What is that? Should I remember that from history? I forgot that one. Charlemagne? I'm just forgetting these memos, man. I'm just forgetting these memos. I forgot. Sucks. Now I sound stupid. Lame. But I know what Normandy is, and I know it used to be like a country, kind of. It was a city-state, but still. So I'm doing all right. Eleanor of Aquitaine, none of these things are striking, none of these things are ringing a bell. Yeah, none of this is ringing a bell. I've forgotten this piece of history. Moving on. And same held true for ambassadors and their families who were considered by fiction of extraterritoriality to remain on foreign soil and thus utter the allegiance, nice word choice, of their home country. In all other respects, however, the sovereign power and his claims to the people's allegiance was complete. It's in Southwest France. I got nothing. In all other respects, however, the sovereign's power and his claim to people's allegiance was complete. A foreign mother could enter the British Isle, give birth, and leave with her child the very next day, and the child would be a British subject. Why? Because the child owed an implied allegiance to the sovereign who protected him at his birth, no matter how momentary and uncertain his presence in the king's realm. They were known as the Franks. The Aquitaines were? It's in Bordeaux? Well, I know where Bordeaux is. I visited Bordeaux, and I still don't know what we're talking about, but okay. They were known as the Franks? I thought that was just, I thought that was just France. But, okay. Yeah. The same rule applies. Sorry to any French viewers who might be watching this live stream right now. I apologize that I don't know about this part of your country. I'm sorry. I've been to your lovely country. I've even been to Bordeaux, and I still don't know about this thing. I apologize. Sorry to my French viewers. Much love. For example, children of gypsies, today called Roma, born in the realm were natural-born subjects, notwithstanding British law at the time that directed the Roma to avoid the realm under pain of imprisonment or death. People, for some reason, really dislike the Roma. Well, let's not talk about that. There's ugly history there in a lot of different dimensions. Let's best move on. For these children, all others born in Britain, the rule was the same. With protection came allegiance, and with allegiance came the state of natural-born subject. The view crossed the Atlantic with the colonists and was adopted with little fanfare after resolution as subjects became citizens. This common law citizenship, known as jus soli, or the right of the soil, prevailed in each and all the states after the American independence and continued to emphasize reciprocal allegiance and protection. When the newly independent Americans confronted a novel situation unknown to England, that of the quasi-sovereign independent tribes, oh Lord, have mercy. Okay, fine. They turned to the principle of the common law. Did the tribes truly govern their people, or were their people wholly subsumed within the United States? Echoing Coke and Blackstone, Chancellor Kent answered with the common law. We have purchased the greater part of their lands, destroyed their hunting grounds, and gradually abridged their native independence. Even so, he reasoned, the United States has never dealt with those people within our national limits as though they were extinguished sovereignties. They were instead dependent nations that maintained a domain of their own. Yeah, we're going to try to deal with the history of the Native Americans. Yeah. Moving on. Indians born under this domain, he concluded, were not subject to the United States, but were aliens, which continues to be hilarious. Native Native Americans are not natural-born Americans. That's the Supreme Court. 1913? Whatever. But yeah, they're not. They were granted by statute like 20 years later. Anyways, moving on. Okay. Indians are not natural born despite being native and, born here. All while encompassing very few exceptions. In a nation of immigrants, an asylum for mankind, that's not... Is there another meaning of the word asylum that has a less negative connotation? Hold on. I actually have to look up the word asylum now. One moment, please. Asylum, an inviolable refugee, as for former criminals and debtors. A refuge granted an alien by a sovereign. Yes, that's true. That's true. A temporary refuge granted political offenders. Any secure retreat. I'm not sure in what sense we're using the word asylum at this point. Are we saying it as a refuge for mankind? Let's go with that. A refuge for mankind. Let's assume that's what he meant. Sure. In Thomas Paine's words, just soli, broad scope, took on particular importance. The young republic attracted tens of thousands of emigres from the old world, the Scotch, the Irish, the French, the German, the Welsh, and many more. Some of whom hoped to stay here a short time. Others thought maybe this was cool. No matter their intentions, however, they could be assured their children would be Americans by birth alone. As Justice Story said, nothing is better settled. The very first of the American legal treatises agreed. Children of aliens are citizens, for they owe a duty at birth to their government. As the antebellum era foremost case on the topic, Lynch versus Clark, Lynch reiterated the common law rule that was the law of the land, for the children of citizens and foreigners alike, including those foreigners, have merely a temporary sojourn. I do like the word sojourn. It is one of my favorite words. I just like it. I like the way it sounds. It means journey, and I like it. Sojourn. Very, very, it pleases me. The promises of American citizenship, Lynch declared, extends to all persons within the jurisdiction. The common law made no distinction on account of race or color. But the slave states did. Okay. As the Civil War approached, more and more Southern states sought to deny citizenship to Black Americans and openly rejected the common law to reach the result. Is this a good time to tell the most racist joke I know? Is this a good time to tell the most racist joke I know? Don't do it? Okay. It's topical, sort of. All right. I will pose half the joke and leave the remainder to you. How about that? We'll make it a learning exercise, you and I collectively. Okay. Here is half the joke. What do you call 5 Black people? Your answers can be found in the Constitution. The rights and privileges that may be entitled to enjoy. On that view, the very prejudice of the caste was unconquerable. Even emancipation could not be conferred citizenship, these states held, because free African Americans still suffered from social and civil degradation. With the common law abandoned, almost 500,000 free Black Americans in the South were left little more than strangers. In the odious decision of Dred Scott, this court imposed the Southern states' belief on the nations. Justice Taney, writing for the court in one of the worst decisions ever, concluded that the words of the people of the United States and citizens have unexpressed and atextual racial components, one that excluded all those descended from slaves, not the Supreme Court's greatest day. They were born in this country, Chief Justice Taney acknowledged, and thus did not owe allegiance to the government, the precise criteria for citizenship at common law. But they were not included and not intended to be included under the word citizens of Constitution. For them, blood, not soil, was the rule. Yikes. Dred Scott was met with shock. Ever since the Declaration of Independence, Justice Curtis wrote, the received general doctrine has been in conformity with the common law that all free persons born within a state are citizens of the United States. Justice McLean said the same. Being born under our Constitution laws makes him a citizen. Northern newspapers condemned Dred Scott as a wicked and false judgment, an atrocious doctrine, a deliberate iniquity, and a willful perversion. Their decision was, in Lincoln's famous words, an astonishing one in legal history. Abolitionists swore to undo what the court had done. By birth, Frederick Douglass insisted, we are American citizens. The Constitution knows that all humans inhabit this country as the people, no matter their color, class, or crime. All I ask of the American people is that they live up to the Constitution, adopt its principles, imbibe its spirits, and enforce its provisions. You know what? As to that much, I agree very much. You know what? That I agree with, for both American citizens and people want to be American citizens. This is what I want. This is what I want for all people of the United States, native born and immigrant alike. Live up to the Constitution, adopt its principles, imbibe the spirit, enforce its provisions, kick ass. Frederick Douglass and I are of one mind. When this is done, Douglass predicted the glorious birthright of our common humanity will once become the inheritance of all the inhabitants of this highly favored country. The court has overruled the common law, but the people would overrule the court. Fair enough. It took more than a decade, and the addition of names such as Antietam, Gettysburg, and Chancellorsville to our national canon. What do those cities have in common with each other? I can't remember anything. Lol. But Douglas's version of our common humanity would be fulfilled. The Reconstruction Congress did not start from scratch. In the midst of the Civil War, the President Lincoln's Attorney General Edward Bates issued a landmark opinion that sought to displace Dred Scott in favor of the common law. Citing key authorities, among them the Calvin case and Kent's commentaries, Bates rejected the premise that citizenship is ever hereditary. Which, if that were literally true, that would mean that children born of U.S. citizens but not born on U.S. soil are not U.S. citizens. Because if they're not on the soil, then, and it's not heredity, then they must not be citizens, I guess. We'll have to put a pin in that one. Every person born in this country is at the moment of birth prima facie a citizen. I'm not even sure what prima facie means in that sentence. Prima facie normally means it's facial evidence of, not conclusory. So normally when you say something is prima facie, what you mean is it's correct on its face. You don't mean dispositive. So if it's prima facie a citizen, prima facie suggests that it can be rebutted. And now I'm even more confused. He acknowledged that there were some limits, hence prima facie. Okay. But those limits were few. The small and admitted class of natural born composed of children of foreign ministers and the like. Okay. To Bates, it was soil, not blood, that furnishes the rule of both duty and rights. Okay. A year after Lee's surrender at Appomattox, Congress sought to overturn the Bates opinion, sought to turn it into law. The result was the Civil Rights Act of 1866. The act declared that all persons born in the United States and not subject to any foreign power, excluding Indians not taxed. Again, those Native Americans do not count. Those dirty, dirty Indians, despite being born here since time immemorial, they still don't count, are not subject to any foreign power, are citizens of the United States. To the Reconstruction Congress, the act was simply assumption of the common law, as Bates had the ablest and most exhaustive opinion. Appomattox? Oh, you and I just pronounce it differently. That's fine. I can live with Appomattox too. I grew up in the South, so we just pronounce it differently, but I'll try to remember the way you prefer it. That's fine. Indeed, the bill sponsor, Senator Lyman Trumbull, enthusiastically agreed with the bill's critics that would make the children the citizens of Chinese and Gypsies born in this country. Even the infant child of a foreigner born, you're from Alabama, respect. South Carolina, holla. Even the infant child of a foreign born in this land is a citizen under the bill. The specter of Dred Scott, however, loomed over Congress's efforts. Opponents of the act contend that Congress could not grant such expansive citizenship and set aside this court's precedents by statute alone. Why not? But fair enough. To quiet these concerns and permanently enshrine the common law, we turn to the Constitution, which, fair enough. What the Civil Rights Act began, the 14th Amendment would finish. Like the act, the 14th Amendment was intended to repudiate Dred Scott. That much I think we can all agree on. This time, however, the goal was even grander, to put the great question of citizenship. Well, this has been a fun stream. This has been a fun stream. If you'd like the stream to continue, please insert 25 cents into the coin box. Okay, moving on. This time, however, the goal was even grander, to put the great question of citizenship beyond the legislative power. The 14th Amendment achieved its aim. The citizenship clause mirrored the common law's criteria for citizenship. The clause starts, like the common law, with the territory. The child must be born in the United States, not elsewhere, even to American parents. Okay. And the clause ends, again, like the common law, with the sovereign power. A child must be subject to the jurisdiction of the United States, unlike, say, the families of foreign ministers. A child born on American soil and subject to the American law was made an American citizen. Even the language of the clause is that of the common law. It doesn't, Scorpio, it doesn't necessarily have to be retroactive because remedy is for the Supreme Court. So although it would be slightly awkward, the Supreme Court could, and were they to go the other way, almost certainly would make any decision make any decision only prospective. There was basically no chance whatsoever if the Supreme Court went the other way, they were going to make it retroactive because it's just too much a pain in the ass. So could the Supreme Court have gone the other way and also made it only forward looking? You bet your ass. Wouldn't be the first time either. So yeah, that's not the problem. Yeah. The EO itself also did not apply retroactively. This is true. That's a fair point. Let's see, where were we? Little wonder then the Citizenship Clause principal author, $10 from Heartbreaker. I think Scalia would have been better suited to write this. Fair. I think the court does not have the vocabulary to opine on this sensitive subject. Also fair. I miss Scalia. We appreciate the $10 super chat. Thank you very much. Okay. The law was clear. Any child born under the protection of the United States, that is, any child for whom no extraterritorial factors or fiction applied, was made a citizenship for whom he owned his natural allegiance. Even putting the common law to one side, the Citizenship Clause key phrase, subject to jurisdiction, requires the same result. Which, yeah, I mean, what the common law held is a little bit neither here nor there. What the Constitution means is the game. Now, the common law, of course, can be very informative as to the Constitution, but ultimately the Constitution is the thing, so fair enough. They forgot the comma. Maybe there's more than one version, and maybe there's a dispute over the comma. Wouldn't be the first time for that too. So you say that they recited a version without the comma? Maybe they're using a different edition that doesn't have the comma. Would not be the first time. In fact, I know that's true. Yeah, that comma is very famously unclear whether it's there or not there. The comma itself is in dispute. Yeah. On the original, it looks like a smudge. Where no one's quite sure if the comma's there or not. Doesn't matter. Moving on for the purposes of today's argument. The National Archive version has the comma. Does it though? Does it? Yeah, no, yeah, it's a thing, man. It's a thing. Moving on. Even putting the common law to one side, the Citizenship Clause key phrase, subject to jurisdiction, requires the same result. The word jurisdiction was hardly unknown to the drafters and ratifiers of the 14th Amendment. Congress chose to use an established legal term, and the clause must be interpreted in that light. In 1868, as today, jurisdiction in the context of sovereignty, also like comma use and things like that weren't as settled back then. It's like in the Second Amendment, how many commas does the Second Amendment have? Does it have one or does it have three? I don't know. Because they're not consistent. Yeah, it's a whole thing. English grammar and spelling is kind of optional at this time period. Moving on. Okay. Where were we? To subject to the jurisdiction of the United States is then to live under its domain, and being reinforced by the clause's territorial focus on those born here. The Citizenship Clause's jurisdiction in the ordinary sense referring to people of the United States to govern those within the territory. The scope of that power was well settled in 1868, which of course is the operative period, largely by the celebrated case of schooner exchange. Sure. Expounding on the general principle, Chief Justice Marshall explained that jurisdiction referred to the full and complete power of the nation within its own territory. That absolute power was susceptible of no limitation, not imposed by the nation itself. All sovereigns, however, were understood to have implicitly waived their jurisdiction in certain particular circumstances or peculiar circumstances. In essence, where exercising jurisdiction would degrade the dignity of the foreign sovereign. And in the context of just solely, those peculiar circumstances arose most frequently in the case of foreign ministers. Every sovereign would hazard his own dignity, after all, if his own officials abroad own temporary and local allegiance to the foreign prince. The limits of that exception were carefully defined. Still within the limitations of the United States power were private individuals of the foreign nation who had spread themselves throughout our territory as business or caprice may direct. Yeah. Caprice is one way of putting it. It would obviously inconvenient and dangerous to society and would subject the laws to continual infraction if such individuals or merchants were not amenable to the jurisdiction of the country. Cute. Nor can the foreign sovereign have any motive for wishing such an exemption, he continued, with respect to its sojourning subjects, who are not employed by the sovereign or engaged in national pursuits. Just like just soli, a sovereign's jurisdiction made no exception for those only temporarily present within the sovereign's territory. Instead, nearly everyone within the territorial boundary of the United States was amenable to the jurisdiction. Sure. We're still reading, guys. Yeah, commas. And of course, even today, we still argue about the Oxford comma. So it's not like even today we agree about commas. Although I am team Oxford comma until I die. Who gives a fuck about the Oxford comma? You're looking at them. No such intra-sovereign concerns apply to children born of parents unlawfully or temporarily present in the United States. No foreign sovereign would have any motive for wishing them outside the nation's authority. For those of you not familiar with the Oxford comma, it's also called the serial comma, the last comma in a series before the word and or. It's called the Oxford comma or serial comma. Look it up. And there was a song about it by Vampire or Weekend or Diaries or whatever their name was called. Who gives a fuck about the Oxford comma? Yeah, moving on. They satisfy both the elements of citizenship, that they're born in the United States and subject to the jurisdiction thereof. They are citizens at birth. Our precedent, the seminal case, Wong Kim Ark. Well, I will agree with this. Wong Kim Ark is the most direct precedent on point. I certainly don't think it's dispositive, but it is certainly the one that, comes foremost to mind. So, for better or worse, that much is true. For nearly a decade, or nearly 2 decades after the 14th Amendment, view the citizenship clause as simply affirmance on the common law. Okay. Under that view, citizenship was fixed by nativity, irrespective of parentage, with limited exception of children born of foreign ministers and other persons who may be within our territories of extraterritoriality. That's a hard word to say. In 1872, I know the difference, Sean. I understand that. It's just the most operative precedent on point, but we'll work with it. Let's keep talking. In 1872, the Attorney General, George Williams, was called upon to determine citizenship of a new child born of Austrian parents, only temporarily residing in New York. Goddamn Austrians. Williams explained that a person born in this country through of alien parents who had never been naturalized is under our law deemed a citizen of the United States by reason of place of birth. So said the Attorney General in 1872. For a person temporarily on a travel visa, I guess, or whatever the 1872 equivalent would be. Thus, a child is a native of this country, Williams concluded, and as such was originally clothed with American nationality. Cute. Like the executive branch, they saw the clause as merely declaratory of the rule of common law. Thank you for the 631 of you who are here, by the way. If you'd be so kind as to hit the like button, it would help. This content, a lot of people on YouTube consider to be a little bit dry. So I'm not beyond asking for you to hit the like button on this, because a lot of people, and also there's that hype feature, which I don't know how that works. If you've got some hypes and you want to give this channel some hypes or this stream some hypes, that would be nice too. Because this content's a little dry and I could use the algorithmic boost, to be quite honest, because this kind of content can drain my channel a little because it's not, super spicy and stuff. It's a little dry. So if you could hit the like button and whatever that hype feature is, that'd be great. Thanks. Did someone retire in the last 5 seconds? Hold on. They might have. Hold on. Talk amongst yourselves. I'm not seeing any announcements of any decisions that of any resignations or retirements. So not seeing that, but I don't have hype enabled. You can't hype a live stream. As I say, I have no idea how the feature works. Hype a previous video then. I don't know. I don't know how it works. Hype something. I don't know what a hype is. It's a new feature. I don't know how it works. Where were we? I was explaining the law for good and ill. NPR is reporting that Alito is retiring, but then pulled it down. Did NPR have a story rewritten, ready to go, and accidentally hit the publish button? Oops. Yeah, Alito has also been on the probably retiring list. Someone at NPR hit the wrong button. Someone needs to send a fruit basket. Yeah, someone hit the wrong button. Anyways, where were we? As an era of Reconstruction faded, however, so too did the promise of birthright citizenship. Uncertainty came with the Chinese Exclusion Act and the election of President Cleveland, the first Democrat to hold the office since the Civil War. A dark time indeed. It was around this time that the State Department began to deny citizenship to those with dual or doubtful allegiance. And it was around this time that several scholars proposed a new theory of the clause, one based on international law. This new theory founded on the parent status, not the child's. It was only if the parents who were domiciled in the United States that argued that the children were internationally subject to the jurisdiction of the United States. Those writers acknowledged the common law took a different view and acknowledged the language of the 14th Amendment is very broad. But they insisted that just soli had been universally rejected by other nations and not made part of the Constitution. Yeah. You can only hype after the live ends. Well, then hype yesterday's live, I guess. I don't know. Go to yesterday's live and hype that. I don't know. Anything to help. In Wong Kim Ark, it's free and it probably helps. Thank you, Investicor, for being a subscriber. We do appreciate it. Okay, yeah, someone just hit the wrong button at NPR. Oops. $10 from Ann Bell Feinstein. Hype is mobile only. Okay. You get 3 hypes per week. Creators can turn off hype. Videos have to be less than 7 days old. Hype is post live stream. Okay. All right, fine. Good. Thanks. Dobbins' dissent's 91 pages. That makes sense. We're not reading all that, I'm sure. At issue of the citizenship was Wong Kim Ark, born in San Francisco to Chinese parents. In Wong's telling, the case was not closed. There can be no just doubt, he argued, that the amendment was intended to be based on the doctrine derived from the common law that the character of a child is incidental to birth only. The government disagreed. It admitted that the opinions of the attorneys general, the decisions of the federal and state courts, and up to 1885, I just had a very weird thought, and I don't know why that thought just crossed my head. You know how, like, on the Whatever podcast, and not just that one, but the Whatever podcast comes to mind, they have a bunch of women on and they ask them really basic questions like, what country did America get its independence from, and when was World War I? Maybe we should let the learned scholars of the Whatever podcast to discuss the finer points of this decision. I'm sure they would be good. Heartbreak is $100 as a very generous super chat to say, read it all. I will do my best until my voice gives out. Thank you very much for that very, very generous super chat. Yeah. Well, I guess I will, in my call of action, mention to hype the videos now. Lame. Moving on. Thank you for the $100 super chat. Hype something. I don't know. I don't know. The government disagreed. It admitted the federal and state courts up to 1885, the rulings of the State Department all concurred the view of birth in the United States conferred citizenship based on the common law doctrine of allegiance and authority of the decision of the Chancellor in Lynch versus Clark. But the executive no longer endorsed that view. The common law doctrine of England has never been the doctrine of the United States. It was not made by the law of the Constitution, so they argued. Excuse me. Yeah, the United States could say that any woman more than 5 months pregnant could not enter on a tourist visa. Yeah, the United States is God on that. Yeah, if Congress especially can pass a law, Congress can do anything when it comes to the border. Congress can exclude anyone probably for any reason, even like shitty reasons, even reasons that are otherwise constitutionally suspect because their power is so high. So yeah, you get Congress to pass a law and you can kind of have any immigration law you want. So, you know, have fun, I guess. Good luck, have fun. Okay. In opinion by Gray, the court rejected the government's position. Gray explained the 14th Amendment merely declaratory of the fundamental rule of citizenship by birth that prevailed with the common law. The same rule was enforced in all the English colonies and prevailed under the Constitution. And the contours were clear, excluded those recognized exempt from the jurisdiction of this country, the children of ambassadors and other representative foreign sovereigns, as well as the alienations of the Indian tribes. Cute. All others were citizens at birth, whether born to permanent or temporary visitors. And Justice Gray noted no one had ever contested this conclusion for more than 50 years after the adoption of the Constitution, until the matter was elaborately argued before the New York Court of Chancery in Lynch versus Clark, which is a court of equity, for those of you unfamiliar with the term. Back when states, and some states still do for reasons that completely pass my understanding, but law and equity were historically separate concepts. And at this point in history, they were still separate concepts in the United States. And in most states, they've been combined because it's a lot more efficient. So the Court of Chancery is a court of equity, which still exists. We just also merged it in with law. That's advanced legal discussion, though. We don't really need to get into that right now, just in case people were curious about the term. It refers to equity, which is a valid legal concept. It doesn't mean the same thing that equity means today. We don't have time for that. Let's move on. And their decision was defined upon full consideration by the vice chancellor in favor of the citizenship. Think judge. The doctrine was repeatedly affirmed in the executive department. Justice Gray wrote, not by mention by Kent and Binney, each of whom affirmed the child of an alien born in the country is as much a citizen as a natural born child. Yeah, immigration law may exclude those not covered by the Constitution, which would be everybody by definition. Yeah. So, yeah. Justice Gray, then within the context of immigration, that is, because citizens don't immigrate. So, yeah. Anyways, moving on. Justice Gray then turned to Schrodinger's exchange to confirm what the common law made clear. The words subject to jurisdiction thereof must be consumed to have been understood and intended by the Congress in the same sense in which the words had been used by Chief Justice Marshall in the well-known case of the Exchange. Nice name, case. On the understanding, aliens who travel to the United States for business or pleasure receive no exemption from the jurisdiction of this country. To the contrary, they were subject to the jurisdiction for as long as they remained here, and any child born to them was an American citizen under the 14th Amendment. What this court held in Wong Kim Ark was simple. The citizenship clause incorporated the common law and granted citizenship to nearly all children born in the United States. I'm not sure that's what Wong Kim Ark actually said, but moving on. Not surprisingly, then, in 128 years since, we've repeatedly understood the rule of Wong Kim Ark to guarantee citizenship to all children born in the United States. I'm not really sure that's what Wong Kim Ark said, but okay. We see no reason to depart from that view. Well, if that's what Wong Kim Ark had said, I guess, but not really, not so much. I've actually read it. The government and the principal dissent share many of our premises. $30 from Good Day. Thank you very much for that very generous super chat. That's very appreciated. I am feeling your love. Thank you. I appreciate the chats. It does make a huge difference to keep the channel going. Thank you. I've been feeling poor lately, so it really does help. Where were we? They agree the citizenship clause was intended to incorporate the background principle of the common law. They agree under the common law, citizenship turns on allegiance, and they agree that Dred Scott departed from that traditional allegiance-based view of citizenship, a departure that Congress had repudiated by the clause. Where the government and the principal dissent error is where their definition of allegiance. They concede the Calvin case and Blackstone state the rule that prevailed before the Declaration of Independence, that a natural allegiance arises from children born here under the protection of the sovereign. Yet according to the government and principal dissent, the United States' conception of allegiance at some unspecified point in time broke from Great Britain's. The government has variously dated this change to the late 18th century and early 19th century and the Reconstruction era. The principal dissent declines to offer a date. Well, it doesn't necessarily have to be a particular date certain. It doesn't necessarily need to be like it happened exactly at this particular date. As long as it because that's not really how we normally think about things. We don't normally, I don't know what the answer to this question is, and I don't even know if there is an answer to this question, But this would be a little bit like saying, when did slander stop being protected as speech? Right? I don't know if there's an answer to that question. But if there is, it probably didn't happen on a particular date. So, anyways, moving on. It's probably something that happened, kind of more organically, I would think. Thank you, Casey, for the subscription. Subscriptions help. We appreciate it. We're at 162,000 subscribers, so let's keep it going. All right. Let's see. Natural allegiances, they contend, were no longer sufficient for citizenship. Some greater quantum of allegiance was required. How much the government offers a smorgasbord of formulations. Primary allegiance, sufficient allegiance, full allegiance, requisite allegiance. The principal dissent, for its part, seems to have settled on primary allegiance. What all these formulations supposedly share is they turn on domicile, the place of one's permanent home. Which is a legal concept, to be sure. At some point before ratification of the 14th Amendment, the argument goes, it became deeply rooted in this country that domicile is a key concept that creates allegiance. The trouble is that there's scant evidence for this dramatically revisionist view. Yeah. Memberships are also good. Both are good. Indeed, even in the antebellum Americans hotly debated whether the Declaration of Independence had abrogated one key aspect of the British common law, that natural allegiance was indefeasible, no matter a person's desire to expatriate. All agreed that such allegiance was owed in the first place. The only evidence the government and the principal dissent can muster, I need to put my glasses back on because my eyes are hurting. These are light-sensitive glasses, in case anyone's wondering. They're non-prescription. They just help with light sensitivity. And my eyes are hurting, so time to put them back on after I clean them. Okay, great. The only evidence the government and the principal dissent can muster to show that the alternative conception of allegiance displays the common law is a funeral oration for President Lincoln. I don't think that's the only evidence. Ahistorical modifiers aside, the government and dissent identify no source that identified allegiance's birth as being based on domicile. I feel like there's some quotes from people around. Okay. Sources from that period instead define allegiance by birth, just as the British did, as the tie or duty one owed by one who is born within the dominion and under the protection of the particular sovereign. Of course, some wish to change the rule, but even those who wish to limit jus soli did not deny that children born of temporary visitors owed natural allegiance to the United States. They instead thought that domicile might serve as a reasonable qualification to the common law rule, namely that citizenship derives solely from natural allegiance owed to the government of the territory of a man's birth. The principal dissent, but not, thank you, $2 for Don for the shades, thank you. The principal dissent, but not the government, at times seeks to directly equate domicile and national citizenship. That's wrong. They are definitely not the same concepts, that's for sure. I'm sure the dissent doesn't do that. I'm pretty sure the dissent wouldn't be that sloppy. And that feels like a caricature and a straw man of the dissent without me even reading it. Because I'm pretty sure the dissent knows the difference between those two concepts. It is, in fact, a general axiom of international law that there may be domicile where there's no nationality, and nationality where there's no domicile. Fair enough. Sure, why not? After all, one who establishes a domicile in a new country does not automatically become a citizen. True enough, that's true. You look good with the shades, thanks. Nor does he automatically lose his prior citizenship. Thus, the principal dissent ultimately acknowledges domicile alone was insufficient to make someone formally a citizen. Yeah, but that's not... Yeah. Of course, domicile was relevant to naturalization and expatriation, but that by no means suggests it was a prerequisite to national citizenship birth. The principal dissent, can I just say as a personal pet peeve, I really hate the Supreme Court hyphenating words at the end of sentences. It makes it harder to read. Why? Just skip to the next line. And unless the word is so long, it won't fit on a line. Just skip to the next line like a normal person. Kill me. Maybe I should start reading them in hyphenation. The principle dissent, reliance on cases concerning changes to a person's state citizenship is thus misplaced. And the government's remaining support for the idea that domicile qualification of birthright citizenship was widely accepted in the United States before the Civil War, or during or immediately after, consists of a single state case about citizenship in the Republic of Texas, HALA, a proposed but never adopted model code for the state of New York, and another treatise that discussed the subject only in terms of the principles of natural reason, which expressly distinguish the common law. Again, I feel like some of the people who were involved in the proposal and ratification of the 14th Amendment said some things, and I feel like you're not giving that weight. Alito did not retire. The congressional debates over the Civil Rights Act of 1866 and 14th Amendment confirm our view. The principal dissent lean heavily on the handful of ambiguous floor statements. Okay, this is where we get to something that's a little bit more meaty, hopefully. This is a little bit more meaty, hopefully. Let's see what they deal with the congressional debates, because that's a little bit more interesting. The congressional debates over the Civil Rights Act of 1866 and the 14th Amendment confirm our view. The principle and dissent and government lean heavily on a handful of ambiguous floor statements referencing temporary sojourners and foreigners. See, for example, Representative Wilson, who said, it may be that children born on our soil to temporary sojourners do not fall within the Act's scope. See also Senator Howard, who said, would not, of course, include persons born in the United States who are foreigners, aliens who belong to family members of embassies of foreign ministers. Far more frequent and explicit, however, were statements embracing the common law. See Senator Trumbull, Senator Morrill, and Representative Cook, Representative Lawrence, Senator Wade, Senator Collins, Senator Henderson. And debates made clear that no member of Congress seriously grappled with domicile-based carve-out to the fixed, certain, and eligible rule. All right, fair enough, I guess. For Congress's intent on putting the question of citizenship once and forever to rest, a domicile-based qualification would have introduced significant uncertainty. Unlike the easy-to-apply common law, it would be difficult, if not impossible, to lay down a general rule of domicile. I'm not sure about that, but okay. As domicile often depends upon the circumstances of each case. Well, it depends. If we mean I just declare domicile because, then yeah, it might be difficult. If domicile, we mean that the Congress gets to define it because it's a legal term and it means, for example, green card holders, then less so. So it depends. What exactly are you trying to define? Domicile is, of course, a legal concept. It can be defined easily. Heartbreaker for $20 says, new EO, all children born of illegal or non-citizens are taken as dependents of the U.S. and parents are deported, have no rights of children or any rights of remaining beside the child. Well, halfway, the way you're phrasing it, not so much, but the end conclusion, yes. The ability to deport children who are citizens and the ability to deport their parents who are not the same thing. So there is no problem with a law that says deport the parents. Anchor babies do not have to be a legally recognized concept. The baby might have citizenship that does not speak to you, is not a problem. So your phrasing is a little sloppy, but the end conclusion, not a problem. You can, in fact, separate parents from their children when the parents are non-citizens and send them home. And as to their children, you can't deport them. Presumably the parents can take them with them if they want, but it's neither here nor there. Pressing on. Okay. So they say it's difficult, if not impossible, and I'm like, I don't know about that. The combinations are infinite. Yeah, but no. Domicile is not... All right. We need to talk about this concept a little bit, just because it's a legal education channel, and I want to provide you some legal education along the way. All right. So domicile and residence are two different concepts in law. You can have multiple residences. You can have multiple homes. You can live in multiple homes in multiple different places, but you can only have one domicile, which incidentally, legally, doesn't necessarily have to be any of those places. Okay. Domicile is the place of your permanent home, is the place for which you intend to return. So up to and including, you being a member of the church, for example. You're a member of the church, and you feel the call of God to be a priest in another country. So you do. And you're an American. So you do. And you go live for 20 years somewhere else, living, eating, and preaching among the people, as you do. Okay, where's your domicile? I don't know. Not from what I've told you. I don't know enough information. There's not enough information in the equation, because your domicile could very well be in the United States, even though you haven't been there 20 years. Or it could be no, I don't really plan on ever going back. So domicile exists until it's changed. It exists at the place of your birth, and then it's changed by your deliberate intent to change it. And you can only have one of them. And it is not necessarily determined by where you spend the most time, as I say, right? You can spend 20 years in a completely different country, and that doesn't necessarily change your domicile. So it doesn't necessarily afford itself to something I can immediately point to and be like, that's the thing. That being the case, however, domicile is a thing that pops up from time to time, perhaps most frequently in wills and estates. If a person dies, what state did they die in for the purpose of administering their estate, right? Which court, is going to hear their case? Or at least what state law applies, right? So it pops up from time to time. So that's what domicile is, just to educate you a little bit. Now you know more than you did before. I hope that was helpful. Yeah, where's a carnival barker domiciled? Yeah, exactly. This is if you're a traveling salesman, you're a carnival barker, you rarely spend a week, more than a week or a month anywhere in particular. Where's your domicile? Don't know. Where were you born? We'll start with that. We'll work from there. But yeah, you can be traveling. You can spend 20 years in one place. You can never spend anywhere really particularly long. Nice to see you, Defense Diaries, by the way. Hope you're doing well. Glad to see you on the channel. Friends of the channel, I slept on their floor. It was comfortable. Love you guys. If Congress intended to hint citizenship on each individual domicile, a question that's sometimes a matter of great difficulty to decide, which, it's reasonable to expect there have been some discussion on the topic, yet the word domicile appears just twice in discussion of the relevant position, and appears only in one speech from the citizenship clause debates, a part of an explanation of why state citizenship is distinct from national citizenship. Fair. Aren't missionaries required to periodically return to domicile to maintain it? No. In this situation, we're talking about a U.S. citizen, by the way, because we're talking about someone born in the United States. If a U.S. citizen is born in, Chicago, to honor our new Pope, for example, is the Pope still domiciled in Chicago? I don't know. Maybe. I don't know. Maybe. Well, could be. Someone's going to have a fight over it, someday. It's definitely going to be a thing. Moving on. Perhaps recognize the absence of ratification era support for domicile-based rule of national citizenship. The government and principal dissent both emphasize the sources from after ratification of the 14th Amendment. They both turn to the same international law treatises that underpin the government's attempt to limit birthright citizenship. The fundamental revisionist scholarship in the post-1884 executive branch actions that rely on it did not put in doubt the understanding of the citizenship clause. As Senator Trumbull explained in 1871, the citizenship clause recognized that every person born within the jurisdiction of the nation was a citizen, as has been true under the common law of the country as well as England. In any case, the pre-enactment history cannot override the text. Which, fair enough, but Gorsuch is in dissent. So Gorsuch has some thoughts about that, I'm sure, because Gorsuch is your textualist. So you would expect Gorsuch to write this, but he's in dissent, so not so much. If Congress intended to limit American citizenship children of those domiciled, nothing in the succinct language of the citizenship conveys that design. That's fair. I mean, if that's what they're trying to do, they didn't use a lot of words to that end. That's fair. Words appearing frequently in the executive order, mother, father, lawful, temporary, are absent for a simple reason: they did not matter. And while the clause does ensure a state citizenship that attaches to U.S. citizenships in the state where they reside, presumably domiciled, but never mind, the explicit invocation of residence for state citizenship only highlights the absence from criteria for U.S. citizenship. When the principal dissent does grapple with the operative legal text subject to jurisdiction in the United States, it has little to say. It argues only that a person is subject to jurisdiction of the government of his domicile, but that's not the question. The question is whether a person is subject to the jurisdiction of the government in which he's physically present, even if only there temporarily. He is, unless he falls under one of the familiar exceptions, such as ambassadors or the Native Americans. Lol. For reasons given by Chief Justice Marshall in the Schooner Exchange, the United States excises full and complete power of its absolute and complete jurisdiction over temporary visitors. To avoid these problems, the principal dissent spends much of its time on the text of the Civil Rights Act. The Civil Rights Act made citizens of all persons born in the United States and not subject to any foreign power. The principal dissent contends that a person is not subject to any foreign power if and only if he's domiciled in the United States, for then and only then his home nation is forbidden from regulating his conduct. Justice Alito contends that a person is not subject to any foreign power if and only if no other country will automatically make him a national. Neither theory works. Ow. As the principal dissent, it's simply not true that domicile in a new nation serves severs one's ties to the old one. I can read words, I swear. Generally assert a claim to regulate rights, duties, obligations, and act of their citizens wherever they may be domiciled. If the test is truly where a person is amenable to laws of two governments at once, then it is a test that every child born to a foreign parent fails, a result that even principal dissent cannot subject. That's not okay. I don't think that's what the dissent is arguing either. It feels like they're strawmanning the dissent a little bit, to be honest, and their own precedent. Justice Alito seems to recognize this bias, so he created an ad hoc exception for those parents who've done everything within their power to become Americans. He does not explain how that exception becomes squared with his view of the text, which is to repeat that anyone automatically made a national of its parents' native home country is not entitled to citizenship. In our estimation, the act raises more questions than it answers, and was replaced by the 14th Amendment, which better expresses the view of Congress anyway. Fair enough. I mean, Constitution does beat statute, so fair enough. It's hard to argue with that position. The dissent is spitting some logic. They're strawmanning a little bit, I think, the other side, but I haven't concluded they're wrong. But they are definitely spitting some truth. I haven't reached an opinion yet as to whether I agree with them or not, because it feels like they're strawmanning the dissent, so I need to read some dissent first. For the dissent and government, Wong Kim Ark is essentially irrelevant. I don't think that's correct either. I don't think that's what they're saying. The attempt to narrow the precedent by noting the courts repeatedly refer to domicile of Wong Kim Ark's parents. That's true. But the reasoning underlying the holding cannot be squared with the domicile requirement of the sort the government envisions. They mentioned the word domicile like 80,000 times in Wong Kim Ark. As we've already explained, the court exhaustively canvassed the text and history of the Citizenship Clause. It traced an unbroken line from the English common law into the founding and antebellum era and through the debates to the clause's ratification. Yet no point did the court identify any evidence in the historical record that ratifiers of the 14th Amendment thought themselves to be imposing a domicile limitation. In the end, it is the dissent in Wong Kim Ark that makes the strongest case for domicile-based theory of American citizenship. There, Chief Justice Fuller resisted the application of the common law, because it recognized no exception in the instance of birth during the mere temporary or accidentally sojourn of the parents. He admitted that in England, the question of domicile is entirely distinct from that of allegiance, because the one relates to civil and the other relates to political status. But he believed a different view as to the effect of permanent abode on nationality had been expressed in this country. Under the different view, the 14th Amendment prevented the acquisition of citizenship. The children of aliens whose parents owed local and temporary allegiance remaining subject to a foreign power. The government and today's dissenters disagree. By the time commanded in 1898, but this view commanded only a dissent in 1898, and neither circumstance nor fact changed the law. Again and again, dissents cast the common law as feudal, medieval, a remnant of the darkness. Do they? Because if they did, that'd be a really dumb thing to write. That was not a view of the Reconstruction era. When dissents see feudalists, the framers of the 14th Amendment saw emancipation. By the time of the Glorious Revolution in 1688, in fact, the tie that created birth was less a duty than a right, the foundation of ancient liberties of free-born subjects. That's why Blackstone described the privileges owed to the natural born. That's why the colonists demanded the right of Englishmen more than 250 years ago. That's why abolitionists lauded the ancient and universal rule of citizenship by birth alone. Citizenship then and now was the right to have rights, to freely participate in our political community. The framers, 14th Amendment, extended that promise to every freeborn. It is so ordered. All right, well, I need a break. Because one, as the British would say, I need a slosh. And two, I need some water, because I've been talking for a while. But I won't be gone very long. And maybe just a brief stretch of my legs. We're on page 31 of 194. I'm not sure how much I have in me, but we'll do our best to try to read more of this. We're 2 hours in. I've got a little bit of energy. I'm going to take it. I'm going to get some energy drink and stuff. And if you guys like this content, we'll keep doing it. So I will return briefly. Okay, thank you. For those of you who afforded me just the brief moment, I just needed a couple minutes to not do this. Just needed a couple minutes to take a little mental break and also give the caffeine just a chance to work. But that's okay. I'm reinvigorated, sort of. And we're going to get back into it with the dissent. Your patience is appreciated. All right, where the hell is my cases? Yeah, Lord have mercy. Too many windows. Too many windows. There we go. All right, great. Where are you guys? Where's chat? Fantastic. All right, let's do this thing. All right, Jackson concurs, don't care. I'm sure she has many intelligent thoughts to share, but that's okay. We'll skip it for the moment. Did Gorsuch write separately or did he just join the concurrence? Because I'd rather read what he wrote if he wrote something. Gorsuch just joined two different dissents. He didn't write for himself. All right, that's fine. It's slightly annoying, but whatever. It's interesting that he joined two different dissents. Whatever. All right. Well, whatever. Let's read. Let's start with Alito because I think it's where's Alito's dissent? Thomas is not my favorite. Sorry. I know conservatives have a big, hard on for Thomas, but he's not my guy. He frustrates me a lot, to be quite honest. So let's start with Alito, who frustrates me less. It's my channel, and I'm going to do it in the order I want. So, yeah. Is he still writing? He's still writing. Unbelievable. No, it's actually completely believable. I don't know why I said that just now. He's still writing, still writing, still writing. Still writing. Jesus Christ. Stop writing. You don't have to write all the words. You can save some of the words for other people, okay? Man. All right, Justice Alito. Damn. Let's go with Justice Alito's dissent. Jesus. Tasty, tasty water with a little bit of Crystal Light for added flavor. No calories. Tasty. Excellent. Justice Alito dissents. This is one of the most important decisions in the history of the court. In my judgment, the court has made a mistake. How long is this thing? This is like 40 pages long too? Okay, we'll give it a shot. I think I can do it. As interpreted by the court today, the 14th Amendment confers citizenship on virtually everyone who happens to be in this country, including the children of birth tourists, women who come here solely for the purpose of giving birth and then promptly returning home. Careful analysis of the text of the 14th Amendment and the process that led to its adoption show that it does not degrade the concept of United States citizenship in this way. Indeed, the 14th Amendment confers citizenship only to those children who at birth owe allegiance solely to this country. Respecting this interpretation would not require uprooting the millions of children who were born here to mothers who entered or remained in this country illegally. Those children are not responsible for their parents' violations of our immigration law, and their plight is a result of a long period in which a coterie, that's right, how to pronounce that word, coterie of actors? I think that's right. Coterie of actors, executive officials, $5. Is the Supreme Court saying that both right citizenship is a constitutional right or the president can't change it? They're saying the 14th Amendment requires it, which means Congress can't change it either. No one can change it. It's God. Except, of course, constitutional amendment. So, yeah, they're saying it is inviolate. Anyways, moving on. Those children are not responsible for their parents' violation of our immigration law, and the plight is a result of long period. Has anyone else seen those videos recently of people being asked to read relatively simple sentences and not being able to do it? That's been depressing too. In the ever depressing man on the street of, do you know when the Civil War, who fought in the Civil War? Do you know what country the United States gained its independence from? Can you name a country? Any country? Recently, it's been, can you read this out loud? And the answer is no, they can't. Sad. It's sad. I particularly like, can you name a country? And they have any country, and they have troubles with that. It's like I could probably name half the countries if I gave it a try, off the top of my head. But then again, I've read a book. I can even name some countries that are not countries anymore. Austria-Hungarian Empire for the win. I'm Team Byzantine through and through. Well, okay. Anyways, result of a long period in which a coterie of actors, executive branch officials, states and cities, and a variety of private groups sent the message to would-be immigrants that our immigration law should not be taken seriously. That's definitely a thing that definitely happened. Or you watch Animaniacs. Yeah, I don't know the entire song, but if I did, that would help. Yeah, something. Jamaica, Haiti, Peru, Republic Dominica, and Argentina. Something. Brazil. Yeah. I'm not so good on the song. You should do reaction videos. I do reaction videos sometimes. I do reaction videos. I don't only do reaction. You mean I should do reaction videos to that and point out the sadness? I don't know what else to say except this is sad. And like, how do you not know this? Like, what country do you think the United States gained its independence from? Europe. I suppose, if someone wanted to be I think one of them one time said everybody, and I actually wanted to give them credit for that. But that's how sad it's at, right? One of those, on one of the Man Streets interviews, someone asked, what country did the United States get its independence from? And they said everybody. And I'm like, you know what? I think I want to give that a point, because I guess that's kind of true. So credit, I guess. Yeah. This message, coupled with ineffective or unenthusiastic enforcement, spurred massive illegal immigrants and the growth of a contingent of people who were born here to mothers and presumably fathers, not that matters as much, unlawfully in this country. Some members of this group have lived here for years, and they have a strong moral claim to be able to remain in the land where they grew up. Yeah, exactly. Pre or post nation state concept. That's good too. Yeah, that's a good time. Yeah, what country? Yeah, that's a good question. Like, yeah, that question does presuppose there's such a thing as countries, which, even up until like the modern era, the concept of countries wasn't really like as much a thing. Like if you talk about the history of Germany, for example, like Germany wasn't really a country until what, like the late 19th century? I mean, it's yeah. What are countries anyway is definitely a thing. '48? No, I'm thinking before that. I'm thinking pre. When did Germany first become a country? Yeah, when did Germany first become a country? Like late 19th century? Because like, yeah, the concept of countries, yeah, it's definitely a thing. Yeah, 1880s, yeah, that sounds vaguely right. Yeah, it's like, yeah, when did Germany first become a country? That's a very good question. Yeah, 1871, yeah, this is what we're talking about, right? And then right away, you know that I'm educated, right? This is how you know that Uncivil Law is not an idiot and is actually pretty well educated. Because I'm like, oh yeah, we can talk about when things were countries. When did Germany even become a country? Late 19th century? Oh, 1871. You mean late 19th century? Oh, yeah, exactly what I said, except with more precision. Oh, so maybe I've read a book once. You know? It's like, oh, I can actually have an intelligent conversation about this concept. It's fucking amazing. It's almost like I have a fucking education. Unfucking believable. Great, moving on. Congress can and should address this situation. How? The 14th Amendment dictates who must be a citizen, but not address who may be a citizen by act of Congress. I guess. I'm not sure how that's helpful to this equation. Congress has conferred citizenship on many people who are not citizens by the 14th Amendment, including children born of Americans overseas. Okay, fair enough. So children of American citizens born overseas are not citizens under the 14th Amendment. Fair enough. Cool. Also, by statute, the Native Americans and the Puerto Ricans, although, yeah, by statute, the Puerto Ricans, although not citizens of people born in the territory in which no one actually lives. And then there's also American Samoa, where people aren't citizens at all. Moving on. For those reasons, the original meaning of the 14th Amendment does not require inhuman results, and we should not adopt an erroneous interpretation of the 14th Amendment simply out of fear of consequences of rocking the boat. Nor should we take the position that our hands are tied by dicta in a sprawling 19th century opinion that, as to put it point generally, very far from a model of careful jurisprudence. Are you talking about Wong Kim Ark? I mean, if we want to talk about opinions like that we should just ignore because they're badly written, the first that always comes to mind is the one with the shotguns for the Second Amendment, because that case is just horrible. It's just horribly written. It's just really, really bad. Plus, the guy didn't even show up to the Supreme Court to argue it. So, like, if we want to talk about opinions that are hard to read, that's the one that comes first to mind. Yeah, the incorporated territory. Yeah, exactly. The incorporated territory, which no one actually lives on. And its name is what? Yes, there's one incorporated territory, but no one lives there. I can't remember its name. Miller was the name of the case. Thank you. That's correct. Yeah, Madison was wrongly decided. Yes, I know. There are definitely people, including Ben Shapiro, who believe Marbury versus Madison was incorrect. I don't believe that. Yeah, I believe Marbury versus Madison was correctly decided. And I always like to, for me, it's required by the Article 3, right? Marbury versus, I know this is off point, but we're talking about it's legal education, right? Marbury versus Madison said that basically, in so many words, the Supreme Court can decide a law is unconstitutional. And people take exception to that. And they're like, well, that's not what the Constitution says. And I'm like, I kind of think it is. Because the Constitution says that they have the right to decide any question of law or equity, federal law. And the legality of a law is itself a legal question. Right? So if you suppose a law itself can be illegal, then saying the law can be illegal is a legal determination. Right? I mean, it's just a legal determination because you're deciding a question of law. Is this law itself legal? And what do you decide that against? Well, the Constitution itself, because the Constitution itself says it's the supreme law of the land. It says so. It says the Constitution is the supreme law of the land. It's like, okay. So let's take that seriously. So this is what I say. Like, for those of you who don't think that the Supreme Court can declare a law illegal, okay? This is for the crowd that thinks, this question is for the crowd that thinks the Supreme Court cannot declare a law illegal, okay? This is for this crowd. Congress, let's suppose that some Democrats become empowered in Congress. Like, that's a foreign concept since they had control of Congress, right? Let's suppose that there's a supermajority, not that they really need it in this hypothetical, but whatever. Let's suppose that the Democrats take over the House, Senate, and presidency. Seems like a thing that could happen. It's been known to happen in the past. Let's suppose that the federal Congress passes a law that says, what are they going to say? No firearm shall transport in interstate commerce. And also everything is interstate commerce because of Wickard. So there shall be no interstate commerce relating to firearms. The Constitution obviously gives the power of Congress to regulate interstate commerce in the first instance. So we're not going to have any importation of firearms. We're not going to have any firearms travel state lines. And for that matter, no one can be in the business of buying and selling firearms because it's interstate commerce because Wickard. Okay? You, being a person who supports the Second Amendment, have a problem with this. Because you're like, I should have the right to have a gun. Okay, what do you do? What do you do? Don't you sue the federal government? What do you sue them for? Your law is illegal, right? You said I can't own a gun. The Second Amendment says I can. So what's the Supreme Court supposed to do in this hypothetical? That's my question to the Marbury versus Madison was wrong crowd. What's the Supreme Court supposed to do? If they can't say that law was illegal because it's against the Constitution. The Constitution is the supreme law of the land. The Constitution says your law is illegal, therefore it's illegal, therefore go away. If the Supreme Court can't do that, what's left? This is my question. It's like, what's left? So, to me, it has to be true. Because if the Constitution is the supreme law of the land, which the Constitution itself says it is, if the Constitution is the supreme law of the land, and Congress passes a law that says no guns, which is a statute, Congress passes a statute that says no guns, So I've got a statute that says no guns, and I've got a Constitution that says maybe guns. If I can't say Constitution beats statute, then what are we doing? And that's Marbury versus Madison. That's Marbury versus Madison. It's saying Constitution beats statute. The statute itself is illegal because it's an inferior law. The Constitution being the supreme law of the land, this statute being an inferior law to the supreme law of the land, the inferior must give way to the superior law. That's Marbury versus Madison. What are we arguing about? So that's it. That's what Marbury versus Madison is. So the law itself is illegal. The law itself is illegal. We have a special name for it. We call it unconstitutional because the Constitution is the law it's illegal against. Right? So it's like, oh, the law is illegal in view of the Constitution. Therefore, we give it a special name, unconstitutional. That's Marbury versus Madison. What else can we do? So that's it. Yeah, that's it. That's Marbury versus Madison. That's judicial review. That's it. To me, that's all it is. That's what judicial review is. It's a review. The courts decide what the law is. Constitution beats statute. So in the event of a conflict, It's the Supreme Court saying Constitution beats statute. Statute is illegal. That's judicial review. So what are we talking about? Yeah, so what are we talking about? Yeah, that's it. So for me, that's exactly what Article 3 says. For me, it's textual. It's right there in the text. It's textual. So I don't really understand the it's illegal crowd. I don't understand what they want to do with that hypothetical. It seems odd to me. Yeah, Constitution beats statute. Statute beats rule. Blah, blah, blah. Yeah, exactly. It's just a hierarchy, right? Yeah, exactly. Exactly. You know. If the Supreme Court can't say Constitution beats statute, then I guess statute must be legal, and that means no guns for anyone, and that's sad. So let's not do that. That sounds sad. Yeah. So that's all. Yeah, I don't get it. What are we supposed to do? I don't know. I don't understand these people. It doesn't make sense. Nor can the position that our hands are tied by dicta by sprawling 19th century opinion put to the point very far from a model of judicial craftsmanship. American citizenship is precious. My precious. Anyone who's attended a ceremony where citizens are naturalized can see that message on the face of those who take the citizenship oath. Yeah. Before saddling the nation with a medieval rule, we better be certain the Constitution requires it. The court's account of a birthright citizenship rule in American law is roughly as follows. After American independence, the British rule of birthright subject was modified in just way to take account of Indians who lived under tribal governance. Yeah. Yeah, and if you think that that's not implicated by the Second Amendment, then just change the hypothetical. Right? If you think that like that's not in the Second Amendment, okay, we can change the hypothetical. If it makes you we can change it to something else. Democrats traditionally have been Catholic. I mean, to the extent they have any religion at all, they're traditionally Catholic. New York, for example, Boston, have very, very heavily Catholic. Very, very heavily Democrat, very, very heavily Catholic. You want to change it to a different hypothetical? No problem. We'll do it. All right. Different law. Congress passes a law that says Catholicism is the official religion of the United States. In order to have a government job, you must be a Catholic. Is that hypothetical working better for you? I can keep coming up with new ones until you actually confront the issue I'm asking. I mean, I can just keep spurning laws. I can just invent laws to actually address the underlying question. Congress says, you know what? We really don't like people saying mean things about us in newspapers, so newspapers are now illegal. That's a law now. Do you want me to keep coming up with hypotheticals? I can keep doing this all day long. So confront the actual underlying issue, not the technicalities. You know? We can keep doing this. Congress says, you know what? We are really not happy with all these military bases. They're really expensive. So what we'd really like to do instead of having military bases, even though it's peacetime, is we'd really like it if citizens individually were required to host soldiers in their home. Everyone who has a spare bedroom must give it to a soldier to spend time in their home. That would save us a lot of money on military bases. It would help with the military. It would help with the debt. Anyone have a problem with this? We can keep doing this all day long. You know, we can keep doing this. It's fun. Every step of the story is incorrect. The Declaration of Independence repudiated the foundation on which British rule was based. From 1776 until the eve of the Civil War, the status of the rule in the country was unsettled. Yeah, if you said due process, wrong clause. Yeah, you failed the exam. You failed the exam. Due process, wrong answer. That was the wrong answer of the exam. Try again. There's a better answer. There's no evidence, and also, even if it were due process, that's a constitutional guarantee. So even if you want to go due process, okay. So you're appealing to due process. So you're appealing to the Constitution? Oh. So now you're going to 14th Amendment? Or you're going 5th Amendment for due process? Oh, okay. I mean, we can keep doing this forever. What do you like? There's no evidence established in the constitutional references the citizens incorporated the British rule. And until the eve of the Civil War, there was little litigation about the meaning of citizenship. To be fair, in early American history, we really didn't have immigration rules. It was pretty open in early American history. So there, yeah. After the war, Congress finally adopted a constitutional provision making certain persons citizens at birth, but that provision differed substantially from the British rule. It specified that a person born here is not a citizen until his allegiance to the United States is unimpaired by any obligation to a foreign power. And while Wong Kim Ark indicated dicta suggesting the 14th Amendment incorporates the British rule, its actual holding was much narrower, which, yeah. According to the court, the 14th Amendment of the Citizenship Clause codified the British rule of birthright subjecthood with only one new exception, which was needed to accommodate the unique status of American Indians. That's a curious claim, and it's ironic the court should celebrate it only days before we celebrate the 250th anniversary. Nice. Which emphatically renounced the foundation on which British rule rests. The rule did not concern citizenship. There was no such thing as a citizen of England, Scotland, or Ireland, and technically, there still isn't. Yeah, there wasn't and isn't still to this day such a thing as a citizen of England. Did you not know this? They're still not citizens today. Damn. Lord have mercy. The inhabitants of the British Islands were and still are subjects. Yeah. The statute arose from a feudal understanding of the original government authority and relationship between those who govern and those who are governed. The king's authority was understood to come from God, and still technically is, which makes the UK technically a theocracy, which I always find hilarious. As Coke put it, a king ruled by law of nature, and birth established a bond between the king and subject, just as birth establishes a bond between parent and child. In Calvin's case, the question of whether a man born in Scotland was the subject of King James I of England, who ascended to the thrones of both Scotland and England before the man's birth. K. In a famous speech to Parliament, James I forcefully explained his views about the source of his authority and relationship with the subject. The king, he proclaimed, sits upon God's throne and is father of the people. 1609. You could get away with that in 1609? Wow. The theory of monarchical power and the status of people provide a foundation on which the rule of birthright citizenship stood. Just as a person automatically acquires birth, all that's entailed by the relationship between parent and child, a person born within the king's domain automatically became the king's subject. I mean, I guess that's true for no other reasons than practical reasons. In the literal sense of being subject, are you subject to the king? Well, he's got a sword and shit, and you're on his land. So, and he's got an army and shit. So there's that. I mean, are you subject to him? I mean, I can't help noticing that he's got a lot of these people in like metal wearing clothes with like swords and shit riding around. So kind of feel a little subject, kind of feel like a little subject, kind of feel a little bit. Yep. Can't help noticing that it's a little bit there. Birthright upheld. We're working our way through it. We're in dissent land. Nate, you're late to the party. We are deep in dissent world right now. Love you, Nate. Nate's late to the party. We love Nate. He's great. Yeah, water Tarsus for being stored. Exactly. This meant the subject acquiring a duty of obedience to the king. King owed a duty of protection to the subject. Really? Did the king owe a duty of protection to the subject? I don't know, man. How much do you know about British history when it comes to kings and their duty to their subjects? It's not exactly all roses. Yeah. This was not based on consent, you don't say, and a subject could not shed it. In this system of soil and servitude, the court sees emancipation, but our founders disagreed. Yeah, how do you enforce the duty against the king? That's a good question. If the king has a duty, how do you enforce that duty? Who do you appeal to? God, I guess. How's that working out for people? Is it working out great? It proclaimed that governments derived their just powers from consent of the governed, not divine right, and absolved the people of the United States from all allegiance to the British crown. I seem to remember reading something about that. Yeah. I seem to remember reading a document that had words to those effect. With the foundation blown away, the British rule of birthright citizenship, or subjecthood, was not suited for easy incorporation into American law. In addition to the French flipped the script on the king. Well, the English did too, to perhaps slightly less dramatic effect, but still pretty consequential. So yeah, English history of kings is weird. The whole country's a little weird. They're making it up as they go along. That's the problem. They're making it up as they go along, which I suppose is common law, to be fair, and they never bother to write anything down. They're playing Calvin ball. Wasn't quite as bloody. The English Civil War was pretty bloody at the time, to be quite honest, but didn't involve as many guillotines. That's true. The English Civil War wasn't exactly a Christmas party. The first was the problem of slavery and more broadly of race. In England itself, the number of slaves had never approached the American dimensions. Just 4 years, well, yeah, but okay. England is different people in size, and it's not really a fair comparison. Okay. Can we think of any okay, never mind. Just 4 years before the American colonies declared their independence, Lord Mansfield's decision in Somerset denied that slavery had any common law foundation. Sure. Nate the lawyer, Holla, for 499 says, I agree with the dissent more than the majority, but I think the majority has a better originalist argument. Well, I haven't really decided who I agree with yet. I'm still in the process of trying to figure that out right now, Nate. And I did find a lot of the majority's argument persuasive, although I also found portions of it to be straw man. Without even having read the other side, I'm like, that is not what the dissent said, right? And they also straw manned Wong Kim Ark for my taste. It's like, that is not what Wong Kim Ark said. And also, without even reading it, I'm like, that is not what the dissent said. There's no way, you know? So I'm like, there was a lot about the majority opinion I liked, but for reasons that were not really completely necessary, because they didn't need to get where they wanted to be, they strawmanned some things along the way in a way I found to be disingenuous. Not that it necessarily undermines the conclusion at the end of the day, but it's like, why? Why even do this? You didn't need to. I noticed, is all I'm saying. How do I think this squares with Korematsu? Really? Is that really your question? How's this square with Korematsu? What the fuck kind of question are you asking? What kind of question is that? I don't even know if that's a genuine question, but I am putting you in timeout for the shadow realm for 10 minutes so you can think about your question and try again. Holy shit, man. Nate the lawyer for 499 says, I love how the majority tried to make it seem like dissenters wanted to make Dred Scott a thing again. Yes, I did note, and I made a comment about the fact that their very first citation when it came to the substance, like, after, because, section 1 is preamble, as they do. So, right, section 2, when they're actually going to start getting into the merits of the thing, what's the very first case they cite? Dred Scott. I'm like, oh, that's a choice. Starting a little spicy over here. What's the very first case we want to talk about when we actually start talking about the merits? We're going to talk about Dred Scott. Oh, that's a little bit of a spicy choice. I wonder which way this decision's going to go. Like, holy shit. There's foreshadowing, but holy shit, do you have to telegraph that hard? I get it. Damn. Right? Shit. Tell me what you really think. You know what I mean? Shit. The first problem with slavery, more broadly of race. In England itself, the number of slaves had never approached American dimensions, which, there's reasons for that, but never mind. Just 4 years before the American colonies declared independence, some guy said, that's not part of the common law, which, sure, why not? Proclaiming that slavery was so odorous that nothing can be suffered to support it but positive law, and it would soon disappear. In the United States, on the other hand, nearly 700,000 people, this is also unfair to the Americans. It's not like we were massively outdone by the English. The English beat us to banning slavery by 20 years. Okay, I appreciate they beat us and all, and it's not like it's nothing, but it also wasn't like 4 centuries earlier. Okay? It's not like there was some long, deep tradition that slavery was bad for like 400 years and America just didn't get the memo. Okay? The English beat us by like 20 years. Okay? And then we're like, oh yeah, slavery is also bad like 20 years later. It's not like, all I'm saying is give us a break, man. We were right there. Jeez. Okay? Damn. Heartbreak said, remember, Justice KBJ, if I steal a wallet in Japan, I'm subject to Japanese law. In a sense, it's allegiance. Holy shit. Thanks for reminding me of that quote. My brain was smarter, and now you made me stupider. Thanks for reminding me about that. I did not need that information again re-injected into my life. Thank you for doing that. That was just wonderfully helpful in every possible way. Unbelievable. Okay, anyways, in the United States, nearly 700,000 people lived in slavery, roughly 1/5 of the population, depending on how we count, lol. And since the contemporary definition of citizens was free man, not slave, it was obvious that neither the Articles of Confederation nor the Constitution, both of which allowed slavery, recognized members of this sizable population as citizens. Okay, are we defending Dred Scott now? What are we doing here? Are we saying Dred Scott was right? What are we doing? I'm confused. Even in the free black population of the United States, there was substantial opposition to the application of British rule. Many states, both in the Southwest and South and Midwest, restricted the right to traditionally associate with citizenship, such as the ability. Are we doing Jim Crow now? Okay, I feel like we're poisoning the well a little bit right now. I don't know if there's. I would give them slavery. I'll give them slavery, but Jim Crow, I feel, is a little bit poisoning the well. I feel like we've moved a little bit off topic just to talk about America being evil for a while. So I'll give you slavery, but Jim Crow, I don't know, man. I don't know. And there was some federal support for this understanding of citizenship. In Britain, on the other hand, as the court notes, the common law did not take account of race, which is suggestive that we didn't follow the common law, but you're using slavery to get there, which that's a bad move. Right? That's not a great move, right? It's like, okay, the English, anyone born there, regardless of race, is a subject. Okay, fine. The America struck out the word subject and wrote in the word citizen. Okay, cool. Anyone born in the United States is a citizen. Not so fast, Alito says. Okay, what are your examples? Slaves weren't considered citizens. I feel like, and therefore, because of that, people that are born here of illegal immigrants are also not citizens. That's not a great argument. You're using the fact of slavery to buttress your argument. The reason that we can say that children of people born here who are here illegally are not citizen is at least partially supported by the fact of slavery. I have to tell you, using slavery in support of your proposition, not great. Wouldn't recommend that. Maybe not that, maybe something else. That's a bad example. Nate the lawyer says Thomas said Dred Scott treated blacks as second-class citizens. The 14th Amendment made them full citizens. Illegal aliens aren't second class, therefore they aren't citizens at all. Again, I really don't know that you want to use slavery as an example or a talking point in your argument. That does not feel like a good thing to do, right? In a comparable way, all right? In a comparable way, when our friends on the left want to do some gun control, and we say, hey, history and tradition, we want to do a history and tradition test. When the liberals or the progressives turn around and say, don't you mind, I've got your history and tradition for you right here. The black codes. The black codes. It's like, maybe you don't want to cite the black codes. Hey, we disarmed all the black people. We did it all the time. Disarming the black people was like our favorite thing to do. Disarming the black people is wonderful and great. So we just can disarm everyone all the time. Maybe don't use the black codes in support of your argument. In a similar way, hey, you know what? Native people who are here illegally, their children shouldn't be citizens. Okay, what would you like to offer in support of that proposition? Slavery. Maybe not. Maybe not that. Maybe you should not use that as an example or buttress of your support. Maybe not the black clothes and slavery. Maybe, probably shouldn't be citing that in any sense for support of your proposition. Maybe you should just leave that one alone. That is my hot take for the day. That is Uncivil Law's hot take. Okay? I know this is just going to get me in trouble with everyone anywhere. Okay? Here's my legal hot take. If you need to cite the black codes or you need to cite slavery as supporting your proposition to make it work, maybe don't do that. Maybe don't cite the black codes and slavery as being examples that make your what you're doing okay. You know why what I'm doing is okay? At least partially because black codes, at least partially because slavery. Maybe don't do that as a legal argument. That is my hot take for the day. That's my hot take. Please don't cite slavery and the black codes in support. That'd be great. Holy fuck. Kill me. It's not a great way to win hearts and minds. Also, while we're at it, you probably also should seriously question whether, okay, why can we deprive the illegal immigrants of their children? You should also seriously question, because Native Americans as being part of your support. You know, maybe that's a really questionable way to go about it. Just saying, you know, when they say, hey, why can you deprive the illegal immigrant children of their birthright citizenship? Why is that legally okay? Do not cite the black clothes or slavery, and seriously reconsider whether or not you want to cite the Native Americans. Maybe these are not good ways to win hearts and minds. Thank you for coming to my TED Talk. Fuck. Moving on, the second problem was the unique status of Indian tribes. Oh my God, please, are you really going to do this? You are doing this, right? You're really doing this. Are you going to do this? Really? Seriously? Are you sure? Tread lightly. There's a lot more ways that this can go wrong than it can go right. The danger signs should be flashing in your minds. We're going to talk about Native Americans now. Are you sure? Are you really sure? Are you really sure? Okay, let's do this thing. The second problem was the unique legal status of Indian tribes in the United States. Under the clause of the Constitution allocating seats in the House of Representatives and presidents and electors, Indians not taxed were excluded from the body politic and therefore denied citizenship. This provision did not require census takers to determine whether individual aliens owed or paid taxes. Instead, the phrase referred to those Indians who retained their traditional way of life. They lived in their own communities under tribal law and enjoyed the privilege of total immunity from state taxation. It's hard to find estimates of the size of this segment at the end of the 18th century, but it was significant. The existence of these two carve-outs refutes any argument that British rule was transported without modification. But you cited slavery, which really, you really want to go that way? Citing Native Americans, you can do. You need to tread very carefully, but you just use slavery as part of your support to prove that we departed from the British. I don't know about that one. Yeah, I don't know, ma'am. Listen to the oral arguments? I did. I listened to the oral arguments. I did. I am very, very, very familiar with this case. Extremely familiar. I've read and listened to everything. And now I'm reading this. And I'm like, I don't know, ma'am. I don't know. This is not going well, in my humble opinion. Yeah. The attorney Sauer made similar arguments. Yeah, maybe don't, though. And also, if you're the Supreme Court, you don't have to do that. Just because he did doesn't mean you do. So maybe he shouldn't have done that. And maybe also you shouldn't do that. Just maybe don't. Okay. You're not helping. Any attempt to plant some version of the rule here has faced problems applying the nation that, unlike, has a written constitution. Well, thank God for that, because the UK doesn't have a constitution. What is it that I said? They've got tea and no constitution. Yeah, I think that was the joke from last time when we had an argument about that. In Britain, the rule of birthright subjecthood, nice phrase, was part of the common law, thus could be changed by Parliament whenever it chose. If the rule was transplanted here across the Atlantic, would it have similar status here? would be part of the common law state legislatures or courts could alter or abandon. Presumably, but maybe not when that's kind of a dumb question. Even if that's true, it doesn't really help you that much. So sure, let's accept the premise. Let's accept the premise that Britain can alter birthright subjecthood from an act of parliament. I don't know if that's true, but let's go with it. Let's also accept the premise that states at the founding could also, or the federal government for the matter, could also by statute change who was a citizen by whatever statute they might impose. Okay. Now, can we think of any provisions of the Constitution that might, in some ways, potentially, arguably, impact this otherwise unquestioned, unilateral, total sovereignty? Can we think of any provisions of the Constitution that might, in some way, potentially impact or limit the right of the state or the right of the federal government to, in its absolute, unquestioned, total sovereignty, impact who is a citizen? Can we think of any provisions that might in some sense have limited or changed that power? Kill me, just kill me, it's fine. Kill me. Just kill me. That's what's happening. Andrew Branca's upset? No shit. Yeah, Andrew Branca's upset with this decision? Yeah, tell me a different story. Yeah, Andrew Branca's upset with this? Oh no shit, Sherlock. Wow, that's an amazing revelation. Thanks for sharing that. Andrew Branca thinks Andrew Branca has problems with this decision? Wow, tell me a different story. Unbelievable. Okay, tell me a different tale. Lord have mercy. All right. Alternatively, did the rule have some status under federal law? Numerous provisions of the Constitution use the term citizen. Did all those provisions incorporate the birthright citizenship? Even if they did, there might have been a later change to the Constitution that might have impacted it in some way. In this case, because we're concerned with the meaning of citizenship under the Constitution, it's the second alternative that's important for present purposes. In Lynch, a decision on which the court responds and many amici rely, the Assistant Vice Chancellor of New York, again, this is a equity court, so just think judge, suggested that the Constitution references the citizen incorporated the British rule, but that's far from obvious. Cool. Nothing in the records in the Constitutional Convention supports the conclusion, and British rule would be a poor fit for the interpretation of citizen in the provisions governing the qualifications of members of Congress and the President. Why? I mean, that's normally how that works, right? I mean, that's how we do the rest of the Constitution, right? Do I have to explain this to the conservatives? Apparently I do. I'm not sure why I have to explain this to the conservatives, but I do. Normally I have to explain this point to the left. But it seems like today I have to explain this to the conservatives and Alito. So I guess I'll do that now. All right. Once upon a time, there was a place called the United Kingdom and England, and it was a nice place. And starting around 1066, but more properly around I always forget the year that it happened. I think it's like 1128. Starting around 1128, give or take, because I can never quite remember the year, this interesting place started having common law. And they come up with a series of decisions that becomes the law of the land, the common law that belongs to the land in a common way. And the principal founders of the United States lived in this land. And then one day they decided, I don't really want to live in this land anymore, but I'd like to live in this different land that's across the pond. But you know what? I'm going to take our legal traditions with us because it's what we know. We're going to take all that wonderful legal traditions and we're going to govern ourselves using the legal traditions that we know and love with some minor changes. Then there was a friendly spat between these people and their home people. But despite the friendly spat, which is barely worth mentioning, occurring 250 years ago, they kept the legal system. And we don't really like the king part so much, but a lot of the other stuff we like. And then they wrote the Constitution based on this shared legal tradition, the common law, as it's known. And so when you read provisions of the Constitution, they are largely, although not entirely, codifying, although codifying is not strictly the right word because codifying normally refers to code, which is to say statute, but I don't know what else you'd call it. So let's call it codifying anyway. They were codifying this law in the Supreme Law, which I suppose is a code in its own way. And so when you're reading provisions of the Constitution, it is informed by the common law. So when you're reading, for example, the First Amendment or Second Amendment, and you're like, geez, what the hell were they talking about? What is this speech thing you talk about? What is this religion thing? This petition? What the fuck is a petition? What is an arm? What the fuck are you talking about? Or any other provision of the Constitution you like. You know what's a really good starting point? The common law. Because that was the thing they were writing against. It was the thing that was shared in common. So all else being equal, you know what they might have meant? They might have meant the common law stuff. It goes in the square hole. Fuck. So when they were writing about the idea of what a citizen was in the first instance, in the beginning, when they were writing an idea about what a citizen was, you know what they were probably thinking? They were probably thinking subject, but not king. That just seems like probably what they were thinking. We like the British subject part, but we don't really like the being called subjects. So, instead of king, how about not king? And we'll use a different term called citizenship. And presto bango, that's how it started. But when they wrote the 14th Amendment, they might have meant something different. Geez, and why might they have meant something different? Now that's a real head scratcher, people. That's a real head scratcher. Geez. Now, when they wrote the Constitution originally, maybe they meant something by citizen, as informed by what the term subject meant in the British common law. Okay, but here's an idea. When they wrote the 14th Amendment, maybe they had a different idea about what citizen might mean. Now, can we think of any intervening events? Can we think of anything that might have occurred, say, between the founding of the country and the creation and ratification of the 14th Amendment? Can we think of anything that might have, in any sense, potentially augmented or disrupted or changed or influenced our conceptions of what a citizen might be? Before, we're going with the British rule. Just cross out the word subject, write in the word citizen, but basically the same thing. That's what we meant originally. Do we have any sense of any intervening events that might have influenced, changed, augmented, or otherwise modified the concept of what a citizen is? Anyone think of any events that might have occurred that might potentially change how we understand what informed the 14th Amendment as opposed to the Constitution? Anyone have any fucking ideas? Fuck me. Putting my hat back on. Christ. Nothing in the records of the Constitutional Convention supports that conclusion. And British rule would be a poor fit as interpretation of citizen. Why? An early draft of the Constitution provided a representative must be citizen of the United States for at least 3 years, but there was opposition to the provision. Okay? One delegate argued that 3 years was not enough. Okay. And then they went with, what was it, 10 or 7? Was it 7? What did they go with? I forget. Did they go with, they're like, not so much 3. I think they went with 7. Wow. This is super duper informative. I don't know what point we're trying to prove, and whatever point it is, it's not working for me. Hey, when they were deciding how long you had to be a citizen in order to be a representative, some people said 3. And then eventually they decided on 7. Okay. And therefore, what? What's that supposed to mean to me? Some people thought maybe 3. Presumably, some people thought more than 7. I'm assuming 7 was a compromise number. There were a lot of people that had a lot of thought. Some people probably thought 0. So they had a lot of different ideas, and eventually they settled on 7 as the number. And therefore what? What am I to draw from this conclusion? Fuck my life. The presidential ability clause required them to be a resident for 14 years. Okay. And what? Its purpose was to prevent a person with possible foreign loyalties from becoming president. And British rule hardly seems consistent with that aim. That is the most disingenuous thought that is just completely disingenuous. I hate this. I hate this so much. I hate this so much. Okay. They were a little bit concerned with who would be representatives and senators and president. And so they were like, you know what? We want to make sure that these people have some, loyalty to us. And, we're going to have a little bit of debate as we do about exactly what does it take to have this loyalty, right? What exactly does it take? Do we have to be natural born, not natural born? How about 3 years, 5 years, 7 years, 9 years, 14 years? Do you have to live here? Or do you have to not live here? So we're going to have a little bit debate about, in order to become a member of our parliament, which we're going to call Congress, in order to become a member of our Congress, how much loyalty do you have in order to be in this position, which you might, pass laws that govern us? And somehow this is informative of illegal immigrants? What the fuck? This is some bullshit. This is some bullshit. If this is how you're trying to convince me, if this is your pitch for why the children of illegal immigrants shouldn't be citizens, my response to your pitch is get fucked. This is fucking bullshit. Fuck you. If this is your pitch, my response is go fuck yourself. Fuck. This is not working. No case concerning the meaning of the term citizen in any constitutional provision reached until Dred Scott. Are you citing Dred Scott in support of yourself? It looks suspicious. Did you just cite Dred Scott? Are you citing Dred Scott in support? Just fall over and die at that point. If you have to bring Dred Scott into your argument, just fucking lay down and die. Fuck off. Before then, the British rule did figure in another handful of antebellum, but none of these addressed any rule, and most appear to have been regarded as the British rule. Did you just cite Dred Scott in support of your proposition? Fuck you. Not only were there no Supreme Court decisions on the constitutional question, there wasn't much litigation on any kind of the question. Cool. And in our time when the difference between citizen and allegiance or alienage is a hot issue, this dearth may seem strange. Well, that's because at the time, we pretty much had open borders. So there wasn't really a distinction, or there weren't a lot of cases because we kind of had open borders at the time. So there weren't a lot of cases. Where were we? The question of citizenship came up regularly in cases in which jurisdiction of the federal court was invoked based on diversity of citizenship, which is citizenship between states, which, whatever. But the issue in those cases is, what state? Okay. As for other constitutional provisions to use the term citizen, it appears the question simply did not come up. So you don't have a lot of precedent on issue, which is both good and bad. You don't have a lot of precedent. Fair enough. The precedent that you are citing is not great, though. Let me cite Dred Scott and some slavery. As support. Maybe not those cases. Maybe not so much. Under the Nationality Act, a foreigner became an American citizen simply by having 2 years of residence. Yeah, we had open borders at the time. Okay, noted. So you became an American citizen merely by being 2 years here and being a nice guy. Cool, that was the law. All right, fair enough. Great, moving on. In years before the Civil War, and indeed until many years ever, the distinction between citizens and aliens meant less than it did today. Okay. During the period, immigration was unrestricted, so aliens could come and stay as long as they wanted. Pretty much. An era where transatlantic travel is slow, inexpensive, expensive, perilous, it's likely a vast majority sailed intended to remain. Cool. If that was their choice, naturalization, as noted, was easy. And for whatever reason, a person who intended to make a permanent home here did not do what was needed to apply. The lack of citizenship did not matter as much as it would. In some places, aliens could even vote and hold elective office. Okay, noted. Whatever reason, the issue of citizenship came up in only a few cases because it didn't matter at the time. For whatever reason, really, you can't figure that out? Seriously? You can't figure out why citizenship didn't come up very much? You just spent like 3 paragraphs saying why. For whatever reason, you just said 3 paragraphs why. At the relevant time period, we had open borders. You want to be a citizen? Cool. Just show up and live here 2 years and keep your nose clean and bang, you're a citizen. Congratulations. Geez, I wonder why there weren't a lot of cases dealing with who's a citizen or not. It's so hard to tell. It's so hard to tell. Why wouldn't there be a lot of cases dealing with who's a citizen or not? I can't think of any reasons why. Kill me. For whatever reason, we're completely baffled. Citizenship didn't come up a lot, except for the question of citizenship of Black people. Wow. Legal treatises, to be sure, include comments on birthright, but those comments were not informed by judicial decisions because there weren't any, because if you want to, you're a citizen. You just basically say you are and bang, you're it. Congratulations. The important purposes for this point is during the antebellum period. Is there some way to pin the summary of this decision? Yeah, well, I'm not sure how to tweet that in a few characters. The summary of decision is children of illegal immigrants are citizens. That's the summary. Everything else is explanations and rationales for that goal. And this is not working. This argument is not working. Not to say there can't be an argument. I'm just saying this argument ain't it, Chief. Children of illegal immigrants are citizens. That's it. Trying to figure out why and who's right is what we're currently into. And the dissent is not working. The dissent is so far, well, at least Alito's dissent is not doing any favors. The important purpose for this purpose is no settling understanding about the citizenship of children born to soil whose presence in this country was unlawful. Yeah, that couldn't have occurred because the concept didn't exist at the time, right? After the Civil War, Congress faced numerous challenges. One of those was ensuring all Black Americans, free, slaved, and those would be treated as citizens. Congress dashed that issue in the Civil Rights Act and then again in the amendment. For the first time, these enactments provide a nationwide rule. The meaning of the rule is now questioned. That's what we're doing, yes. In tackling that question, an avowedly textualist court should start by examining the text of the citizenship clause. Cool, I'm down with that. The clause states all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens. All right. First, a person must be born in the United States. Cool. And second, what we're all fighting over is what it means to be subject to jurisdiction. And that's not easy because we've often remarked jurisdiction is a term of many meanings. Fair enough. Jurisdiction doesn't necessarily mean the same thing in every context. Fair enough. So this part I don't have a problem with, right? It's like, there are people who will say, like, if they're not citizens, that means you can't prosecute them. That isn't necessarily what it means because you lack jurisdiction, right? If you lack jurisdiction, you can't prosecute them because you lack jurisdiction. Jurisdiction might mean something different in different contexts. So that part I can work with. The concept of jurisdiction might mean something other than criminal jurisdiction, for example. So I can work with that. If subject to jurisdiction had a term of art during Reconstruction, we'd presumably hold the phrase had a meaning in the 14th Amendment. Fair. Yeah, I mean, if the clause had a meaning in the law, generally speaking, then you'd presuppose that's what it meant. Fair enough. But the phrase was not a term of art. Okay, so it doesn't have a meaning that we can deduce in that sense. Okay, fair enough. If the citizenship clause set out specifically named exceptions, our job would be easier. We'd follow the exceptions, but they didn't. Yep. And when a legislative body chooses to adopt a generally worded rule, we apply it in all circumstances that fall within the rule, not just those that were in the mind. Fair enough. We follow the rule as far as the rule goes. I have no problem with that. We do that in First Amendment land, Second Amendment land. So far, so good. Okay, so far, so good. We're off to a more promising start. Maybe it gets better. So what does the phrase subject to the jurisdiction thereof mean? Unfortunately, the text of the 14th Amendment does not provide an answer. It sure doesn't. Textualism really doesn't help that much. First, the 14th Amendment uses the term jurisdiction twice, once in the Citizenship Clause and once in the Equal Protection Clause, and the wording of the two clauses differ. The Citizenship applies those subject to jurisdiction of the United States, whereas the Equal Protection Clause applies to any person within a state's jurisdiction. Okay. When Congress uses disparate language, we presume the difference matters. They could mean different things within the provisions of the 14th Amendment itself. They could mean different things. I can get on board with that idea. Keep selling me. You're off to a better start. Keep trying to sell me. Second, the phrase subject to jurisdiction in the United States applies not only to those born in the country, but those who are naturalized. Okay, fair enough. I can work with that. There may be some people naturalized, but are not subject to jurisdiction in the United States. Okay. In other words, whatever subject to jurisdiction means, it must mean something that's not inherent in naturalization. Depending on what you mean by naturalized, sure, I can work with that. So far, so good. Although the text of the 14th Amendment provides these clues, we must look beyond the text. Yes, textualism doesn't really help you. So textualism is out. We need to go to some other tool in our toolbox. The textualist is left like, I don't know. So let's move to some other tools in our toolbox. Fair enough. The term of the 1866 Civil Rights Act provides an explanation. Well, certainly somewhere to go because it looks to relevant context. The CRA included its own citizenship clause and circumstances surrounding Congress's adoption were meant the two provisions were understood, but they used different language, which is not helpful. The 39th Congress debated the CRA from January to March of 1866, where it was passed and sent to the president for a signature. Congress debated the 14th Amendment from April to June of 1866, so they decided it immediately following. Was adopted. Thus, during the 6-month period, the very same Congress debated two provisions. So the co-writing of them is very strongly suggestive that they mean the same thing. Fair enough. I can get behind that. So fair enough, right? They use different language, which normally suggests different things, right? Subject to a jurisdiction of, and then not subject to a foreign government is different language. But nevertheless, they were adopted by literally the same Congress, literally back to back. And so it is perfectly reasonable to view them as saying the exact same thing, perhaps in different words. Perhaps both phrases, it's not that one phrase means the other, perhaps they both mean the same thing, and neither phrase is necessarily a good reflection of what they mean. But they mean the same thing, whatever that thing is. Could be. Now, to be fair, they could mean different things, but it's not invalid, right? You're using relevant context to try to interpret what it means. So far, we're doing okay. So far, so good. So far, so good. Let's keep going. In addition, one of the chief reasons for adoption of the 14th was to prevent the CRA from being held unconstitutional. Okay, if the CRA had granted birthright citizenship to persons who were not entitled to birth under the 14th Amendment, there would still be doubts as to the constitutionality. Well, maybe, but like, I don't know. Okay. But it could go broader, right? So just because we want the CRA to be constitutional doesn't mean necessarily it's coextensive. It would require the CRA, it would require the Constitution to be at least as expansive as the CRA, but it could be more expansive. Because if our concern is the constitutionality of the law, we could write them so that they're the same, or we could write something broader under which the law would also be constitutional. So either one would be fine. Sean Richards says, don't we have a rule that we tend to assume no lines are meaningless? If it means the same thing, that would be meaningless. Those are general canons of construction. They're not absolutes. So you're not wrong to be thinking it. You're just wrong to apply it rigidly. But yes, we have different words that is suggestive they mean different things, but it's not absolute. There are other clues that might suggest they mean the same thing. Perfectly valid conservative reasoning, because you're using now history and you're using history to inform what it means. So these are all reasonable ways to look at things. Let's press on. So it's at least coextensive, although the Constitution might go further. Moreover, following the ratification of the 14th Amendment, Congress reenacted, which is also suggestive that they might mean the same thing. That reenactment would be pointless if the test for birthright citizenship was less generous than the 14th Amendment. No, not necessarily. They might be concerned about it as a matter of timing. Like maybe the statute was illegal and now we're going to repass it just to make sure, because now that we've passed the constitutional amendment, we don't want an argument that somehow the statute was illegal because it wasn't constitutional at the time it was passed. So just to be sure, we're going to repass it just to make sure. So I don't know that I agree with that conclusion, but okay. So I don't think necessarily pointless. Not sure I agree with that. For all those reasons, it's abundantly clear the texts were substantially identical. I'm not sure the conclusion necessarily follows strictly, but it's at least plausible. I therefore turn to the text of the CRA provision. Provides all persons born in the United States, excluding Indians not taxed, are hereby declared to be citizens. The language provides two exceptions that were well known and well accepted. The first was for career diplomats. The second were for Indians, which is kind of suggestive against what you're writing. The exclusion of tribal Indians from citizenship followed the appointment clause, blah, blah, blah. In the Constitution, just as revolution, taxation, and representation went hand in hand. Indians were not considered part of the political community. They're domestic dependent nations. Sure. Let's go with that. Tread lightly, but sure. They belong birth to their own tribes because Indians who lived were not considered part of the political community. They did not receive representation, were not taxed, and were not citizens. Okie dokie, moving on. The only other exception for children of diplomats comes from kind of the laws of nations, so fair enough, we can blow past that. With that understanding of the citizenship test in mind, which only those two exclusions, right? If we're only excluding Native Americans and the children of diplomats, that's kind of a blow to you, Alito, but let's see if you can somehow salvage this. When Congress framed the citizenship test in the 14th Amendment, consolidated two exceptions by birth, Indian not taxed, and subject, 14th thereof, in the phrase. If that's what it did, then you lose. Therefore, a person who is subject to any foreign power, which is not, I see what you're going to do. I see the sleight of hand that you're going to do. I see it. I see your sleight of hand. No, absolutely the fuck not. I see 100% your sleight of hand. Fuck you. That's what I say. Fuck you, right? We're moving from the concept of diplomats and we're doing a sleight of hand to move to the concept of people not subject to a foreign power to get to where we want to be. That is a disingenuous sleight of hand, and go fuck yourself. Absolutely the fuck not. No, absolutely fucking not. You can't fucking do that. No, fuck you. Debro 474 says 1999, catching up on today, so people say in place, you say some people find the Scott streams boring. They do. I love them and learn something. Thanks for explaining. No problem. Yeah. This is some bullshit. That is a sleight of hand. The 14th Amendment uses subject jurisdiction. Therefore, a person is not subject to foreign power, is not subject to jurisdiction. That's true, but it doesn't mean what you're about to say. The children of diplomats are not subject to jurisdiction. Likewise, tribal Indians. But they're certainly subject to jurisdiction in a different sense of the concept. Sure. Okay. All right. So now we're going to talk about Federal criminal jurisdiction, even though they're not citizens, no problem, different provision of the Constitution. The Constitution gives the power to Congress to regulate affairs with Indian tribes. So you want to have criminal jurisdiction even though they're not citizens? You have a provision in the Constitution for that. So Congress is like, how about not citizens, but still criminal law? Cool, no problem, we can do that, which goes even to show against you, right? Because now you're separating the concept of citizenship jurisdiction from the concept of criminal jurisdiction, right? So in 1817, right, the Constitution itself says not so much on the citizenship for the Native Americans because they're dependent nations. And then in 1817, Congress is like, you know what we'd really like to do? We'd really like to have criminal jurisdiction, even though they're not citizens. So let's do that. Okay. So you have criminal jurisdiction, even though they're not subject to the jurisdiction of the United States within the meaning of the 14th Amendment, because if they were, they'd be citizens and they're not. So you're separating the concept of criminal jurisdiction from the concept of citizenship jurisdiction, which is exactly what you don't want to do. Because if they're separate concepts, then having all the criminal jurisdiction in the world doesn't prove anything. Because they're separate concepts. So you're about to fuck yourself. Unfucking believable. 1817 is before the 14th Amendment? Sure is. That too. But you're separating the concepts. That's the problem. Right? Because you're trying to interpret what's subject to the jurisdiction thereof in the meaning of the 14th means. Yeah, your own point kind of goes against you. You take it as a point in your favor. It's actually a point against you. This is the problem, not a solution to your problem. Right? In 1817, before the 14th Amendment, Congress is treating the concept of citizenship jurisdiction differently than criminal jurisdiction. They're treating it differently. So when they wrote the 14th Amendment and they wrote the word jurisdiction, they might have been writing it on a backdrop in which the concepts were separate. So when they were talking about citizenship jurisdiction within the meaning of the 14th Amendment, the 1817 law that reflects there's a difference between that concept and criminal jurisdiction is a point against you, not a point in your favor. Because you can have all the criminal jurisdiction in the world, and it doesn't mean anything about citizenship. So when the 14th Amendment says subject to the jurisdiction thereof, you can have all the criminal jurisdiction in the world, and it doesn't mean anything with respect to this question. And that's a problem for you, not an asset, at least in my humble opinion. So parents can just thrust their children in the U.S. system, be damned the U.S. citizens. Yes. But that being the case, I'm not a consequentialist by nature. I'm a proceduralist by nature. I'm not a consequentialist by nature. I think in procedure. I think in terms of rules and categories. I'm a conservative. I tend not to look to outcomes. I tend to look to process, procedures, rules, right? What are the rules? Let's follow the rules. And whatever consequences flow from the rules is correct. To me, that's conservative thinking, right? We have rules. We're going to follow the rules. We're going to treat them categorically. We're going to get to the end of the page, and whatever answer pops out is the right answer. Now, if it's not the right answer for some reason, we can change the rule set, but there are ways of changing the rule set, right? You don't say, because I don't like the consequence, I'm now going to go back and gerrymander the rule set, right? I'm going to go back and change myself in an intellectually dishonest way so I can get to the end I want, right? If you followed all your rules, if you get to the end of the page and you don't like the answer, one of two things has happened. Either you made a mistake in your rule set, in which case go re-examine your work. If you made a mistake in your rule set, then so be it, fix the mistake. The other possibility is you follow the rule set correctly and you just don't like the outcome. The solution to that problem, at least from this conservative's perspective, the solution to that problem is to think about it categorically. You can absolutely go and change the rule set, but you have to do so in a categorical way so that you're intellectually honest, right? You can say, I don't like this result. I want to fix it. But the way to fix it is by fixing the rule set. And then, of course, and this is the challenging part, when you go do that, try not to break everything else along the way. Because, of course, your new rule set has to satisfy all the answers you liked before, right? So you have to create a rule set that got to the right conclusions you liked every other time and also fixes this problem so that when you reapply the rule set in a neutral way with your blindfold on and your scales in your hand, and you don't care about the result because you have a blindfold on and you just have scales and you go put things on the scale, the right answer will pop out. So try not to break everything along the way. But that's categorical thinking. That's a conservative thinking. That's a conservative's way of approaching the problem. A very bad way for a conservative to approach the problem is to get to the end of the page and be like, I don't like the answer, therefore I'm just going to make an exception. You know what I think about just this one time, bro, right? You know what I think about just this one time, bro, when it comes to law, right? It's like, this is conservative jurisprudence through and through. This is how conservatives think. So welcome to conservative jurisprudence. Well, at least welcome to this conservative jurisprudence, because I'm disagreeing with Alito's conservative jurisprudence. I'm looking at Alito. I'm like, yeah, you're being a bad conservative. So welcome to this conservative jurisprudence. Fun times. So in 1817, we decided maybe criminal jurisdiction, which I don't have a problem with that. Treaties repeatedly described as being within the jurisdiction of the United States, depending on what we're talking about, sure. Likewise, the court held that Indians were within our jurisdiction subject to our laws. With what meaning? Thus, tribal Indians were subject to the jurisdiction of the United States in the sense they could be. That can't possibly be true because in 1913, which is like 70 years after these things you're writing, they decided that Indians were still not citizens. So it can't possibly mean that because the Supreme Court said so in like 1913. What it confuses me is it feels like they're stating natives are not citizens. Yeah, that's what they're saying. That's exactly what you're saying. You're not confused. You understand correctly. They are 100% saying that Native Americans are not citizens under the 14th Amendment. You do not misunderstand. That is what they're saying. That's what the Supreme Court said in like 1913. You don't misunderstand. You're not confused. That's correct. They are in fact saying Native Americans are not citizens of the United States by being born here. That's 100% what they're saying. You're not confused. You got it. Moving on. Yeah. 100%. You got it. You're there. That's dumb? Well, maybe, but at least you understand the dumb now. The understanding of the phrase subject to jurisdiction thereof also explains why naturalized citizens must forswear all allegiance when they become United States citizens, which isn't even remotely a requirement. United States grants cert on an AR ban case? Outstanding. Outstanding. That's very good news for the Second Amendment people. Fantastic. That's great. From the earliest days of the Republic until now, Congress has required naturalized citizens to renounce, but not so much. You can absolutely be a dual citizen in the United States, even today, so not so much with that. Also, I don't know 100% how it works as a matter of U.S. law. I know, like, if you're born into it, you can have, like, both UK and U.S. citizenship at the same time, but I honest to God don't know if, like, you're a UK citizen and you want to become a U.S. citizen, whether you really do have to give up UK citizenship. I know that, like, in the oath, you say you do, but, like, do you actually? I actually don't know the answer to that question. I don't know whether or not you actually have to give. I don't know. I actually don't know what the rule is. I'm not an expert on immigration law, so I don't know. Yeah. So so assuming that you weren't born here and you're a citizen of some other country and you come to the United States and you follow the legal immigration process all the way through the legal way, and you get to the end and you become a citizen of the United States, do you necessarily have to give up all citizenship to any other country you belong? I honestly don't know the answer. I don't know. Can I break down the AR ban case? As soon as they decide it, sure. You want me to break down the case? You can talk to me in about a year. You can keep it? Cool. There you go. So that's definitely not a requirement. So moving on. Such an oath would not be necessary, but not so much. That's actually apparently not the rule. And some of the 14th Amendment, no, that's not what it says. Court in terms of subject jurisdiction that frames means subject to the laws. That's not exactly what they're saying. That's not a fair interpretation of the majority decision. No, there you go. First, he gives the 14th Amendment citizenship plainly differs from the Civil Rights Act. It does? How? Justified departure, it argues that raises more questions than answers. Oh, you just think that you don't think that the language is coextensive, or you think that, oh yeah, you think that, okay, I get what you mean now. I understand. But, okay. But that's fine. I mean, it does use different language. Now, you think they were written at the same time, and so they have significant overlap. You think they're one-to-one, which is a strange interpretation. Not impossible, but strange. Like, you have very different language. They could mean the same thing, but that's a bit unusual. I mean, you're not talking about like a word here or there. You're talking about a phrase difference. So it's like, not so much. Now, it's probably better to say the 14th Amendment includes at least the CRA. It might go further than CRA, but yeah, that's not right. Justified departure raises more questions than its answers, but the way I see is where subject to any foreign power raises fewer questions. The Constitution might have gone further than the CRA. Second, the court cannot explain why the 14th Amendment did not confer citizenship on children born in the United States of tribal Indians. Well, you can, incidentally. It's not that hard. I mean, the concept of Native Americans was very different at the time than it is now. The idea of them being being true, independent, sovereign entities was more a thing than it is really in modern understanding. So it's not that hard to understand why Indians were excluded. Now, whether that's a good thing or not, it's a whole nother set of problems. But to understand why they were treated differently, there's a lot of bitter history there. So there's kind of some reasons. Can we think of any reasons why it might be a good thing? And incidentally, at the time, the tribes didn't even want citizenship. So this wasn't even an anti-Indian thing at the time. What they came to think of it later is a whole other set of problems. But the Native Americans didn't want citizenship at the time. So you could view it as an act of respect because, there was some history that can you think of any historical reasons why the Native Americans might not want to be thought of as citizens of the United States? Can you think of any reasons why they might want to not be thought of as part of being America and might want to be left the fuck alone? Can you think of any reasons at the time that Native Americans might be, we're not really so thrilled with the idea of being citizens, and the United States might say, we understand that, so we're not going to impose this on you? Can you think of any reasons why that might have been the thought at the time? It's not super duper hard to think of why they might have thought that thing. Now, what we think about today, but can you think of any reasons at the time? I can think of some minor reasons. Any reasons why the Native Americans might have been, don't call us citizens, leave us the fuck alone? Can you think of any reasons? I can think of some. So they can't explain why it didn't confer citizenship? I can. History. There were some events. As explained, federal law governed those children and parents to the extent the federal law wished, which is true enough as far as it goes, because they still have the right to govern it, which is a whole nest of nightmare fuel. So that's true. Yeah, the original sovereign citizens. They were the original sovereign citizens. And the U.S. government said, you're right, for a long time. That's how hardcore it was. The only sovereign citizens ever. They said, we're sovereign citizens. And the government said, yes, you are. They won for the next 150 years. Yeah. And why might they want that? Can we think of any reasons? Fuck. Until Congress changed it in 1924 by statute. Third, the Congress cannot explain. Yeah, you can't think of any reasons why Congress might have had some different thoughts until 1924. Geez, in 1923, was there any reasons that up till 1924 they might have excluded the Native Americans or treated them differently or separately in any way? Can we think of any reasons at all? Oh, man. Third, the court cannot explain why the phrase subject to jurisdiction applies to naturalized citizens. Well, it wouldn't. It wouldn't apply to. Wait, no. What does the 14th Amendment say? What? Hold on a second. Yeah, all persons born or naturalized. What the fuck are you talking about? The court can $10 from Heartbeat. God bless the next 100K dead patriots that want the correct record. Do not discourage those that want to define Americanism. GG, the next revision when needed. Thank you for your super chat. The court cannot explain why the phrase subject to jurisdiction in the United States applies to naturalized citizens. What? All naturalized citizens, like everyone else who's present, must obey the law. So the phrase meant what the court thinks it's superfluous. Well, no, it's just saying that people who are naturalized are citizens in the full sense of the word. Because you could hypothetically have like some sort of two-tier citizenship system, right? So you could have it so like naturalized citizens are some lesser tier of citizen. So the 14th Amendment says all persons born in the United States or naturalized are citizens. So what it's saying is that naturalized citizens are citizens in the exact same sense as a person born here. They're equivalent. That's all it's saying. So all persons born here or naturalized are citizens. So what does it mean? Well, if you're born here, you're a citizen. If you're naturalized, you're also a citizen. How is this confusing? I'm confused by your confusion. I'm confused by your confusion. By contrast, if it means not being subject to any foreign power, which isn't even true necessarily for naturalized citizens, it serves an identifiable purpose, explains why naturalization exists. Well, no, maybe they just wanted to be clear that naturalized people were not second-tier citizens. So if you make it all the way through the naturalization process and you're a citizen, you are a citizen in exactly the same sense as a person born here. Why is this confusing? Why is this you can't understand why the phrase would include naturalized Americans? They want to be clear, beyond doubt, they're citizens in the exact same sense as natural. Why are you confused? I'm confused by your confusion. Please help. Please send help. Let the founding fathers count as citizens? Well, by this point in history, there were no founding fathers left, so I don't think that was the problem. I'm not really sure that was for founding fathers in mind, unless they were thinking retrospectively for some reason, but whatever. Moving on. For this reason, the interpretation does it, though? Court does not confront these problems because it pays little attention to the text. Now, that's just mean. Instead of performing its own textual analysis, the court leans on precedent that glosses the text. But none of them analyze the text. Yeah, I mean, I will agree. The precedent is of marginal value in this domain. Even Wong Kim Ark is of marginal value. I mean, they're all clues. But to say that there's no precedent that decides the question is correct. There is no precedent that decides the question. Now, that being the case, it's completely reasonable from a conservative perspective, incidentally, to look at what the precedent does teach to see if it might have some suggestions on the matter, right? I mean, I know there's no precedent that exactly says this, but here's some stuff that seems to be suggestive. Maybe we should go read that and see if it provides any wisdom on the subject. That's a perfectly conservative thing to do. What the fuck are you doing? Now, that being the case, they're going to gloss over it a little bit because it is gloss. They're not glossing over it because they're lazy. They're glossing over it because it is gloss, because it doesn't decide. So they're like, well, here's basically some vague musings on the subject. And then you're like, the majority treats them as vague musings. Well, of course we do. Of course we treat them as vague musings. That's what they are. They're vague. They don't decide the question. There's some things that, kind of speak to the ideas, and, we're looking at them, and, they provide some gloss on the idea. You're treating it as gloss. Of course we are. What do you think we're doing here? Holy shit. So yes, we treat it as gloss because it's glossy shaped. But none of those analyze the text. You're right, it doesn't. But we're doing what we can with what we have. We're cobbling it together best we can. What the fuck? The court first cites Lynch, but then as Justice Thomas comprehensively explained, any reliance on Lynch is misplaced. Sure. Next, it turns to Schooner, which held that a ship of war of a friendly power could enter the United States without seizure. Sure. Great. Yeah, okay. The next question, whose team am I on? I'm on Team Constitution. That's whose team I'm on. I'm on Team Constitution through and through. That's what I am. I am, or at least play one on TV. I'm a constitutional scholar. I'm on Team Constitution. I want what the Constitution says through and through, for good or for ill, right? Because I'm a categoricalist. I don't pick and choose. I don't pick and choose. I want all the Constitution. I like all of it. For good or for ill, I want every last drop of that Constitution. I want it injected into my veins. Now, there might be things in the Constitution I don't like, but you know what? That's just my tough shit, because it's part of the Constitution. It's part of the Constitution, and I'm going to give it every ounce of respect and worth that it's due. I'm going to give it whatever meaning it might have. I'm going to give it full faith and credit, and I'm going to give it the full throat of support, for good or for ill, whether I approve or disapprove, whether I like it or dislike it. I'm going to give the Constitution every breath of my meaning, because I'm a constitutionalist and I want to follow the Constitution. So whatever it means, that's what we're going to do. So whose side am I on? I'm on the side of the Constitution. What does that mean for this case? Well, I'll tell you what it means for this case. The majority made some good points, albeit at times red herrings. Alito's dissent sucks ass. So what it means at the moment is I'm siding with the majority. Now, I'm not committed to that proposition because I'm still reading, but that's the direction I'm leaning. The majority makes some really good historical points. They seem to have a lot of support. Now, they do some red herrings along the way, which isn't great. I really wish they wouldn't do that. It isn't necessary for their argument. It could just not be there and it would be fine. So a little disingenuous for no particular reason. So that's a little annoying, but it is what it is. It's not a perfect opinion. And I'm going to say so because I'm being honest. The majority has some red herrings in it. Here's some things I like. Here's some things I don't like. Okay, does the dissent make a better case? Nope. Not so far. So far I'm on team children of immigrants, children of illegal. So far I'm on the team of children of illegal aliens are citizens of the United States, because the majority has a persuasive argument, and so far the dissent has dick. But I haven't reached to my end conclusion yet. I haven't reached the end because I'm still reading. So maybe I'll change my mind back. Right now, it's not looking real great for the people who want to exclude the illegal aliens. That's all I'm just saying. Right now, things are not leaning in your favor. Would I have said the Constitution, would I have been yeah, you would have said the Constitution is wrong? That's cool. Yeah, I have no problem with that. There are provisions of the Constitution I think are wrong. I'm not going to necessarily tell you what those things are because it's not really material to our discussion. But them being wrong is not the same thing as it not being the law. It is the law itself, the supreme law, if you don't mind. Can the supreme law itself be wrong? Of course it can. You know how I know that? There's these things called amendments. Whoa. You know how I know for an absolute certainty the supreme law of the land can be wrong? You know how I know that for an absolute certainty the supreme law of the land itself can be wrong? Because they gave me a mechanism to change it. That must mean it can be wrong sometimes. Oh my God. The supreme law of the land might be wrong. Fuck. Jeez. Well, it's really good they gave me a mechanism to change it. Maybe we should do that sometimes. Yeah, you know, this Constitution's some bullshit right now. Maybe we should fix it. Oh, we did? We've passed an amendment? Fucking fantastic. Glad we did that. Glad we fixed that little foible. Holy shit. Yeah, can the Constitution be wrong? Yeah. Is there a way to fix it? Yes. Is the way to fix it for the judiciary to start making up bullshit? Fuck no. Yeah. I am pro 13th Amendment. I think it was a good idea. I like the 13th Amendment. I think that was a good idea. Fantastic. Let's not have slavery. Slavery, not such a great idea. Let's not do that anymore. Awesome. All right, next the court turns to Schooner. The question, Schooner exchange, the 14th Amendment, however, does not waive part of the United States sovereignty. Sure. It's true the government has waived its sovereign right to subject covered diplomats and their dependencies to the legal process, but that's done by statute. Yeah. Okay. That implements treaty obligations and long respected norms of international law. Yeah, that's true. Fair enough. I suppose we could change the law so we can prosecute diplomats. It wouldn't have really anything to do with the 14th Amendment, but okay, moving on. The interpretation of the 14th Amendment citizenship clause above is based entirely on the text and legal concept, does not depend on the record debates, but the extent they strongly support textual interpretation are not doing really great right now. Yeah. I'm not a fair weather conservative, or I try hard to be. I'm not perfect. You know, I'm a human being too, and I sometimes can't stomach things, but I try, although not infallibly, because I'm a human being and I make mistakes and sin. What amazing concepts, I know. But I try to not be a fair weather conservative. I actually believe in things called principles. Remember those? Remember? I believe in things called principles. And I'm going to apply those principles even if the result is something I don't like. Whoa! You know, because I'm principled. Wow! It's amazing. Nothing up my sleeve, folks. It's great. All right, so we've got some people who said some stuff about this at the time. We got a couple of senators who said some stuff, but, you know, so some other senators said some stuff. But, you know, actually, it's very odd for conservatives to do this. This is, although I think it is not wholly inappropriate, it is notable as odd for conservatives to use legislative history to interpret text. That is not something that conservatives typically do. You know, if you went to court with a statute and you had a statute and you're like, hey, what does this mean? And you're talking to conservative justices and you're like, you know, well, during the floor debates, here's what some people in Congress said. How's that going to work out for you? Not great. But suddenly the conservatives are doing it now. It is odd. It is notable. That is not what we do. But it is today, I guess. We're doing some legislative history, even though normally the conservatives would sooner, you know, chop off their own nose than do legislative history. But apparently we're doing it now for some reason. So we're doing it for some reason, even though normally we think it's the devil, but we're going to do it today in a principled way, I'm sure. So here's some legislative history, which we're going to bring up, even though we would never, ever, ever normally do it, but it's positive for us. So let's pretend. Some more legislative history. Oh, this is good. I do not suggest we should base our decision made during the legislative debates. Then why'd you mention it? This is the most disingenuous sentence I've ever read in my life, right? He has to say this, but then why did he write the preceding two paragraphs? This is a disingenuous sentence. I do not suggest we should base our decision in this case on statements made during debate. Well, no shit. That's what conservatives say. But that being the case, why'd you just spend a couple paragraphs talking about it? If it isn't something we should base our decision on, in other words, it's irrelevant, right? Because if we aren't to base our decision on it, it's irrelevant. Why are you talking about irrelevant things then? Are you getting paid by the word? What's that about? Reliance on any form of legislative history is always a problem. I know. Why are you doing it? Here, the only legislative statement we have are floor statements. Great. Cool. Yeah, so why are we talking about it? We should base our decision on firm ground provided by the Constitution. But if we look beyond the text, such as the congressional debates, which in no way we're supposed to base our rule off of, I mean, the guy just wound up being a hypocrite within the space of 5 paragraphs. Normally it takes a little bit more than that. This is just total hypocrisy. He's writing this in the same breath. Does he not notice? Apparently he doesn't. He's like, you know what? Here's a whole bunch of legislative history. We should totally not use it. But if we did, what's the rule? What's the rule? This decision, I didn't think it was possible. You know, I didn't really have a firm position on this one way or another. I thought that there was some good arguments about it not being for, illegal immigrants. There was a great law review article I read that I thought made some really powerful arguments along this domain. But I hadn't really picked a side on this question. And if you want to drive me, it's a really bad day. It's a really bad day when you're reading your own side's arguments and you're like, I think the progressives are right on this one. That's a bad day. That's a bad day. I'm reading Alito and I'm like, I think the progressives are right. Unbelievable. Unbelievable. Unfucking believable. Unfucking believable. I'm dying. And I don't have promise, and I haven't read Thomas, but I'm not having a lot of promise that Thomas is going to save the day. Not to say that I haven't ever agreed with Thomas on an opinion, but I don't have a lot of high hopes. He's not a hypocrite. Please read the whole discussion. I'm reading the entire case. I'm reading the whole thing. I couldn't be reading more of the whole thing if I tried. All I noticed is that he contradicted himself directly within the space of 6 paragraphs twice. He said, here's the history, and we shouldn't do it. But if we did, I'm reading. It's going great. After the ratification of the 14th Amendment, Supreme Court cases quickly acknowledged the interpretation rules set above. In Slaughterhouse, which I hate the case too, because it killed the 14th Amendment. You're citing Slaughterhouse? Unbelievable. Wrote the 14th Amendment citizenship clause was intended to exclude from operations citizens or subjects of foreigners born within the United States. Expressing doubts in Elk versus William, Justice Gray's opinion held that citizenship requires not merely a person born in the United States be subject and respect by completely. That's definitely not right. Warren Limited. The turn of state's law until Wong Kim Ark in a different direction. The case provides the strongest support for today's decision. That much is definitely true. I would not allow the meaning of American citizenship to be forever dictated by the opinions dubious dicta. Fair enough. It is dicta, although it's dicta in your favor, in my humble opinion. I think you're going about this the wrong way. The dicta in Wong Kim Ark, I think, is in your favor. You're looking at the wrong way. You're treating it as just domicile for the sake of domicile. It's a lot easier to recontextualize it as talking about green card status. Now, they didn't really have green card status at the time, so the analogy isn't perfect, but it's a lot more intellectually honest to say when Wong Kim Ark was talking about domicile, what they really meant is that what we now would call green card. Didn't exist at the time, but that's what they're talking about. You know, the idea would get later flushed out, right? They didn't really have a word for it yet, but later it got flushed out and it's like, oh, that's green card status. We recognize what that is now. That's what they were talking about. They didn't know it yet, but that's what they're talking about. That's a lot more intellectually honest than trying to distinguish from Wong Kim Ark. You don't have to distinguish. Wong Kim Ark is in your favor. Why are you doing this? It's totally not how I'd go about it. This is a very backwards way about going about it. I don't like this at all. Why are you doing this? Instead, you're just going to ignore the dicta, which I understand you can throw away a throwaway line here and there. I mean, yeah, but they mentioned it like 18 times. I mean, it's a little bit, I mean, it's essential. It's dicta. It seemed, are you sure it wasn't essential to the reading? Because I think it's essential and a very reason to distinguish it. You're going about this elite is going about Wong Kim Ark exactly backwards. This is a horrible way to go about it. He's going about it exactly backwards. And this is insane. This is insanity. I'm losing viewers rapidly to more conservative channels, I would like to take note. I was at like 378. I'm at 278. I think I'm losing my audience. I think I'm losing my conservative viewers, and they're probably going to the more conservative people who are willing to say that birthright citizenship is a disaster for the country, which it may or may not be, but that's consequentialism. Maybe it's a disaster for the country, but is it the right answer under the Constitution? I think I'm losing viewers. I think I'm losing viewers to more conservative YouTubers because I'm like, you know what? Maybe they're wrong. Court leans heavily on Wong Kim Ark, showed little respect for precedent. Okay. Wong Kim Ark's treatment of the text of the 14th Amendment's relationship with the Civil Rights Act fares no better. It's hard to skip the conclusion it was aimed at divert as much attention as possible from the provisions actually say. Are you reading the same Wong Kim Ark opinion I am? Because that's not what I read at all, man. I'm not. Did I misread Wong Kim Ark? Because did we read two different opinions? Because that's not what I'm getting from Wong Kim Ark at all. Did I misread it? I mean, did we read the same thing, man? Jeez. When the opinion finally turns the text of 14th Amendment, summarizes subject to jurisdiction has the same meaning as within the jurisdiction in the Equal Protection Clause. But the opinion makes no effort to explain why they might have chosen different language in two places within the same provision to express the same concept. What do you mean? Why not? That doesn't make sense. Of course you would. Why not? Why would you not do that? That makes total sense. He says it doesn't make sense. I'm like, it makes absolute sense. Provision 1. All persons born or naturalized are citizens of the United States. Provision 2. All citizens have equal protection. Why would they use citizen twice? Because one's defining what a citizen is, and one's clarifying what that means legally. What does it mean to be a citizen? Well, among other things, it means equal protection. Oh, okay. What's the confusion? Yeah, dicta is fuck your nation of citizens? I don't know, man. I don't know, man. This is... I agree with your assessment. I wouldn't leave. Thank you. Yeah, so he's like, it doesn't make sense to do it. I'm like, it makes total sense. Differences in languages convey differences in meaning. Okay. As for a phrase not subject to any foreign power in the Civil Rights Act, Wong Kim Ark tries two different tacks. First, it suggests the phrase means the same thing as subject to the jurisdiction of, but as if the opinion maintains subject to the jurisdiction thereof essentially means subject to civil and criminal liability for breaking the law, then subject to jurisdiction does not mean the same thing as subject to any foreign power. Yeah. Right. So, okay. Many aliens within our territorial limits are subject to a foreign power. For that matter, citizens are too. Some countries even mandate military service by those living abroad. Okay. Being within the United States is not the same thing as not being subject to a foreign power. Oh, okay. Wong Kim Ark argument falls no better than the first. The opinion speculates that Congress might have thought that not subject to any foreign power trimmed the birthright citizenship too much, and this accounts for Congress's different use. A perfectly reasonable proposition. The suggestion flies in the face of all the reasons previously mentioned why citizenship tests in the Civil Rights and 14th Amendment must be understood to be substantially identical. Yeah, well, maybe your conclusion is wrong. Maybe they shouldn't be treated as substantially identical. You ever think about that? This is accepted Wong Kim Ark, and dicta is sometimes not necessary to determine the exact. They mention it like 14 times. At the end of the opinion, court clearly spells it out, but have permanent domicile and residence. Yeah, which we would now call. Yeah, this is the holding of Wong Kim Ark. Yeah, a child born. This is Wong Kim Ark. A child born in the United States of parents of Chinese descent who at the time of birth are subject to the Emperor of China, but have a permanent domicile and residence in the United States. Yeah, that sounds a lot like green card status. They didn't call it that then, but green card status. Yeah. So, green cards. That's what I think. That makes sense to me. Thus, in holding the case was limited to children born here in the United States who are not citizens but established permanent domicile. Yeah. And it's Congress that gets to decide what permanent domicile is and if you're allowed to create it, which sounds suspiciously. Yeah. So at the time, right, this is the distinction, right? At the time, we had essentially open borders, as we did for a large part of our country, right? They mentioned that earlier. In earlier American history, all you had to do was show up for 2 years and not break a law, and you're a citizen. Poof, congratulations. That's a very easy way of becoming a citizen, right? Even at this point in history, we had pretty much open borders. Not quite as much, but still. And so this person's here with permission of the United States, but it's the United States that gets to define that, right? So they're here domiciled because the United States creates the rules that allow for it. Early American history was show up, congratulations. Later, not so much. Congress gets to define it. So Congress has redefined it to mean green card status, which deals with their ability to control the border, because they can exclude at the border pretty much without limits, unless you're a citizen. But other than a citizen, they can tell anyone to go away for pretty much any reason they want, because borders. So if you're here with the permission of the United States, whether that's anyone who comes, great, or, green card or whatever, and you're domiciled, then cool. Today we'd call that green card status. So children of green card holders are citizens. Okay. How hard is this? It's not that hard. It's a much easier way to go about it. I don't know. The court dismisses these points and repeatedly refers to domicile, arguing domicile was merely an incidental fact and not element. I think that's the wrong way for the majority to go about it too. The problem for the majority is they don't want it to be as constrained as it is. The majority treats it as dicta because they want it to be more than it is. I don't know why on God's earth the minority is treating it as dicta, because it feels like the easiest thing in the world. Yeah, they meant exactly that. And by that, they mean what we now call this. And because they're not that, therefore, illegal immigrants don't apply. It's the easiest thing in the world, but they're not. I don't know, man. They're not going down that road for some reason. I don't know, man. Okay, so Wong Kim Ark is telling Justice Gray Holding mentioned rules were Chinese. The British birthright citizenship did not take account of the citizenship of the alien. Sure. So if the opinion had aimed to adopt the British rule, there was no need to whatsoever to hold that. Well, we had anti-Chinese sentiment at the time, so it was worthy of mention. The fact that he was Chinese was factually notable because there was a lot of anti-Chinese sentiment at the time. So that's why they mentioned it, because that's why he was not being allowed to be a citizen, because we were anti-Chinese at the time. Blah, blah, blah. Wong Kim Ark, their domicile takes on special meaning. If they'd been white and black, they could have applied, right? Because they were Chinese, they forbade. Because they established domicile, they did everything possible with intent. So maybe today Congress would, so it's like, so they weren't here legally, but they were trying. So I don't know. I think there's easier ways to distinguish and just be like, oh, it's green card status and call it a day. Wong Kim Ark is therefore best holding that people are lawfully present here. Yeah, I like this. Wong Kim Ark is best understood as holding that people are lawfully present here, establishing the United States as their permanent home. But see, this is the first part is good, but then he kind of loses it in the back half. Establish the United States as a permanent home and do everything with their power to become citizens, can no longer be subject to any foreign power. But that would give citizenship to lots of illegal immigrants. So Alito is not even getting to where you guys want to be, like the conservatives who don't like this. Because Alito is saying flat out that Wong Kim Ark's parents were not here legally because of Chinese exclusion acts, right? The law at the time was basically everyone is welcome except for the dirty Chinese. Wong Kim Ark's parents were not here legally. They were really trying, though. They did everything that they could to be here legally, like get jobs and like participate in the community and everything. And their children were citizens. Now, there are two ways to solve this problem, right? There are a couple ways to solve this problem. You kind of gloss over the details of the Chinese Exclusion Act and be like, well, what they really were was green card holders. So that's one way to solve the problem. Alito goes about it in a way that undermines what he's trying to do, because he says, look at what he says. It's not me saying it. Look at what he says, okay? You don't have to take my word for it. Just read what he says, okay? Look at what he says. Don't take my word for it. Wong Kim Ark, okay, the precedent, is best understood as holding that people who are lawfully present here, they were lawfully present, they just couldn't get domicile, right? They were legally here. Wong Kim Ark's presence were legally here. So he's going to go on the idea of legally present here, but that would do nothing for birthright tourism. So he might be trying to like do everything on lawfully present here, but even then, it's just a very weird way of going about it, because it's like, okay, if a person's here on a temporary visa and they give birth to a child and they want this to be their permanent home, but they're only here on a 6-month visa, does that count? Because they're really, really trying their hardest, because they're doing everything within their power. So birthright citizenship is okay. I mean, it's a convoluted mess. It's a convoluted mess that undermines its own conclusion. It's legally unsound and then undermines itself in the way he's going about it. The majority's like, this doesn't make sense. I'm with the majority, at least as to that much. I'm like, this is some convoluted nightmare bullshit. You know, you don't really have the precedent. You don't really have it. And you're enacting a rule that winds up just eating itself. It's like, well, as long as you're lawfully present here and you try your best and wish upon a star. What are you doing, Alito? So birthright tourism is okay as long as they really, really try? What are we doing? He's eating himself alive in convolutions that he doesn't have to do, because he's coming up with an interpretation of Wong Kim Ark that is completely not required. He's trying to distinguish Wong Kim Ark based on an interpretation that isn't compelled by the case. The whole thing is nightmare fuel. What is this going? And he was here prior to the Chinese Exclusion Act. Well, that too. But either anyway, it's like there's ways to do this, and this ain't it, Chief. This ain't it, Chief. Alito's opinion is garbage. It falls apart. It's nightmare fuel. This opinion sucks. His opinion sucks and is horrible, and I hate it. I hate it. It's not necessary. He brought slavery into this for some reason. Wong Kim Ark benefited Chinese Americans, but its impact on other immigrants were limited. For decades, immigrants were made largely unregulated. Yeah, I know. During World War I, the federal government began limiting the flow of immigrants. In 1917, before my father's grandfather came here, holla. My father's grandfather. My father's grandfather did, well, what today would be a little illegal immigration, but at the time was okay because it was fine. Yeah, my father's grandfather was a German sailor at 17. And this would be 1913, 1912, something like that. These dates are critical, right? So circa 1912, 1913, my father's grandfather was a sailor on a British ship, and he was a tuba player. And the German ship came to the United States at the port of Philadelphia in 1912 and 1913, and my father's grandfather got off the boat and didn't go back and became a citizen, which was legal at the time. Maybe not under German law, but the Americans had no problem with it. Lol. He's like, fuck this bullshit. I'm not getting back on the boat. And then World War I happened. So, probably good timing. Lord have mercy. All right. Anyways, where were we? Thomas makes the same argument as Alito. Oh, Lord have mercy. Yeah. Where were we? Immigrants, both legal and illegal, was light. Number of Americans shrank. The story of illegal immigration, I don't care. Illegal immigration is bad. I don't care. It doesn't really inform the illegal immigration national problem. Don't care. Efforts to solve immigration, don't care. Despite this, don't care. Congress has not passed comprehensive legislation. That's not the judicial branch's problem. States did some stuff, don't care. Blah, 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 blah. Immigration's been a problem, blah, blah, blah. Congress hasn't passed any laws, blah, blah, blah. As a result of this, some bullshit illustrated by laws of countries. Whatever. Other countries don't have birthright citizenship. Who cares? Other countries don't have the Second Amendment either. What are we talking about? Response claim in this test, executive orders unconstitutional face, blah, 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 blah. That is a horrible opinion. And then we went on for several pages talking about the scourge of illegal immigration, like that has any idea what the 14th Amendment means. Who the fuck cares? So that was exciting and bullshit. And we are going to speed read because there's no way I have the mental fortitude to read Thomas and 94 pages of it. But I'm okay because I've been doing this for a very, very long time. And so I'm very, very good at speed reading decisions and look because I know where to look. It's gotten to the point where I actually know where to look in paragraphs because I know how they're written. And so subconsciously, I just know where to read because I've read thousands and thousands of decisions. So I can speed read it very, very fast. So let's speed read it and see if there's anything of any value whatsoever. Thomas saved the day for this proposition because Alito's not doing you any favors. Thomas, unfortunately, has a tendency to sometimes just appeal to incredulity, and that's not going to do the trick. But maybe he has something principled. If anyone, he is capable, when he's at his best, he is definitely capable of writing better than anyone, at least that's still alive, when he's at his best. But he's not always at his best. Some days he writes some real bullshit. So can Alito save the day? or apologize, can Thomas save the day? I'm still trying to find the start of his opinion. I can read it fast, but I can't read it fast in reverse. He goes, is he writing War and Peace or what? Once there was a girl who had a child here illegally, and what about their child? And then the child grew up. Okay. Let's speed read this thing. Okay. He's off to a more promising start. I begin with early American history. In America, you're generally a citizen if born here and this was your home. That's not a great start. Okay, so they're talking about domicile. Domicile is critical for citizenship. Okay. Approach consists of country's early ethos. Okay. Blah, blah, blah. The United States did not claim every citizen born on soil. Kind of did. Children were domiciled. No. Domicile requirement. He's doing better. Birthright, parent domicile, where they result domicile. Law domicile is interesting to understand. Okay. This is better. Domicile means legal home. Okay. This is promising. So far, so good. Domicile of his parents. Okay. Every person only has one domicile. That's true. Okay. That doesn't necessarily mean that you're not subject to a foreign state, but just because you have a domicile here, you can still be subject to a foreign state. So fair enough. Dual citizenship, 19th century. Okay, so you could only be a citizen of one place at a time at the time. Okay. I'll take your word for it. I'm reading. Once a person became domiciled, he's no longer subject to any foreign power. Okay. Okay, I'll take your word for it. When a person traveled, yeah, but it's worse than that because Americans who domicile in other countries are still subject to U.S. law. And subject to home country, person moves his home country permanently, is no longer subject to the country from where he's originated. Does this mean that citizens of the United States who are domiciled in other countries no longer have to pay taxes in the U.S. because they'd be thrilled? Does it mean also that they lose their U.S. citizenship as a result? They'd be less thrilled maybe about that. I don't know about that. Temporary visitor government does not apply the same law. Okay, domicile. Domicile determines civil and political rights. He fixes allegiance. That sounds a little bit like what Justice Jackson was trying to say. If I visit Japan, I'm subject. Yeah, I guess if you visit long enough, maybe. Domicile determine which government had the power to declare laws as individuals' most important affairs. Sure. Marriage and divorce would be determined by domicile. Fair enough. Age of majority, right to sue. Domicile determine which government had plenary jurisdiction to regulate his activities anywhere. Well, yeah, but we regulate our activities overseas. Power to impose taxes. The people overseas might have some thoughts about that. Maybe he doesn't think that foreigners overseas should pay taxes, or citizens overseas rather shouldn't pay taxes. Domicile determine when government a person prejudice or protection. Okay. Dred Scott. Scott was domiciled in Missouri. Fair. Cortes Creed held Scott was not a citizen, therefore could not sue because of race. Blacks could not become citizens because it considered subordinate and inferior beings, and a whole lot of other language. Permanent domicile. Blah, blah, blah. Okay, still reading. He's making some points here about domicile that are interesting. I'm just kind of wondering how he's going to where he's going to go with it. His background that he's setting up is good. I'm a little bit curious how he's going to connect the tissue, though. But his introduction is interesting, intellectually. Civil Rights Act includes children of temporary visitors. Indians not taxed. Fair enough. Tribal Indians not completely subject to jurisdiction. Okay. Uncovered civil rights are subject to foreign power. So the slaves. So he thinks the act and the Constitution have the same meaning despite the different language. And he's using the constrained language of the act to constrain the Constitution. All right. Phrase subject to jurisdiction thereof is a familiar way to describe the relation of domicile to his home nation. Fully and completely subject. Full implied jurisdiction. Leave a clause fixed in place the World Civil Rights Act. No one knowing allegiance to what it means. Citizen Clause Civil Rights Act includes citizens from tribal citizens. Tribal Indians were excluded because, like temporary visitors, retain a primary allegiance to and they're subject to their primary nation. Okay, tribal, they're not subject to complete jurisdiction. Okay. With respect to contemporary visitors, children born temporary visitors of allegiance. It's a little conclusory. He doesn't have a lot to work with, to be fair, though. But yeah, it is a little conclusory because he has the predicate for it, but he doesn't really have the connective tissue that he needs to get to the end of the page because it just isn't there. And he's trying to get from the predicate to the end with a little hand wavy in the middle. And it's not as bad as Alita's dissent by far. It's just as thin and not really doing a lot, but took the same position. Domicile in the United States. Okay. Okay. So they have examples in the past where, all right, where various people were denied citizenship. Okay, fair enough. Okay, that's interesting. And these examples are post 14th Amendment. Okay, cool. That's helpful. Mm-hmm. Mm-hmm. Okay, so he's got some examples. Okay, so this is helpful. Okay. Same language. Powers. Incorporated language expressly. Okay. So, yeah. Okay, that makes sense. Parties long agreed Constitution does not apply to persons born temporary visitors. Uh-huh. Senate Elks. Mm-hmm. Plessy versus Ferguson. Lord have mercy. Citizenship exclude persons not domiciled here. So clause person foreign only when the parents are domiciled here. Okay. Thomas has a better argument, to be sure. Yeah, I'm giving Thomas a bit of a short shift here because I'm just trying to understand the outlines of his argument. Just to try to understand if he has anything better. But he does have something better. He's got the predicate. He's got predicate that works on domicile. He's got some examples that work that are post ratification. He's got some scholarship that works. So far, he's doing a lot better. I'm not sure if it can get him where he wants to be, but he's doing a lot better on the exam, I'll tell you that. So he hasn't completely lost his mind, as he sometimes wants to do. He's writing some nice intellectual treatises right now, which I appreciate. One sentence is speak for his jurisdiction, long academic scholarship. Just one more in scholars for domicile. Okay. Okay. Wong Kim Ark interpreted to apply person born and domiciled here. Rose out of the unique circumstances of the Chinese. Okay. Could not become naturalized. Okay. Ban Chinese immigration, Chinese Exclusion Act. Chinese person renounces allegiance. Chinese government could behead him. Okay. Chinese, even those who lived here, had no path to citizenship and no means of freeing themselves from the grasp of China. Executive branch took the view that because domicile no longer ensured full integration, subject to jurisdiction must require more than domicile. That view would entail a child born to Chinese parents was not a citizen. Instead, the executive branch sought to replace the requirement of domicile. The requirement the person's parents already be citizens. Okay, skipping ahead, the compilated facts. The court's decision in Wong Kim Ark concerned only persons already domiciled in the United States. Depends what you mean by domiciled. Government agreed that Wong was born and domiciled. Thrust was that birth and domicile were insufficient. Government lamented the mistakes made and misunderstandings. Blah, blah, blah. State citizenship was based on domicile, but argued different rules for national domicile. The court found so important that Wong and his parents were domiciled that it gratuitously insisted upon the fact. It sure did. It mentioned it quite a lot. Saying it's dicta is kind of, it's just disingenuous to say it's dicta. Now, what it means, yeah, it's a whole other set of problems, but to say it's dicta is, no. It seemed pretty essential to deciding the case. 7 different ways. Permanent domicile, confirmed domicile is the persons born and domiciled. Okay. Subject domicile, present single question. The opinion itself was meandering dicta. Sure. His treatment of Wong Kim Ark is definitely going better than Alita's is. I'll tell you that for damn sure. For the government's primary theory that due to birthright citizenship, child born before his parents. Time of birth. Okay, but does he say why Wong Kim Ark's parents were domiciled here? It doesn't look like he does. Let me just speed read it again, because it doesn't look like he said why they were domiciled here. In his view. Yeah, by statute, they could not be considered naturalized. So domicile might be different from naturalization. Fair enough. But does he, so they couldn't become naturalized, which is to say they couldn't become citizens, but they could live here. So green card status, are we talking about green card status? Or what we now call green card status? Is that what we're doing? Because if that's what we're doing, I can live with that. Kinds of Exclusion Act, renounce, okay. No path of freeing themselves. Okay, no path of citizenship. View that domicile no longer exists, shared full subject jurisdiction must require more than domicile. So grants ought to replace the requirement domicile. Okay. Stipulated facts. Wong Kim Ark was born in San Francisco. His parents were not temporary visitors. They were not illegal aliens. They'd done everything they could to express their desire and intent. They came to settle in America. So green card status, right? They couldn't become naturalized, but they could live here permanently. So green card status? Certainly, the person's domiciled. Greenwan was born and domiciled. Yeah. So green card status, why not just say that? Why not just say it's green card status, or what we today call green card? It's a green card from which you cannot become a citizen. I mean, they're not using that terminology, but that's what we would say in the modern time. If we took Wong Kim Ark out of its era and we put it in the modern era with modern vernacular, so they're allowed to be here, they're just not allowed to become naturalized, and they're allowed to be here permanently. Well, what's lawful permanent status? What do we call that now? What do we call it when you have lawful permanent status? We call it a green card, right? Right. So his parents had lawful permanent status, what we would now call a green card. Congress is like, but you can't become a citizen, but you can have a green card. Can't become a citizen, can live here forever. Okay, green card, no citizenship. Okay. Why not just say that? Why not just say that? It's what we would now call a green card. Congress at the time, in its infinite wisdom, decided that these kinds of people couldn't become citizens. They had a green card, but no path of citizenship. But he had a green card, and that's good enough for us. Why not just say that and call it a day? Why are you going through all these convoluted machinations when you could just do that? It seems a lot easier. And then you can get to where you want to be. You can take Wong Kim Ark and make it a case about green card holders and be like, okay, yeah, green card holder, but not illegal immigrants or permanent residents. If you interpret it that way, which is perfectly plausible, you get to exactly where you want to be, and you don't have to twist Wong Kim Ark to do it. They just didn't use the term green card because the concept didn't exist yet, because anyone could come here. That was the trick. Anyone could come here and live here forever. So they didn't have a green card yet because you didn't need permission. Everyone automatically had a green card. Everyone just automatically, that was the law at the time, essentially. Everyone just gets a green card. You want a green card? You want a green card? Can you show up? Congratulations, you have a green card now because it's lawful permanent status. Everyone gets a green card, but no citizenship for you. Okay, cool. Everyone gets a green card, no citizenship for you. Why is this hard? I'm confused. I don't know. Seems like an easy fix to me. I can work with that. Yeah, so they had permanent residence and permanent domicile with permission of the U.S. government. Oh, okay. That sounds like green card status. Okay. And then the question is the kid of a green card holder a citizen? And the Supreme Court says, sure. Cool. I can work with that. What does it say about temporary visitors or illegal immigrants? Nothing. Yeah, born and domiciled. Why not just say green card? Seems easier. And then you get to exactly where you want to be. Now, I mean, that constrains Wong Kim Ark. Which doesn't necessarily answer the question. But Wong Kim Ark is your biggest problem to having illegal immigrants, children not be citizens. Wong Kim Ark is your biggest problem. And I can very legitimately make that problem disappear. Now, it doesn't necessarily get you to the end of the page by any means, but it makes Wong Kim Ark disappear. So there's that. And that makes your job easier. So I don't know, man. I don't know. You know, feels like, whatever. So anyways, there's a lot of dicta about a lot of other things, which, sure, fine, fair enough. I don't care about those issues because they're dicta. Full and nonetheless decide, reject the premise for domicile here at the time of birth. It's settled here. Family cannot acquire a permanent home here no matter how long their stay. The Senate is because their view they were not actually domiciled. Okay. One comer left same the rule. A child of see, this is just the wrong way to go about it. This is the problem. The dissent is going about this the wrong way. They're treating domicile as the thing. And they're not really thinking about how do you get domicile? And they seem to be treating domicile as just merely the place in which you are and intend to remain, which is a typically correct definition of domicile. But if the government doesn't allow it, then you can't get domiciled there. So your mere presence and intent to remain cannot create domicile because it's a legal concept. Domicile is a legal concept. So if the state says, well, you can't do that, your wishes to the contrary can't overcome that. So, but the thing is, they pin it into domicile, and then they have to walk it back, right? Because they have to walk it back. Because an illegal immigrant who comes here and gets a job, and works a job and stays here for 20 years, is de facto domiciled. So then you have to distinguish that. And you run into all kinds of problems when you didn't have that problem in the first place, because domicile isn't quite right. You're not working on this quite right. The thing is not just that they're here with intent to remain, but that status was legal. At least that's my understanding of it. Wong Kim Ark's parents were here legally, right? They couldn't become nationalized, but their presence here was legal, correct? I am understanding this correctly, right? Wong Kim Ark's parents were here legally, permanently, with permission. Or at least the U.S. government didn't tell them to go away because there was no such concept at the time, whatever. But they couldn't become citizens. Okay, so they get automatic green card status because that's the law. Cool. But the government can change it. So what are we talking about? Yeah, this is an incredibly convoluted way to go about it, because then you have to distinguish between illegal immigrant domicile when you didn't have to go down that road. This is a very backwards way of going about this problem. So this is not working. Yeah, alien parents, but permanently domiciled, but with permission. Temporary visa, yeah, so, okay. Okay. Yeah. So, but Wong Kim Ark is not your biggest problem. I mean, you can make Wong Kim Ark disappear. That is not your biggest problem if you want to ban birthright citizenship. You know, you can make Wong Kim Ark disappear and just limit it to children of green card holders. I mean, that's not your problem. Your problem is that Wong Kim Ark certainly didn't speak to what's true of non-green card holders. It didn't certainly speak to that issue, and nothing really else does either. And the language of the 14th Amendment is what it is. And you're trying to root everything in domicile, and you're trying to use Wong Kim Ark as extending that concept, but it just doesn't quite work. It doesn't quite get to there. To be fair, though, Thomas is a lot more intellectually interesting than Alito. And I might be short shifting him a little bit because I'm speed reading it, but it's not quite working. Yeah, some took advantage, birthright citizenship, facilitate trips, blah, blah, blah. Yeah. A new range of scholarship. Yep. Lots of interesting law review articles on the topic. Blah, blah, blah. Uh-huh. 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 Yeah. Yep. Okay. All right. Here's my view, which remains subject to change, because I need to give Thomas more consideration. There is enough here that is interesting that requires some further consideration. Alito's opinion is a garbage mess, disaster fuel. I can reach that conclusion. Thomas has some things here that are worthy of serious consideration. Does it get him to the end of the page? I don't know. I don't know. I'm being a little bit, my analysis at this point, subject to change, is though the majority, I believe, has the better end of it. That is my cautious and subject to change opinion. The majority, I think, has the better end of it. It didn't particularly help when Alito started quoting legislative history at me. That didn't help. And the best arguments in support of the limiting principle are legislative history. Like, the quotes from the senators are your best thing, and that's a tool that conservatives just don't really use. And so it's awkward at best for conservatives to reach for that tool when it's a tool that conservatives just don't use. Conservatives hate legislative history. We think the random musings of, random senators or congresspeople is typically some bullshit. And so to see it used here is particularly rich, because it feels like we're doing it because we need the support. We're doing it not for a principled reason, but for special pleading. We're doing it because, reasons. Mainly, I need it in order to make my argument work. So I'm going to use a tool that I hate and loathe, but I'm going to pretend it's principled here, which you're having a tough time squaring that circle. So all those things. So my tentative opinion, my tentative opinion, very much subject to changes, the majority has the better end of it. This is going to require a great deal more analysis, and I'm going to need to hear more opinions from more people on this issue. I could use a second and third and fourth opinion on this issue. So I'm going to be conservative and defer judgment on the matter so that I can actually hear some other thoughts on the subject from a legal perspective, not just screeding, right? Yeah. So that's my thought. The first paragraph of Gorsuch's dissent, Gorsuch didn't write a dissent. I wish he had, but Gorsuch didn't write a dissent in this opinion. I wish he had written one, but he didn't write one. Unless you're referring to some other case. Yeah. Well, he tagged on both dissents. Yeah, he tagged on both Thomas and Alito's dissent. So, yeah, because it's right here. Thomas filed a dissent in which Gorsuch joins. Alito and Gorsuch filed dissenting opinion. So I guess Gorsuch co-wrote the Alito opinion, which we read and I hate. So I'm not sure how much of that is Gorsuch, but I hate it. I hate the Alito Gorsuch opinion. I think it sucks. We read the entire Alito Gorsuch opinion in full. We read the majority opinion in full. We read the Alito Gorsuch dissent in full, and then we skim read Thomas. The assessment was the majority is mostly good with some slight red herring and slight straw man problems. Alito Gorsuch dissent is a fever dream of nightmares. And having sped read Thomas, it's like he might have some things that are worth considering. Kavanaugh also dissented in part. That's true. Oh, I misread it. You're right. Gorsuch files a dissent. Okay. I apologize. You're right. That is what it says. There's a comma there. I misread it. Gorsuch did write a dissenting opinion. I'm an idiot. I'm a moron. I did a stupid because I apparently can't fucking read. Let us read the Gorsuch opinion. Sorry. I'm a moron. I read it wrong like 8 times. I hate my life. Sorry. If I'd known that, we would just read Gorsuch. I wouldn't have read Alito. I wanted to read Gorsuch in the first place. I wouldn't have read Alito because Alito makes my brain hurt. Alito makes me sad inside, and I want to yeah. So this makes me sad. Maybe Gorsuch has something to say. Gorsuch is my favorite by far. I've disagreed with Gorsuch to be sure, but Gorsuch is my favorite. So maybe Gorsuch can speak to me a song. Yeah, no, I just made a mistake. Gorsuch did write a dissent. All right, let's give this a shot. Let's see if Gorsuch has something to pull us out of this nightmare. What you got, Gorsuch? Do you have anything for us today? I can only hope. Let's see what we got. At the heart of today's dispute lies 2 competing views of the 14th Amendment Citizenship Clause. On one account, the clause incorporated the English common law rule of jus soli. That rule, developed in feudal times, has more to do with being subject than a citizen. It was based on the notion that a man owed personal service to the lord of the soil, the same as his master owed the king, and was born with child and only ended in the grave. Nice quote. On the other account, the clause adopted a distinctly American settler view of citizenship, one that promises the full dignity and glory of American citizenship to any child born in this country to parents who made this nation their permanent home regardless of race, religion, or national origin. To my, the latter understanding better accords with the clause's public meaning and leads me to join the dissents. Okay? I write only to emphasize a few points. First, understanding justice. I can read, I swear, sentences. I can read. First, understanding Justice Thomas and I share of the citizenship clause is consistent with this court's holding United States' Wong Kim Ark. That case involved parents born in China who made their home in this country lawfully, even though they never became naturalized citizens. The question this court faced was whether the child born in this country himself was a citizen. The government argued the child was not a citizen because his parents were not. This court rightly rejected the government's position. Throughout history, many nations have restricted citizenship by birth to children of citizens. But an American view of citizenship reflected citizenship clause is not so parsimonious. What matters is whether the children's parents are citizens. What matters is whether they, and by law their child, have made this place their home and domiciled, which sounds like green card status, so I'm off to a more promising start than whatever Alito was writing. Second, respondents choose to pursue a facial challenge to the executive order at issue and secure a preliminary injunction. Under this court precedent, we can sustain the injunction only if no circumstances exist in which the order might be lawful. That's true. It's a demanding standard not met here. Among other things, the executive order orders that children born temporary visitors in this country, whether here lawfully or not, are not citizens. And at least to that extent, the order is consistent with the citizenship clause as Justice Thomas and I read it. By definition, temporary visitors to this country do not make this place a home, and their children cannot make this place a privilege of citizenship. Because it's lawful, at least to that much, I dissent. Finally, just because the executive order has some lawful applications and can have a facial challenge does not mean it's lawful across the board. It means from narrow legal challenges. Besides addressing temporary visitors, the order also denies benefits decisions to children born in this country to parents who make their permanent home here but do in defiance of federal law. The government insists this aspect of the order can survive any possible legal challenge because individuals can secure domicile in this country only if they do so in compliance with law, which makes sense to me. About that, I harbor doubts. Really? Okay. Perhaps Wong Kim Ark does not squarely foreclose the government's position. After all, the case addressed a child born to parents who lawfully reside. Still, I wonder, is a child born here to parents who have long chosen to make this nation a permanent home not a citizen under the 14th Amendment solely because his parents' presence violates statutory law? I mean, that's a way to solve the problem. And if you go down this road, what about illegal immigrants? What about, that's, I don't know, man. If those parents aren't domiciled here, where are they domiciled? Well, domicile exists. I can help you answer that question, at least partially. Domicile exists wherever it exists until it's changed. So domicile first exists where you're born. So in want of any other thing, where their parents were born would be their place of domicile if the United States does not recognize their domicile. You can't change it to here if we want to allow it. So your domicile would be wherever it was before, no matter how long you live here. That would be the answer. But okay. And if the answer is nowhere, no, it would be wherever they came from, presumably. How can we reconcile that conclusion with, of course, the longstanding recognition that every person is domiciled somewhere? They are. They'd be domiciled wherever they were born, for want of a better answer. And their children could be domiciled here, but not necessarily given status. Which is interesting. I guess that would effectively make them green card holders. I don't know how that would work as a matter of practice. That's interesting. I hadn't really thought about that. Like, because domicile exists where, domicile first exists where you're born. Right? It would be really odd to say that a child born to, if you presuppose, well, we'll do Mexico because that's the thing at the moment, right? So let's take some Mexican citizens who come to the United States illegally. Perhaps they live here for a number of years. Perhaps not. I'm not sure if it makes a difference. They have a child here. Where is their child domiciled? Well, even if their parents are still domiciled in Mexico, regardless of how long they've been here. So they came across the border yesterday. They came across the border 40 years ago somehow and are still having children, never mind. And in that intervening time, have been working and all the rest of it. Even if you conclude their parents are still domiciled inside Mexico because the United States refuses to recognize it, it would be very odd to say their child is domiciled in Mexico. He might have been conceived, let alone born on this country, depending on what we're talking about. And that's a very odd thing to think. So if the child is lawfully domiciled here, de facto, what does that mean for maybe his children is an interesting quirk of this legal doctrine. So maybe that's the problem they're trying to avoid. Because, like, what about their children? Where are they domiciled, Kurt? That's a really good question. If they're domiciled here, can we kick out the child to a place that they were never domiciled in the first place? That's a really interesting question. I hadn't really thought about it in those terms. Maybe that's why they're fighting with domicile so hard. If that's what they're trying to do, they didn't make it clear in their decision. In any event, and that's the end of that. So, yeah, Gorsuch's opinion doesn't really do very much. He just muses about the question of domicile. And maybe if you're domiciled long enough, it counts. But the question is, and even illegally, because Wong Kim Ark's parents were here legally. And he's like, well, what if they weren't? What then? And he's musing that if you're here long enough, maybe that should count. So Gorsuch is kind of saying he's at least opening the door to illegal aliens who are here long enough and they have kids, and that's okay. So he's opening the door to that. Alito's all over the place, and I don't fully understand Thomas's opinion yet because I haven't given it the full weight that's due. So I don't fully understand Thomas's opinion yet. So what questions would you like to ask, preferably not about this case? Maybe one of the other cases or something else legally related, because I could use a change of topic. I don't know that I have a lot more to say about this case right now, because I really need to listen to some other commentators. And I really need to give Thomas's opinion another chance. He's got some bones there that could lead to something. So I need to give him another chance to see if he can lead me somewhere. Is Chevron dead? Chevron is very dead. Yeah. The grandchildren of illegal immigrants. Yeah, exactly. There are problems here. Yeah. Humphrey's executor is gone. You're trying to cheer me up? Oh, thanks. I didn't pick up on that. Thank you. Yeah. And I just know that I'm not allowed at the cool conservative parties because I'm at least open to the possibility the majority could be potentially right. So I'm not allowed at the cool kids conservative club. I'm not allowed at the ideological hardcore conservative club. So I'm not allowed with Andrew Branco, and I'm sure Ben Shapiro and Viva Free and Barnes, for God's sure. I'm quite sure I'm not allowed with a hardcore conservative crew right now, because I'm like, you know what? Maybe they're right. Maybe they're right. Do I want to talk about this? Yes, I do. Let's get you on stream. Nate's going to come on and offer another opinion, or at least some thoughts and musings on this issue. I could use a second opinion and several other additional opinions. I said Roberts. He's not Roberts yet. Let's get Nate on. First, I'm getting a beer. What time is it? 2:00? Close enough. All right. Let's get, yeah. Excellent. My mother's side is Scottish, so I've got that going for me. Shout out mom's side. What am I doing? I'm trying to get Nate on the stream. Okay, hold on. Now, how do I invite Nate the lawyer? Invite guest. Copy link. Text link. Neat. There he is. Great. Send message. No. Send message again. Okay, let's do that. Okay, now I need to capture the screen. I'm going to go to full alt here so I can capture it. Okay, great. If I press this, what happens? Whoa, that's definitely not what I want. Hold on, Nate. I'm fighting with the layout. Give me a second. No. What am I doing wrong and why am I okay? No. How do I change the layout? No. That's what I'm having trouble here. Nate is patiently waiting right now as I try to figure out how to stream. Okay. Oh, okay, add scene. Okay, cool. I guess that works there. And then if I do this, progress is being made. Excellent. And then I do this and bring it like that. And now people can see you. Great. Hello, Nate the lawyer. How are you doing?
Oh, I'm doing great. How are you doing, bro?
I'm doing good. So I'm trying to figure out what I think. My initial impression, I thought the majority was overall good. I thought there were some things where they were a little bit disingenuous to the precedent or a little bit perhaps disingenuous to the minority. Gorsuch didn't really say very much. Alito was disaster fuel. And I still haven't made my way through Thomas, but that's where I'm at right now.
This decision kind of pulled me in. Well, all the decisions pulled me in a couple of different ways. This one particularly, I legally believe Thomas made better logical points on the precedent when I read through it. But I think people who are saying the majority is wrong don't really understand the law, because I think the majority had a better position going in. They're arguing for stare decisis. They're arguing 150 years tradition. They're arguing to keep the law the same. And whenever you're trying to argue to change the law, I think that's where the issues come in. And I think particularly Roberts did a very good job, because Roberts obviously is an originalist, and he structured that opinion really as originalism as you agree. He went all the way back to feudalism in English common law. So he really is like, we're going to go back to originalism. They went into legislative history of the amendments and all that stuff. So I get it. But I do think at the end of the day, this just came down to which interpretation you're going to. This is just an interpretation issue, because Thomas's dissent was also based in originalism, but it was just a different wording of originalism. And I do think, I don't know if this beef between the Chief Justice and the conservatives, but he came out really hot with that opinion, with the whole, essentially they're trying to bring back Dred Scott. I'm like, what the hell is going on here? Yeah, I'm like, what the hell's going on here? You know, Dred Scott. And then Thomas had to address the Dred Scott thing right off the bat. He's like, what are you talking about, Dred Scott? So well, let me see. I reading. All right, so reading through the majority opinion, I agree with a couple of things. Number one, stare decisis. You already get your check mark there. Now you got to convince me. I agree with, hey, from the inception of the country, this is where we got this from. It transferred over through English common law, so that's what we have. Even though England doesn't have it anymore, we still have it. But then he says this progressed to Dred Scott. And, you know, Dred Scott, we said this was not the case. And then that was overturned, he said, by statute at first. Then it was overturned by constitutional amendment. Mm-hmm. And during that constitutional amendment, we said, okay, if you're born here, and I think the distinction really comes down to this. Bloodline, whether you're bloodline or whether jurisdiction is the thing that trumps when it comes to birthright citizenship. And what do I mean by that? So Ted Cruz, I think, is a perfect example. He was born in Canada, right? So technically he wasn't
McCain was born in Panama.
Yes, but you would, the Panama zone, you can actually make an argument that that's American soil, because it was the Panama zone but I'm talking about Ted Cruz was born in Canada. So his citizenship wasn't essentially through this birthright mechanism. It was essentially through a congressional act. Congress said, passed a law that says if you're a child of U.S. parents, no matter where you're born on the planet, you are a U.S. citizen.
Right, and even the majority seem to say that. They seem to agree that the 14th Amendment does not, on its own terms, give birthright citizenship to children of U.S. citizens if they're not born in the United States. That seemed to be what I think the majority said too.
Yes. So that's how Ted Cruz got it, and that's how he's a citizen. And I would say if you're two Canadians who have a child here in the United States, those children would still be Canadian citizens, right? Because the majority made the distinction between this citizenship through bloodline. Mm-hmm. But then there's the switch. We've rejected that. Our citizenship is based on soil. And if you're on U.S. soil and you have your baby, that is the determinative factor, not domicile, not anything, just being on U.S. soil. And that makes a difference. And I can just wrap up the majority opinion into that. It's the jurisdiction matters, and jurisdiction is based on where you physically are. And I think Thomas and the conservatives on the other side said, well, hold on. That you're leaving out a big piece of that, which if you're two Mexican citizens have a child, now you have this kind of weird thing where your child is an American citizen, but you're Mexican citizens, you know, but truly your child is a citizen of Mexico, just like you. The child and the parents are citizens of the same place. But the majority seems to reject that and say, no, well, that's not the way we do things. That's not the way we've always been doing things. And we're only going to do things this way. And I think the reasoning was sound. I think the precedent was sound, but I don't really think they convinced me that was really the proper interpretation. what they convinced me is that we've been doing it for so long. If you want to change it, make a constitutional amendment to change it.
Yeah,
I don't know how you feel about it.
Well, I read the precedent as not particularly helpful because I read Wong Kim Ark as speaking to what I just call green card status. That's the way I read it.
Yeah, correct.
Wong Kim Ark, the way I understand it, the parents were here lawfully.
Yes.
Permanently, with intent to permanently remain. Now, they did in fact later go home, but that's neither here nor there. We're gonna presuppose that at the time of the birth, they were here with the permanent intent to remain, even if that changed.
Correct.
So they had lawful permanent status, which is what a green card status is. And it's like, okay, so these are, and we're just giving out green card status to anyone who wants. You want green card status? Great. Show up, you get green card status. You get green card status because you show up. Congratulations. No problem. That's our policy at the time. I can live with that. Fantastic. So I'm like, well, that's the way I read Wong Kim Ark. So for me, distinguishing Wong Kim Ark, it's like, well, it's only speaking to, green card holders. It's like, that's part of our community enough for the purposes of being a natural born citizen. So that doesn't, because green card holder status comes with a lot of, it's like citizenship light, it comes with a lot of benefits, so it's like, okay, fair enough. I can live with that.
But I would even agree with you. Under Thomas's dissent, that green card status would entitle that child to citizenship anyway. Under the dissents, all the dissents would agree that if you have green card status, your children would be American citizens if they're born.
Yeah. So like for me, the precedent isn't that problematic. The precedent doesn't really get me very far. And then they're like, oh, there's no cases about it. I'm like, of course there's no cases about it, because up until like yesterday in legal time, if you want to be a citizen, show up, congratulations, that's fine. And that can be US policy. There's nothing wrong with that. That's fine. So there's no cases deciding who's a citizen, because why would there be? That doesn't make any sense. So the precedent is no help. The history isn't much help. The English common law seems to go in favor of the course interpretation. We just strike out citizen and write in the word citizen. I'm like, okay, cool, that makes sense. Because when we're interpreting things in the Constitution, the common law is always a really freaking good place to start. So what's the common law tradition? And if we're going to change it, fair enough. But, that's the place to start. So I can import all that. That's fine. And it's like, so was the 14th Amendment trying to change that? Or, was U.S. history in some way trying to change that? Did we depart from that by our own customs and practices? Did we treat it differently? And, the majority makes a reasonable case. The answer to that question is no. Especially in early American history, anyone who shows up, anyone who's born here, congratulations, you're a U.S. citizen. Hope it works out. Now, that being the case, it's true that at the time that getting here was hard. So that if you showed up, it showed a lot of
gall,
determination. It wasn't something you could do on a whim. But be that as it may, for better or worse, that's how the Constitution's informed in anything else, right? It's like that's what the understanding was at the time these clauses were written. It was written against that factual background, but the collapse of the factual background itself doesn't change the legal determination. That's a classic rule of legal interpretation. It's just because the factual predicate disappeared doesn't mean the legal rationale changes automatically. The Supreme Court said that about its own decisions. And so it's like, okay, the majority's making some really good points here. And it's like, in the dissent, Alito, for my mind, is all over the place in nowhere land. Gorsuch isn't really adding anything of substance.
No, not really.
To the extent he seems to be musing that illegal immigrants, if they're here long enough, that counts as domicile. That seems to be what his suggestion is.
Yeah, he seemed to be suggesting that.
And then I haven't made it through Thomas's opinion yet, because Thomas is a serious player. He's not my favorite. Half the time I find him off in La La Land. I did a skim to find out if that was true. My skim said, no, this is serious and worthy of consideration, but it's 90-something pages, and I'm not there yet.
Well, I will say this. With Thomas's dissent, he attacks Roberts' rationale point by point. He attacks all of the precedent that Roberts go. He attacks what's it called? Kim Wook or
Wong Kim Ark.
Wong Kim Ark. He attacks that, and it's interesting because he attacks it and his reasoning. So, for instance, he starts with Dred Scott, And he says, well, even in the Dred Scott case, Dred Scott's argument was domicile, that not only was he wasn't a citizen of any other country, so he was essentially stateless. He had been born here in the United States, and he was domiciled here, right? He had no place else to go. And Thomas's argument was essentially that Black slaves under Dred Scott were second-class citizens, because they weren't really citizens of anything. They were essentially second-class citizens. They had none of the privileges of citizenship, but they had all of the responsibilities of citizenship. Like, for instance, being called to fight in a war, pay taxes. So that's what he was meaning by second-class citizens. During that time, they were citizens in all but name only. And obviously with the privileges of citizenship, voting, owning property, whatever. So when he went through the historical context, he pointed out that the liberals are trying to make it seem like the Black African slaves from that time are the same as illegal immigrants. But the distinction is that an illegal immigrant has a sovereign who they're loyal to, which is their home country. They are not stateless. And on top of that, since they are not here legally and have another sovereign, they are under the jurisdiction of their own sovereignty, not just because they got here. So his distinction between African slaves and illegal immigrants, I think was how he was trying to, how he essentially made that argument, and I think in a profound way, because essentially when you read through his dissent, he's almost offended that they're trying to equate this to the African slaves being granted full citizenship through the 13th and 14th Amendment. And it's trying to say, these are people who were fought, died, and could be conscribed to the army. They can be forced to fight for their country versus someone who chooses to come here illegally. So, and I think that distinction does matter, because in that case, he essentially saying that if you already have allegiance to another foreign power, then your children have your same allegiances unless. And I think he rejects the magic soil argument for essentially an argument that says it's part of the process. You have to be born here. You also have to be subject to the jurisdiction thereof. And on top of that, you have to be domiciled here. You have to live here. This has to be your home country. And I think I do think you can make an argument that he's correct in that assumption. And obviously, he also used Plessy v. Ferguson, Harlan's opinion, dissent in Plessy v. Ferguson.
Sure.
And so he went through it, and he's just saying, hey, the majority seem to only cherry pick the parts that support their conclusion. But when you really read it, all of the precedent actually makes this argument that if you're here illegally, or you're from that your children don't get this benefit. So I would ask you, Palestinians who essentially are not recognized by the United States as having,
they are certainly not. There is no such thing.
So if a Palestinian was to come here under Thomas's formulation, Palestinian comes here, they're living here, they have a child, they're not subject to any other foreign, because there's no Palestine.
Well, presumably they'd be subject to Israel, because the United States recognizes Israel. The territory they'd be born in is Israel.
No, but the Gaza Strip, Israel doesn't like before, but right now the Palestinians in, let's say, the Gaza Strip, they're self-governed, so they're not a part of Israel. Israel didn't say that.
Well, I'm not an expert on it. I think Israel still claims sovereignty over it. They just basically give all the administrative aspects, but I still think they consider part of their sovereign territory.
Any stateless person,
okay, stateless I can work with. Sure.
Any stateless person coming to the United States who has a baby, Thomas would say that person's child is a citizen because they have no allegiance to another foreign power.
That's a fair, I hadn't really drawn that conclusion, but you're right. That would be a natural consequence. They wouldn't have any, and presumably they would have intent to stay here. They have no intent to go anywhere else. So
exactly,
that would be a natural consequence. Now, to be fair, there aren't that many stateless people, but you're right. That would be a consequence of it. Yeah.
So I think at the end of the day, I think they had to play the role because essentially it seems like the Chief Justice wanted to make.
I'm surprised the Chief Justice wrote this, to be honest. I didn't know that he wanted that particular hot tamale.
I think he would. if you read through both the dissent and the opinion, he goes after the dissent pretty hard.
I definitely felt that.
He just essentially straightened up calling them like, hey.
I saw that, but at times I felt in a disingenuous way. And for reasons that pass my understanding, I don't really like anyone's read on the court about Wong Kim Ark, because it's like, I think my reading is better than everyone else's reading. They're treating it as a lesson about domicile. They're treating it as a lesson about like this various things. They're trying to distinguish them. Like, I think you guys are just reading it wrong. It's like, yes, it's domicile, but the key was it was domicile with permission. So they were lawful permanent residents.
Mm-hmm.
The lawful permanent residents, though. So it's like, yeah, it's just like, call it a green card. You know, they didn't have that language at the time. So like, sure, that's all it speaks to. But they spent all this time talking about what domicile is and whether it's domicile or not. I'm like, but you don't have to distinguish on those grounds, because domicile also has to be with permission of the government. It's a legal concept like any other. Yeah. And also the government of the United States has under the Constitution the rule to determine uniform rules of naturalization, and they also have control over the border. So for me, like, sovereignty of the border is a huge thing. The government's power at the border is near absolute, up to and including the United States Congress passing a law for some reason saying we don't want people of religion X to come in the United States. I think it's probably valid because of how their power is plenary. You know, and those people aren't protected by the First Amendment. So I'm not even sure First Amendment considerations come in at that point, assuming Congress passes the law. But like, you know, it's like the whole thing is just weird to me, and how they went about deciding it. And the majority felt disingenuous at times, but I felt they were more solid overall, even if they took some shots they didn't have to.
Well, this is because I have my notes for my video. So this is what I came up with. This is me just looking at Chief Justice Roberts. This is what he does. He looks at English common law, as we talked about, and he establishes the right to the soil, right? That's his thing, soil from British common. Then historical context, Dred Scott, which we already talked about. And he said Dred Scott, which had been overturned. He said Dred Scott essentially took the view that Thomas was taking, that it was blood and not soil that determined citizenship. And then the 14th Amendment explicitly overturned Dred Scott, establishing that it's the U.S. soil that grants you citizenship, not your blood relation, because that was what happened with slaves. And then he grounded his decision in originalism, as we talked about, textualism, because remember, he went back to, hey, let's go back to the text of the documents, go back to this. And I
don't think the text is much help either.
Yeah, and then
unfortunately, a lot of the unfortunately from my end, a lot of the interpretive tools I would normally rely on are not of much value. The text doesn't really tell me very much. It doesn't really get me very far. There's not much precedent because there was no issues over it, because everyone's a citizen who wants to be, don't you know? So there's no cases trying to define what it is. The best they've got is the coextensive nature of the Civil Rights Act they're passing at the time, which uses slightly different language.
Yeah,
and that's like, okay, well, but it's not just slightly different. It's like a whole different clause. It's like, okay, is that coextensive? I mean, that's a little bit odd to read two completely different clauses as being the same thing. I mean, I guess you could, but it's a little odd. And that's like, what do we do with this? I don't know.
But it's the big knot. Like on one, it said subject to the jurisdiction thereof, and the other one says not subject to the jurisdiction to any other jurisdiction. So
well, at least one of them wrote that basically one was written in the positive and one was written in the negative. And I'm like, I'm not sure I buy that, but nice try.
Yeah, because the Civil Rights Act would say, as long as you're not subject to any other jurisdiction, Mexico or whatever, and then the 14th Amendment kind of wrote that and say, all right, if you are subject to our jurisdiction. So I think if they left the language the same as from the Civil Rights Act, then I think Thomas's argument makes more sense, because then you could say Mexican citizens are subject to that jurisdiction.
Sure. And, you know, standard rule of construction, you know, different words tend to mean different things.
Yeah.
So your presumption going in is, well, they wrote different words. They probably meant something different. If they meant the same thing, they would just wrote the same thing, and they didn't. And again, it's not like a word slip. It's an entirely different clause. So like, the presumption, it's like they meant something different. I'm like, it's coextensive. They wrote them at the same time. The same Congress wrote both. It's like, yeah, but they gotta have meant something different by it. It's very odd to read them the same. And then, of course, I mock Alito and the conservatives for going to legislative history, because conservatives hate legislative history. And you know what's going to save the day? We're going to quote random senators and floor speeches. I'm like, what the fuck are you talking about? I don't tell me I'm wrong, Nate. Tell the audience I'm wrong. Do conservatives like the floor speeches? Is that really what they appeal to? Is that something they cite a lot? No, not so much.
Hold on. Oh. In your favorite Gorsuch case, that's what the conservatives were saying against Gorsuch. Remember? So and the what's the
Bostock.
Yeah, Bostock, because Gorsuch was like, now this is where the difference between originalism and textualism comes in.
Yeah, but that's why I sided with Gorsuch, because I thought it was better.
But he did, to be fair, Gorsuch is generally an originalist, but he took a very textualist view of that particular opinion, while the other conservatives were like, we're going to take an originalist view. And an originalist view, Kavanaugh and the rest of them said, well, listen, let's look at the quote unquote legislative history. And the legislative history said sex specifically does not include gay, transgender, and all that stuff. And then Gorsuch says, well, let's look at the word sex. And they're making these decisions based on the person's sex. So it just doesn't make sense for them to eliminate it. But then, so he took a very textualist view and overrode that. So that's the conflict here. And I think now he's trying to go back to this. So, well, to answer your question before, I think it's you use the history when it suits you. And I think conservatives have used the history against other conservatives, just as against Bostock.
Well, I mean, in that particular case, they were looking at language that Congress was considering, because Congress had considered, as memory serves, with the Civil Rights Act about the transgender language, they had considered language that would have dealt with transgender issues specifically, and then they decided not to deal with it. Yeah. And so it's like, well, Congress considered this language, but didn't do it. So the question there was, well, what does the failure of that consideration mean? And it's like, and Gorsuch says, well, not much, because what matters is what they wrote in the end, not like various proposals they considered. I mean, it's marginally informative. What matters is what they wrote. I'm like, yeah, that works for me. But
then you'd have to ignore the fact that they specifically said this word does not include these people.
I did. Right? I did ignore it. I was very happy ignoring it.
but that's the originalists can't ignore that. The people.
But they didn't write that. They didn't write that. It was a proposal they considered. They didn't get Congress to pass that.
No, but they rejected it. Like, it's in the legislative history. We're rejecting it because, remember, it was in there and they specifically took it out because they said we don't want it to cover this. And then that's when they passed because they want it only to be men and women, not LGBT. But then Gorsuch said, well, hold on. How do you determine this issue of same-sex marriage, right? Does sex have any role in it? If this was a man, it would be okay. But since it's a woman, it's not okay. And what's the determinative factor? Their sex. So if that's the determinative factor, I don't care what they thought about it. You can't do this based on sex, so it's good. So I agree with you 100%. But I do want to make the point that they did, Kavanaugh and Thomas and Alito went right to legislative history and started reading through all the arguments and saying, hey, they specifically said no to this, which is a fair argument, I think is a fair argument for an originalist to make. And I think they're trying to make the same argument now.
I think there is a distinction to be made between language that was officially floated and, considered and rejected versus random floor speeches. Because in random floor speeches, you got Senator whatever saying, well, here's what I think, this clause means or whatever. But having language that was actively considered and voted on, even if it's voted against, right? That's some kind of expression of Congress as a whole, as opposed to just whatever one random guy had to say. Congress, or at least the House, as the case, or Senate, as the case may be, is making a determination by voting on something. That might imply something, but it's more of a sense of Congress as a whole, at least, or the House as a whole, versus some random floor speech. So there is a distinction for whatever value it has to be made.
Yeah, I agree. I definitely agree with that. I just think, number one, I predicted this was going to go down this way.
Everyone did.
But and this was really, even though like in my video I said it's a 5-4 decision, but it's really 6-3 because Kavanaugh, he agreed with the judgment, so it's a 6-3 decision. But he disagreed with the constitutional analysis. He just thought that in other words, he's like. He was going back to judicial. In other words, we don't get to the constitutional question if it violates the statute.
Sure.
So he said it violates the statute. So why are we even looking at the constitutional question? Because we don't even need to get there, right? It violates the statute, fix the statute, then we can come take this up again. So
I was surprised they decided the merits, man. I was like, yeah, they're going to just do a per cur or a dig or something.
But he gave them an out to pass the buck, though. He gave them an out, right? We can just decide this on the statute and then throw it to Congress, and then they can't do anything about it. They had the out. They had the out, right? Hey, this is the statute problem. And we won't even look at the constitutional question. But I think you had Comey Barrett and you had the Chief Justice, and they said, well, we can answer the constitutional question. Why kick the can down the road? And they did.
That's not something the Supreme Court says, though. That's the opposite of what the Supreme Court says. We can decide it. Why don't we? No, it's like, we can. Why? Yeah, let's kick it down the road. It's their favorite thing in the world.
Most of the time, they do kick it down the road.
They don't decide things. What the hell are you talking about?
But this time, it seems like they were like, well, we got 5 votes. Let's just make it happen. And he just
you think there's anything special in the timing in particular? Because that July 4th weekend's coming up. Are we doing a little American Eagle bullshit for 250? Is that what we're doing over here or whatever?
Well, I think the liberals are going to be so happy at this.
Yeah, they're going to be completely happy.
Oh, and your unitary executive theory. It's funny. It got bumped up and then it got knocked down. I was like, what the hell's going on? And what is this? It was like, yeah, unitary executive theory is now
unitary executive theory except banks. I'm like, okay.
No, well, I actually agreed with both the decisions. For the FTC commissioners gets all its authority from the executive, from Trump. Right, FBI director, all those positions, Federal Trade Commission, all those places, their authority to act comes through the executive branch, and Trump is the executive. So yes, he should be able to hire and fire those people without cause. I agree with that. I do think the precedent was too broad in limiting and letting Congress limit that power.
Well, Humphrey's executor's been really dead letter for quite a long time.
Even though
they finally put a bullet in its head a long time ago.
But you didn't agree with Humphreys, though. You've never agreed with Humphreys. No,
of course not.
Executive thing, yeah. So
of course not. Of course I don't agree with that. What are you talking about? Of course I don't.
That's what I said. You've never agreed with Humphreys.
Of course I don't. The one that caught me a bit by surprise was the decision in the GPS case with the GPS records from Google.
That I agree with too. I agree with that case.
I didn't disagree with it. It just caught me by surprise. I guess it does follow on from Carpenter, but I thought third party doctrine would rule the day, and so I was wrong.
Well, you can think about it 2 ways too. For instance, renters or hotel guests. They don't own the property. They're just there for a certain amount of time. But even if you're going to go search somebody, so you need a warrant because for that particular time.
Right.
So just the third party. You sometimes you can't, you have to. So I understand where they're going. And on top of the fishing expedition, I like what the Supreme Court did in terms
they didn't actually rule on the underlying search. They kicked it back to the Fourth Circuit with no guidance as to what to do.
Yes,
and I even said in my stream, I'm like, if I'm the Fourth Circuit, just fuck my life, because I know what no matter what answer I am, I'm just wrong. So I guess I'm going to make a decision. I know I'm wrong. It's fine. Whatever. It's good.
But I think you have to look at, we have to break down the components of that particular. Number one, there were essentially 3 searches that we're talking about. There was the one search of give me all the phones in the area of this bank, right? So they came up with a number. Then it was like, okay, give me these particular phones because of whatever information they had. So then Google and then they got down to 3 people and they said unmask these 3 based on new information, and then they found the one guy. So the Supreme Court to me is saying, okay, and which one of those they essentially said those are searches, but each search may need a different level. Like at the first search, maybe just a reasonable suspicion search, in terms of in other words, like a stop, question, and frisk. We have a crime that was committed. We believe we have enough evidence. Now we just reasonable suspicion, cast a big net. Then the next one, you may need probable cause. Okay, well, these individuals, we know a crime has been committed, and we believe one of these 3 people have committed the crime. So it's saying when does the court have a role, or when does probable cause has a role to get further into a search? Because they're saying it's a search, but they're saying at what points and how far can the government go at each level of the search? And I think the initial search is reasonable suspicion, but I think when you get down to 3 people, that privacy concern gives you now your Fourth Amendment protection. Okay, now we need a search warrant because now you're trying to limit to individuals. These 3 individuals, you need probable cause. That's kind of the way I read it. But I'm
Yeah,
assuming when it goes to law court, they're going to be like, what the hell?
Yeah, no, I just know I'm going to be doomed. I mean, it seemed to me to be reasonable. Like, obviously, there's bank robbery. That's the impetus. It all seemed pretty reasonable. Give me a half hour before, half hour after, 150 meters, which is a football field and a half in every direction. Seems reasonably contained as the space and time. I want everyone who happens to be there. And also, I have a specific reason because I saw him on a cell phone. So that's, a specific reason. And then based on the initial list, I used some detective work to filter it down and came up with some names. And even at that point, of course, I didn't think I had probable cause. That was just a lead. And then I followed up on those leads because I had 3 names. And obviously I didn't prosecute everyone, right?
Yeah.
So I had 3 names. Those are leads. And then I did some further detective work to find out who the bad guy was. I mean, it all sounds reasonable to me, but what do I know?
But at which point do you need a warrant? So first search. All right, give me the first blah, blah, blah. Do you believe, I would say you don't need a warrant. I would say I would handle that as a unreasonable suspicion, a pat down, for instance. You have a crime has been committed and you're just trying to do an investigatory search. So I'm saying that would be good. But I'm saying when you start narrowing it down, that's where I think they're saying more protections are needed because they've admitted it's a Fourth Amendment search. But at what standard and at what place does the standard intentionally grow? And I do think when you get down to 3 people, now you're probably looking at probable cause because now you're really doing a search. You do because they unmask the person at that last level.
Sure.
Like, these are 3 anonymous people who happen to be in this area. Blah 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 blah. Now you're unmasking. Now you're going after them, and I think you need probable cause to make that search happen.
Yeah, I just found it interesting that they said like there's a privacy interest in it, and I'm not necessarily opposed to it, but like, how do you get there from originalist principles, which I suppose you didn't have to because Kagan wrote it. So like the fact that you have this evolving idea about what is.
Wouldn't it be cats? That's a cat. It's telephone.
Yeah, I mean, cats isn't the worst idea about the telephone booth. Yeah.
It's a cat's argument. It's hey, third party, I'm thinking over a third party. I'm giving it now. You have an expectation of privacy under the Fourth Amendment to have a fourth. So that's essentially a cat's argument they made.
Yeah, I suppose
Does that make sense?
No, I get it. It's just for me, it felt like a very revolutionary step because I mean, it felt very consequential to me. In terms of its scope, it's just like, well, between that and Carpenter, it's taking records that are in possession of third party and saying there's a privacy interest in it. And I was like, I was genuinely surprised. I thought it would have gone the other way. But
no, isn't but that's literally that's cats. That's everything, right? The phone call, right? The wiretap. That's all. that's.
I think it's a distinction worth making. I mean, in the case of the wiretap and in the case of cats, it's like you're exposed in the public. But in the case of these cases, you're talking about records that are created or maintained by someone else. Like, because in Carpenter, you're talking about cell phone records, which the person themselves that's subject to the search didn't create. Mm-hmm. They didn't actually create the records. They might be about the records, but they didn't create them. And then in the case of the case that just came down, you're talking about GPS records that, again, are based on their movements, but they didn't create the records. The third party created them based on data provided by the user, but they created them, stored them on their own server and stuff like that. So the participation of the user is at least distinguishable from like cats, because you're not just like, well, I'm directly involved in this phone call and I'm just using a wire as a medium. It's like, no, this is a little bit more, I'm not searching your records. I'm searching someone else's records.
You're making a metadata argument, right? So you're saying the metadata, right? The phone call. You're not talking about the actual contents of the call. You're talking about the time, place, and the thing that was used at the particular time. So that's the metadata.
In the case of those records, sure.
Yeah. So I would agree with that because you're not creating that record. Your call is the part that generally cats would apply to. Cats would apply to the contents of the call, not the actual metadata. But the metadata has been protected before in other cases. Metadata has been protected before in other cases. That's the Patriot Act, for instance. Metadata, blah, blah, blah. So I don't know. I think the protection.
It felt important to me. It felt revolutionary to me because my view, third party doctrine has obviously been questionable for a lot. But like the problem with the Fourth Amendment and things like this is the Supreme Court has been in search for a cohesive doctrine when it comes to third party doctrine, Fourth Amendment. Do you remember when they used to be flirting with the idea of the mosaic?
Yeah.
Remember old school with the mosaic? Yeah, old school shit, right?
School, yeah,
so they've been flirting with these ideas and trying to deal with this stuff for a long time. Do you remember when they used to do with like the essential third party participant doctrine? Like, oh, this person was essential, so the fact that he's there is irrelevant. Yeah. I'm talking some old school Fourth Amendment law. Long story being short, like they've been flirting with these ideas for 40 years, 50 years, and still like floating in the dark. But like third party doctrine had overtaken. And it's like, oh, it's a third party involved. It's not my record. Yeah, it's not my document. It's Google. It's Google's record. I didn't go to your house. I went to Google's house. Who the hell are you? And suddenly I have interest in Google's documents that Google's created at Google's house. It's like, what the hell, man? That's revolutionary.
Let me explain this to the audience. So for those of you in the audience, what we're talking about when we talk about third party doctrine, let's say you're a criminal. You come to my house and you've left something here, like your gun that you used to blah, blah, blah. The cops come into my house and they illegally search my house. You left your ill-gotten gains. They illegally search my house, grab the stuff, and prosecute you for stuff they illegally took from me, right?
I'm screwed.
The Supreme Court would say, the Supreme Court in the third party doctrine said, well, hey, it's great and all that. It's messed up that they illegally searched Nate's house. But you don't have any constitutional protection against the stuff in Nate's house. Nate does, so they couldn't use that against Nate, but we can use it against you. So that's what Kurt is saying. Kurt is saying, well, generally you don't have any protection if these right? Am I?
You got it, man.
Explaining it right?
Yeah, you got it. Third party doctrine, right? It's Google. It's Google's records created by Google for Google on Google servers that I searched Google's house. It's like what is my privacy interest in this? And the court said, apparently I have one, and I find that to be revolutionary.
Because they're saying that is essentially a phone call. they're saying this is a phone call. And the fact that you initiated a phone call gives you that privacy interest. That's what they're saying. You initiated the phone call.
Well, they're not even saying that much because they're saying it's a search.
Yes.
Which may or may not implicate my rights, and Fourth Circuit go figure it out. And I'm like, I don't know what the rule is, because we both know that there's a line somewhere.
Yeah.
But neither one of us can figure it out, right? And we both know that. So it's like, okay, I'm the police. There was a robbery. I want to search geo records within 10 miles for 8 days, right? Versus like this versus, I want to search it for a space of 5 minutes. Within a span of five meters. And what's interesting is, depending on exactly the facts of that, I don't even necessarily know that would necessarily be per se reasonable. I'm sure I could conjure a fact pattern if you gave me enough time to think about it, where even the government searching for 5 meters worth of 5 minutes would somehow be unreasonable. I'm sure I could do it with a little bit of work. So like, what are the rules? And it's like, you don't know what the rules are. So we're left in a world of confusion, which is fun for all the lawyers in Fourth Amendment land for a while.
Yeah. You seem to, because I watched your video the other day, you seem not to agree with the Federal Reserve firing.
No, I had problems with it because, like, let's just start with basic principles, right? I mean, which branch of government is the Federal Reserve in? It's got to be executive, right?
No, it's none now.
That can't be none. It can't be none of the above.
Because it's not a government agency. Federal Reserve is not a government agency.
Well, then I have problems with delegation doctrine because we both know from case law that Congress cannot delegate federal power to a private entity. Can't do it.
But can't do it. The Federal Reserve is not a federal agency, nor it's essentially like a collective. It's owned by the banks, have an interest in it.
Well,
the federal government,
if
it's a cooperative.
If that's true, then I'm bringing down all that fire of case law. Congress cannot imbue legislative nor executive power into a private agency. So classic hypothetical. Okay. Classic hypothetical. Congress, for some reason, is really concerned about the treatment of dogs. There's lots of dogs that move in interstate commerce. No problem there, right? So we want to help dogs. Now, Congress wants to deal with this. Now, Congress doesn't really want to have an administrative agency, so we're going to designate. What's your favorite private entity of choice in this sentence? PETA. We're gonna have PETA. We're gonna have PETA be the ones that's going to do it for us. They're going to be the ones that determine, how dogs are treated and what kinds of dogs, different breeds, and all the things, because they're the experts, don't you know? So Congress creates a law that gives power to PETA to determine the rules as it relates to fair treatment of dogs in interstate commerce. Is this legal? Fuck no. Because Congress cannot imbue executive power into a private entity. So if the Federal Reserve is a private entity, I've got delegation problems at the ass.
Well, I think what it's essentially saying, with the difference between the FTC and the Federal Reserve,
This should be good.
Is the Federal Reserve, for me, is a public-private structure. Like, for instance, a lot of times you'll have this in local governments. Well, you'll have, like in New York, for the Rent Guidelines Board, you'll have private landlords on it. You'll have this, and then the mayor will pick 5 people to sit on the board. But the board itself is a government, it's a hybrid of both. It's a hybrid of the government. So I don't think the Federal Reserve is a executive. If it was totally under the executive, I'm with you. Unitary executive theory, I'm like you, Scalia, I'm with it. But because it's specifically not that, in the law, it's specifically not that. And the president, even though he appoints them, specifically, it's independent. Specifically, it's not a government agency. It's as federal as what's it called? Federal. What's the people who deliver the mail? Federal Express. Federal Reserve is as federal as Federal Express. Not the post office. Federal Express.
Federal Express is just a full-on private agency. What are you talking about?
Yeah, but I'm saying in terms of it's actually not a federal government.
Yeah, but the federal government doesn't imbue FedEx with any federal regulatory authority or the ability to pass rules. FedEx doesn't have any governmental power. They just deliver packages.
No, what I was saying, they're as federal in terms of being, like the name Federal Reserve, I think people believe that it's a government entity fully, but it's not. It has that 50-50 split. And I think that's the part, because the banks own part of the Federal Reserve. We own most of the money we owe is to the Federal Reserve. The Federal Reserve is, there are private entities that own. There's no private entity that owns the FTC. There's no private entity that owns part of the FBI. It's all owned by the government. And I think
because they have to be. So if you're talking about a semi-public agency, it has private components that passes rules that have the force of law and administrative effect, then I'm saying that that's illegal.
And I'm agreeing with you. But that should have been bought in this particular case, but that wasn't.
So let's you and me together sue this Federal Reserve as an unconstitutional delegation of power.
I don't know if that's going to be.
Let's take on the Federal Reserve, you and me together.
Who's always making that argument? Who was the guy? The Rand Paul. Rand Paul makes the argument that the Federal Reserve is illegal and unlawful. And
Nate, you and I are the best lawyers ever, don't you know? And I'm sure we're going to be able to crack this case wide open, man. It's kind of great.
The Fed is not going anywhere. But if that's the
case, we're
case,
just taking on an entity that can literally create money out of thin air. What's the problem?
Yes, but I think the issue here with the president is that FTC, I control it. I should be able to do it. The Fed chair, I don't really control it, but by constitutionally, I can appoint the people who go there, but I can only remove them with cause because of the nature of the entity. So I understand the distinction. I think the distinction makes sense, but I know nobody's going to be happy with it. I think it's a win because he does have an expanded power. Essentially, what they said is we're going to give you unitary executive over all agencies that derive their authority to operate through you, and ones that do not derive their authority to operate through the executive, we're going to keep this the with clause situation. So I'm thinking that's probably, and I assume this will work for the post office too.
The post office is fully public.
Oh, so it wouldn't work for the post office. It would only work for those quasi-public ones where you have public and private ownership of the same company.
It's the Illuminati, isn't it? That's just the part they were afraid to say out loud. is literally the Illuminati. I mean, the decision literally comes down to because Federal Reserve, because of our history and tradition and the independence and such that predates the Constitution. That basically the concept of bank independence. Basically, what it comes down to is that the concept of bank independence is so deeply rooted in the history of power that when the Constitution wrote Article 2, Section 1, there's an implied asterisk, but banking, though. That's basically what it could. That's the way I read it. It's the way I read it. I'm putting on my tinfoil hat and talking about the Illuminati, man.
It is, but let's be totally honest. It is different. It has been different. Most people don't know.
They got to you too.
But most people don't know that the major banks own part of the Federal Reserve. The United States government owns part of it. The private banks own part. So most people don't know this. Most people are ignorant to the fact. They think it's a federal agency, but it's not. It has these different components to it. So I would say let's challenge the delegation doctrine, but I don't think it's going anywhere. I don't think it's going anywhere. What about?
You think I might have a problem convincing the U.S. Supreme Court that everything the Federal Reserve has ever done is basically unconstitutional since the beginning of ever?
Yeah.
You think that might be a tough sell?
I think that'd be a tough sell.
Yeah,
I think so. One of the cases where some people are going crazy over, but I thought it was an easy win, was the West Virginia case with the
mail-in ballots.
Yeah, Little versus Helcock or Heacock.
You gotta love the guy's name's Heacock. I mean, that's just you gotta love
Cox.
that the guy, his name is Heacock, as a transgender person. I'm like, you've got who's shitting me at the Supreme Court? Am I being punked? It's like the guy's name is Heacock, really?
Little versus Heacock. Little v Heacock. So
yeah, well, apparently these twin cases stand for the bombshell proposition that there's such a thing as men and women. It's biologically based, and there might be differences between them. I don't know if you're aware of that, but apparently.
Well, so number one, I totally agree with the decision. It just
I do too, 100%.
It's obvious.
100%.
I'm surprised this was 6-3, but I do.
I'm not. Apparently, whoever read it from the dissent went on for an hour and a day. So I'm looking forward to reviewing the oral announcement of their pain as they maximum cure in this.
And it seems like Justice Jackson really doesn't understand what a woman is. But yeah,
she said so as much. She still can't figure it out. She still can't figure it. She said so in her opinion. I'm like, holy shit, dude! It's not just a meme. Did you read that? She's like, even the petitioners, the people who are trying to overturn this ban, the students who are like transgender, even they are saying biological sex is a thing, and we're not confronting that. And she's like, I still can't figure it out. What the
I don't. I think she's just jumped the shark with this one. But I will say this though, it was easy to me. It was obvious, but and as a technical matter, for those of you who don't know, when it comes to Supreme Court and they're dealing with issues of discrimination, there's what's known as the tiers of scrutiny, and there are 3 tiers. There's rational basis, there's intermediate scrutiny, and there's strict scrutiny. And when it comes to gender, it's generally decided under intermediate scrutiny. That's the second level. So, and it's pretty high. The famous case is VMI, which is the thing that presented this intermediate scrutiny. Now, intermediate scrutiny means that the government has to have an important governmental interest if they're going to pass something that distinguishes based on sex. Some of the clearest examples are selective service for men, right? That's been challenged in the court, but the important government interest was that men are stronger, faster, and are traditionally at war and blah, blah, blah.
That's hate speech.
But that's the reason why men have to register for selective service and women do not, and so forth and so forth. So when it comes down to this, Title IX was passed, but it had to be passed. When it was passed, it had to also overcome intermediate scrutiny. And the intermediate, the reason why I was saying that there was a physical disadvantage between men and women. And I think one of the key principles that people misunderstand about Title IX is that they believe that it separates men and women, but it does not. Title IX speaks to a protected class and essentially a protected class and everyone else. So that's why, let's say, for instance, in the NCAA, if you sometimes see women kickers in male football, right? There'll be a woman on the male football team or a woman joins, but you'll never see a male on the women's team. And the reason for that is that the protected class are women, and that's because they have this biological disadvantage. But any woman could play on the men's team, but no man could play on the women's team. So that's the protected class. And that protected class was so you can have women who go into sport. And it was all based on biology. But in this particular case—
And it works. because
it worked. Yeah,
Title IX caused women participation to go up by what, 800% or something like that?
Yes.
Yeah,
it
so it worked.
was fantastic. But and then also women, like for instance, women don't like to play football, so you don't see a lot of women's football teams, even though Title IX demands it. But if you just people they don't want to play it, then it's fine. One thing though, in this particular case, which I thought may have some gray area to it, is that this person had transitioned before puberty. So
Supreme Court isn't having any of that bullshit.
So they took away the argument of physicality, right? Hey, this is not about physicality. This person has been taking estrogen since they were like 5 or something like that.
It's about physicality as the category. That's the thing, right? We're thinking about categorical, because in intermediate scrutiny, it doesn't have to be perfect. It doesn't have to be least restrictive, right? Yeah. It just has to be tailored. Doesn't have to be the least restrictive tailoring. So for those of you unfamiliar, if we're talking about freedom of speech, government wants to pass a regulation that goes to content. Government doesn't want you to say a particular thing or a particular view, right? In order to uphold that, it needs to be a compelling governmental interest, and it needs to be the least restrictive means. So the interest has to be way up here, and the way that's restricted has to be as tight as it possibly can. It couldn't possibly be any tighter, right? It's as tight as it can because we value free speech so much. When it comes to sex-based regulation, it doesn't require that much. We only require it to be an important governmental interest, so it's in the middle. Mm-hmm. And it only needs to be tailored. It needs to be designed around it, but it doesn't need to be maximally, right? It doesn't need to be perfect. It allows it to be a little bit looser. So, for example, this person says, well, I'm not the typical male. I didn't have puberty. I took the hormones, whatever that is. It's like, so how's the Supreme Court deal with that? Supreme Court basically says, look, the tailoring doesn't have to be perfect. We have a rule that says men are this way and women are this way. You might be an exception in some sense to the rule, but that's okay because it doesn't have to be perfect. The fact that the fact that you're testing the boundaries of this is not going to defeat it, because we're allowed to treat the category with a slightly looser gloss that allows for exceptions. So presupposing it's true that you transition before puberty, or even in some sort of case, there is a male who had no external intervention whatsoever. For whatever combination of natural reasons, he doesn't produce testosterone, he doesn't go through puberty, whatever, combination of factors. It's like, but you're still a male. So we get to treat you in a categorical way, because we're not coming after you individually. We're saying that you belong to this group. The group is like this. So we're treating you in that way, and it doesn't have to be perfect. So that's what they said. And I'm like, yeah, I'm down for that.
I would even be more specific in saying you're not part of the protected class, because that's kind of the way they speak about the class of women in this is a protected class, and you're not part of that protected class because you're a man.
Sure, but the reason that we're allowed to have the distinction,
correct, yes,
is because we can treat men categorically and women categorically,
correct,
distinct. And yes. I'd quibble by saying that men are also a protected class in whatever context there is. It's just that we're allowed to treat if we had some rule that discriminated against men in some way, we'd be asking the same question. So it's not that men aren't a protected class. It's just that in this particular context, maybe women are getting the benefit of it, maybe not. But either way, it's like we're allowed to treat it as men categorically versus women categorically without special attention to you.
No, I would say this in terms of Title IX, the protected class is women, and there's an open category because men in Title IX formation aren't protected at all. Like women and men can compete together with no problem. It's just when you have to have a particular category for women alone because of the biological nature of it. So you see that all the time where women can compete with men, but men can't compete with women. And so that's what I mean by protected. So in this particular instance, men, like in other instances, like you're saying, I definitely agree, would be a protected class. But in this instance,
you might be right.
The open category.
Yeah, maybe they are, maybe they're not. I'm not sure it's worth actually arguing over. But either way,
it's not. I'm just saying. But that's the way I've always thought about it. But I would say this though, there's not really any ruling that I really, except for the birthright citizenship, I could have saw that going either way. But
I haven't rendered an opinion yet. I need more time and I need to look at things. It's a deeply complicated case. I didn't really have firm opinions in the first place. I read some law review articles which they cited, which I thought made some pretty good arguments, to be honest. But I need to like relook at it, reconsider it. So it's deeply consequential, and I don't know yet.
But how is it? The funny thing is that we've been doing this for what, since the 14th Amendment was back. Like people are making it seem like the world has changed. I'm like, it didn't change. It actually stayed exactly how it was yesterday. Nothing has actually changed.
It's all because of Biden. It's all because of Biden opening the borders. What changed was Biden deciding to open the borders and let everyone in the door. That was the problem.
I'm talking about for the but I'm just saying, it's just like nothing really changed in terms of the way it's been enacted. But interestingly enough, I found it very fascinating that because I was doing research on this. So let's say, for instance, Puerto Rico and Guam, for instance, and the Northern Mariana Islands. So if someone's born there, they're citizens through birthright, and you have a lot of people, tourists, going to those places, having children, but they are actually statutory. They're citizens through statute, not through the so under the 14th Amendment, you're a citizen of the state you reside and of the country.
Sure.
If you're born on U.S. soil.
Or naturalized.
Right?
Which they seem confused by for some reason. It's like, why would they mention naturalized? I'm like, because they want to be treated the same? I don't understand the problem.
Yes. But if you were but in like Puerto Rico, which was a colony, if you were born on Puerto Rico, you weren't a U.S. citizen. And there's still one place that occurs in. And that's
Northern.
Not Northern.
Samoa. American Samoa.
Yeah, American Samoa. So in American Samoa, that's U.S. soil, but it's not a state. And since it's not a state, Congress would have to pass what's called an Organic Act, like they've passed for Puerto Rico, Guam, and all these other territories. And that Organic Act would say anyone born there would be U.S. citizens. But in Samoa, in American Samoa, they never passed that Organic Act. So they're what's known as U.S. nationals. They're actually not citizens. And the most of them actually go into the army to get their citizenship. And they'll come here to the United States and would have to go through the citizenship process just like anybody. But they have American passports. And those American passports say U.S. national. So it's a little quirk in the law where you have people born in the United States on U.S. soil who are actually not citizens. So it's one of those interesting little quirks in the law. But Congress hopefully one day will give them citizenship. But the only reason why they don't have, because they say that there's like most of the majority of the population, they say they don't want to be U.S. citizens because it would conflict with their
I
thing.
seem to vaguely recall it has something to do with like women, and it would require them to like treat them in a way that they don't want to treat because they have a very male-dominated culture. I seem to remember it related to a sex-based thing with like traditional, like hardcore patriarchal male culture. It's what I vaguely seem to recall. Maybe I'm off about that, but I don't know.
Yeah, maybe you're right, but I know there's an issue with whether they want to become, because But again, like so, it's a fascinating thing the way they've tried to work it out. And there's like this weird island in the middle of the Pacific.
Yeah, I always forget its name. It doesn't have any population.
Paya, something like that. Or
Paya Atoll, is it?
Yeah, Paya Atoll.
Yeah, it doesn't have any people on it. It's got research staff. And for some reason that passes understanding, it's fully incorporated. So anyone born there is a U.S. citizen, even though no one lives there.
It's not even on the state, which is another crazy piece to it too.
Yeah.
But it was a part of Hawaii.
Yeah.
And then they separated it from Hawaii because we don't want you guys to have this one random island in the middle of the Pacific. And they separated it from Hawaii. But now it's
so if you can make it there, and have a kid, I guess you're good to go.
There was a murder on the Palmyra.
I did not know that.
There was a murder there. Ooh. And the feds had to go because people have boats and they went there. So there was a murder and they killed like all the people from this boat. So the feds went there and had to investigate this murder on Palmyra Atoll, from these people. So there's a if you search it up, there's a
fun, exciting
case. Yeah. But it's one of those quirks where if you can go to this desolate island in the middle of the Pacific and take a video of you having
there's always no man's land of Yellowstone where we can just kill people for free, right?
That's true. It's crazy. So which was your most surprising decision of this?
Well, I guess the Fourth Amendment decision caught me off balance. because I just thought that, third party doctrine. So I was surprised at the continued erosion of that case. So that probably cost me the most attention. And just that they're taking the Second Amendment seriously at all surprises me. I wasn't decided by the decision. And apparently they just decided to take cert on an AR-15 case.
Oh, that's
today. So I'm wow. Okay. So apparently we've decided the Second Amendment exists and we should have some cases about it. I'm like, okay, that's nice.
The disfavored right. I never asked you, what did you think about what was the other case? Let me see. There was another case I wanted to ask you about. Mail-in ballots, the mail-in ballot
case.
I
thought it was a nothing burger in the end. I told my people.
I predicted it was going to be, that way.
I thought it was just kind of it's such a small issue and people hear mail-in ballots and they go to everything that can mean, right? It could, that's the problem in the Republican zeitgeist, right? They hear this case, it's about mail-in ballots. So what they're thinking is this deals with issues like you don't need a signature requirement, or you can use a drop box, or you can use whatever, or ballot harvesting, big one for the things. I'm like, so I did the decision. I'm like, guys, it's really not that big a deal. It's what the case stands for is a very narrow proposition. It presupposes the envelope is postmarked, whether that's going through the postal mail or through FedEx or USPS or something. So it has a date on the envelope that can be tracked. It has been postmarked by Election Day. Okay. It arrives some point past Election Day. Can they count it? And the Supreme Court says, yes, as long as state law allows for it, there's nothing in federal law that prohibits it. In this case, 5 days. One of the justices was like, what about 50? And I'm like, what about 50? As long as they meet their requirements for the Electoral College, then, as long as state law governs. So there's no problem there. But I'm like, this is just dealing with this very narrow issue of it's been postmarked by the date. So we know the voter casted by that date and it was received at some point, but we know it was cast. So is that a valid vote? I'm like, yes. So do we need signature requirements as far as the federal law goes? I don't know. Is ballot harvesting okay? I don't know. Are drop boxes okay? I don't know. So I was telling people on my channel, it's you need to calm down. It's not that big a deal. If the world has not come to an end, the world will come tomorrow. I was actually surprised. I thought the case would have gone away the other way because of history reasons. During oral arguments, they spent some time talking about the states, and in the briefs talked about how the states made some really exceptional efforts to try to make sure state ballots would be received by Election Day, including during times of war, right? So they took being received by Election Day. It's really, really serious. And I thought that might cover it today. So predicted that one wrong too, not doing well for my cred.
To be honest, that was one I just nailed easily. And the reason why I nailed it, the fucking mailbox rule. Let's just not pretend there's.
Oh, you want to go old school contracts? Okay,
but
cool.
that's essentially the mailbox rule.
Sure.
When you postmark it and put it in mailboxes, good.
I respect that. Okay, fair enough.
So as soon as it took me right back to the mailbox rule. That's exactly what this is. You have a date, and as long as it gets there, as long as it's postmarked before that date, and you put it in a mailbox, it's good to go. It can be counted. Now, obviously, the restriction, how far along with the restrictions. So, but I would have rejected anything after Election Day, like the 6th or something like that. Then yeah, I think you run afoul of the law. But if you're talking about the mailbox rule, then I don't see how you could go the other way. I understand some of them were saying it's confusing, all this, and made these arguments, but I thought those arguments were dumb. I think the simple fact of the matter is we do this all the time for a whole bunch of stuff. For taxes, for instance, for everything with the government, you have to have it postmarked day of, right? If your check is in the mail to pay your taxes on April 15th and it's postmarked that day, no matter if they receive it 2 weeks later, your taxes were paid on the 15th. So it would have been one thing the government did. That was the only thing the government would have done where you had to be received by that day other than postmark, because we understand the mail is slow. Now, maybe they could change that. Congress can go and change that and say, hey, we're going to do it now.
Oh, absolutely. Now, they did give a little minor caveat. They're we're not sure quite how far Congress can go, but I think that was neither here nor there. Yeah, if Congress passes law, it has to be received by Election Day, that's got to be valid.
Yeah. So
yeah.
But still, it's there's all this history of this particular thing, and the government does it in all these other circumstances. I was it would be unusual for them to now go say, well, no, it has to be on Election Day. It was all right, so it has to be on tax day. It has to you got to pay your taxes by tax day. That's not that's just not the way it works. So and I understand people equate the mail-in ballots to all this stuff, but I just
it was a very minor issue, and I think the gnashing of teeth on the other side, on our side, is a little overblown. The gnashing of teeth on the citizenship issue is more interesting, but I haven't figured it out yet because it's complicated.
I think there's a better argument for the citizenship thing, but like I said to my audience, I said I think when it comes down to it, you kind of have two good arguments on both sides, and what's going to carry the day is stare decisis. Are we going to continue to do what we've been doing, or are we going to change things? Because if changing things, I think would bring a lot more confusion. Because what about the people who they've actually done this in one country, the Dominican Republic. So they had birthright citizenship. And Haitians would go across to the Dominican Republic, have their children, and then run back to Haiti. And so you had all these Dominicans, all these people who had birthright citizenship in Haiti who were actually Dominican citizens. So the Dominican Supreme Court went and said, hey, guess what? All this birthright citizenship is cuckoo, and we're removing it. But they made it retroactive.
But they did. That's hardcore.
So all of the people who had birthright citizenship for like the past 100 years,
that's hardcore,
were instantly stateless.
Well, that's hardcore, man.
So they were all stateless because they weren't Haitian citizens; they were Dominican citizens. So that was hardcore. But I don't think the U.S. would have done that because you have some contractual rights and things of that nature. I don't think they could have done that for. But that's what that's the most extreme they could do. But yeah, I thought birthright citizenship. It was going to be hard to get that overturned. I think, but I do think Thomas would make a good argument, and I do think the Chief Justice. It was just beautiful to watch him really go after Dred Scott, Plessy versus Ferguson, and one of the worst cases ever decided by this court. They seem like they want to bring this thing back up. The Black Supreme Court Justice wants Dred Scott back. I was like, oh my God, this is great. What shade? By the Chief Justice. I just don't know. But I would also, too, interesting bedfellows, right? Chief Justice and Amy Coney Barrett. All the females voted one way with the Chief Justice, and all the guys voted the other way. So that also seems to be an interesting little play here. So is Amy Coney Barrett, is she a traitor to you?
No, not really. I mean, the case, again, was such a marginal consequence. I don't really feel like I have a good sense of her yet, to be honest, as a justice. So I don't really have a strong opinion about her one way or another. But that particular case didn't do very much for me. So, yeah.
Oh, but you're number one guy. You're a Gorsuch fan.
I love Gorsuch. Yeah.
Yeah.
Well, she had said more in the citizenship case. He didn't say very much, so there wasn't really anything there. And to the extent he did say something, it was like leaving open the door for illegal immigration. So I was like, not quite sure what we're doing here. So.
Yeah. Well, but I think right now, the dynamics of the court, I think what do they call it? The progressive wing, the ones who the more activists, I think, are the liberals. The Sonia Mayors, the three liberals are very, very more activists than the judges. And I think the conservative justices break down to originalist and textualist. And I think Kavanaugh, he strikes me as this originalist textualist. Like he's like with that 50-50. He can be originalist, textualist. I think Gorsuch is really just a textualist. Even in this last opinion, he seems to be really hammering on the textualism piece of it. And Thomas, Alito, and the Chief Justice are strict originalists. And it's just fascinating to see two originalists use the originalist interpretation of the Constitution and war it out with each other, right? My originalism is better than your originalism. It's fascinating to see how they can both be interpreting it using the same standards, but come out to vastly different conclusions based on the same playbook. So somebody put here, they like Thomas. I like Thomas sometimes. I don't like him. I think sometimes he can be silly. Like his state religion, like he believes that you can have.
Yeah, no, like half the time, Thomas is not my favorite. Like half the time he writes decisions that I'm like, I don't think that they meet even what conservatism is. It's like I'd like to think. I mean, I respect him and all, but half the time it's like, I don't think these are good. I don't think these are conservative decisions. So me and Thomas do not get along that well.
I think his best decision, even though it was a concurrence, I'm not sure if it was a McDonald or Heller, where he essentially said, this whole thing about substantive due process is BS. He was like, we need to just put it back to the privileges or immunities clause of the 14th Amendment.
I think he's right. I'm not sure what it would. I'm not sure what it would get us. I don't think he's wrong. I just don't think it's worth. I just don't think the juice is worth the squeeze. I think if we actually took the time to do that, we'd pretty much wind up exactly where we are.
No,
So,
because
like,
you
what's the
still have
point?
things that are not incorporated. His argument is just incorporate everything. That's what they wrote it for.
What?
You have the
Grand juries and quartering is left to not be incorporated?
But literally his argument is that they literally wrote the privileges or immunities clause.
Oh, I think he's right.
Incorporation.
I agree.
It's literally in every
He's not wrong.
transcript and everything you wrote, right? And then they read it out.
I know.
Now,
slaughterhouse cases were some bullshit. You don't have to convince. You don't have to convince me about that. I'm just not sure.
This bullshit of substantive
I'm just not sure fixing it at this point is worth the squeeze. It's just
it's a one-liner. Hey, privilege or immunity clause incorporates them all to the states. That's what it was meant for. Boom, game over.
I don't know about that, but okay.
And he says it'll clear up the Second Amendment because he's right. It'll clear up all the Second Amendment garbage. It'll clear up everything. It's just like, you're done. So I agree with that, but. I don't know. I think that's his best decision, though. His best concurrence is that concurrence, because that reads very well, because he attacks substantive due process. He doesn't say he doesn't want. For those of you who don't know, I'm sorry, I'm talking. Substantive due process is the way. It's like the First Amendment. The First Amendment was originally only against the federal government's intrusion against speech. States could violate your First Amendment rights. They could, and I've heard the case Baltimore v. Bollinger. Was that the case? So there was a case, Baltimore v. Bollinger, which was overturned by the 14th Amendment, where the Supreme Court said the First Amendment protections, the Bill of Rights only apply to the federal government and not the state. So the states could have a state religion. The states could do it. The states can do whatever they wanted. So then they passed the 14th Amendment, and the 14th Amendment essentially says, and the privilege or immunities clause said, hey, these apply to the states. But then you had the slaughterhouse case, which said, no, they don't apply to the states. The privilege or immunities clause doesn't apply to the states. So essentially, what they did was say, well, there's a due process clause in the 14th Amendment. And to have due process, substantive due process that's meaningful, you have to have the freedom of speech. You have to have the right to an attorney. You have to have you have to have the Fourth Amendment protections. So you could have substantive due process. So that's when you hear incorporated. There's incorporated to the states through the 14th Amendment, because to have true due process, you have to have a right against unreasonable search and seizures. You have to have a right of freedom of speech and those type of things. So substantive due process is the way they incorporate your Bill of Rights to the states. Sure. Even though I said that in a long-winded way, but
that's okay.
That's essentially what it is.
You're geeking out hardcore on some deep 14th Amendment lore, and I'm here for it.
No, I'm telling the audience, because we all talk substantive due process. Like, what the hell are they talking about? So, no, but this is great stuff. This shows you how the law has evolved over time. So,
yeah.
All right, brother.
Why don't you tell us a little bit about yourself? I know you just did the VidCon thing, so tell us about that. How you're doing? What's life like? People love you, Nate.
Oh, I'm all right. I'm about to get into these videos right now. I think I'm gonna do a separate video for each one of these cases, because I have them all.
Yeah, I probably will do some of them. I don't think I'm going to release them all at once, but I'm going to try to do like something about yesterday's cases probably for tomorrow, and then I'm going to like break up today's cases. Probably do Birthright tomorrow and really piss off everyone. So that sounds like fun.
Yeah, but it's just like, so I think Birthright. I'm probably going to do all five, and I'm just going to do like quick hits. Like, okay, here's what this case means. Here it is, because I think there's a lot of spin out there right now about this. So I just want to just, hey, this is just what, and I do think the way they use, it just fascinates me the way they use Dred Scott, because I never thought I would see a Supreme Court.
Yeah, no, I caught my attention. It's like we bring Dred Scott, and then we brought slavery into support for the propositions. I'm like,
God.
wow,
I'm like, what's going on?
Wow, this is. I was like telling my chat, this is not the way to go. Like, just don't cite the black codes as support for your proposition. Don't cite slavery for your proposition. Just leave it alone, man.
What's going on here? Yeah, this was like, wow. And to really see the conservative justices going after it, like this wasn't this. The Chief Justice was literally calling them like, "Hey, they want to bring back Dred Scott." This is kind of crazy. Oh, somebody asked, "Was TPS good temporary?" Yeah, I think I don't even know why they even went up for cert. Like that should have been done in the lower court. The temporary status for Haitians and stuff. I'm like, I don't even know why that. Like, temporary means temporary. That's essentially what that case meant to me, right? That's what it meant, right? Temporary means temporary. You're not here. Like, I don't even know why.
I have some reservations about the metering decision because it's like I didn't mind the metering policy itself. If the Supreme Court had said, like, because of practical concerns, like the amount you can process is obviously a natural limitation.
Yeah,
I would have understood, but they like, yeah, you don't, they basically like, if they just don't provide services at all, or just tell you to go away because that's okay too. And I'm like, I don't know about that. I had a problem with that decision.
that's Castle Rock. I thought that was coming off like the heels of Castle Rock. In terms of the government doesn't have to, it's not an affirmative. They don't have to do this.
Yeah, I mean, I guess
it's due process.
It did come down to what it means to be at the border versus in the United States. So was in the United States versus at, and I'm like, I thought they would have gone the other way on that for practical concerns. So I predicted that one wrong too. Some of my late term predictions have not been as good this term, I guess. Oh well.
But I to be honest with you, I don't think any of the outcomes. Like sometimes I'll say, okay, this outcome I disagree with, but I really don't disagree with any of the outcomes of these cases because I can really see. Except for the one that I would quibble with would be the birthright citizenship one. But even that, I'm like,
yeah, I'm gonna have to get back to you on that one. I'm gonna need to listen to a lot more both left and right wing opinions. I'm gonna have to read Thomas's opinion. I'll get back to you in a couple of weeks what I think about it.
Read Jackson's opinion.
Do I have to?
No, it's hilarious. It's just like, yes, we believe it.
I've already read hilarious. I already read Jackson's hilarious opinion in the Second Amendment case from Hawaii, where she said, this doesn't restrict the Second Amendment at all. I'm like, or gun rights at all. I'm like, oh, okay. Well, I'm glad that was cleared up. Thanks.
Yeah, but that was dumb because for those of you who don't know the Hawaii case, essentially there was a if you were a lawful gun owner and you had your gun on you and you walk into a business, and if you walked into that business but didn't have express authorization from the owner of the business, or there was a sign that says welcome all gun owners, it was like a felony to bring your gun, even if you were lawful. But the kick was these places were open to the public. So they called them vampire laws because it was like you had to be invited in. Vampires have to be invited into your house. So they called them vampire laws. So the Supreme Court said, well, it should be the opposite way. If you don't want somebody to bring firearms to a place that's open to the public, you need to warn the person, because essentially you're making them, because you're carrying a weapon, you're making them by status, criminalizing them. So it's now up to the businesses, if you don't want somebody to be armed, to have that up on the window. Do not, and that's how they do it here in Texas. If they don't want you to bring a gun in, they have, there's a certain businesses you can't bring them into, like places of alcohol or churches and things of that nature. And then there's a separate level where if you're a business like Walmart and you don't want people to bring guns in, you have to have a sign. That sign has to have it has to be certain, like that, like you have to be told this is you can't be, there's no thing where it's just like you're automatically not allowed to bring guns in here. So I think that was a good opinion in terms of, but now I know Gorsuch, he's itching to get to the New York law, the New York one. Did you see his concurrence in what's the last Second Amendment case? Like he's itching to get to because the New York law in New York,
restrictive by declaring everything sensitive.
In New York, yeah, number one, they do not only declare to get a gun in New York, you have to file the paperwork. You have to be gotta wait 6 months. Everybody who's in your household, even if they're there temporarily, has to write an affidavit saying that they're okay with you having even if you own the home, that they're okay with you having a gun in your own home. And even on top, but then after that 6 months is up, you have to go to the police department and be interrogated by an officer for about an hour on your need to have a gun. And if that officer feels in their own experience that you just want to have a gun just to have one, they can deny you access to the gun. And even if you get the permit for a gun, you still got to wait like another year to then get the license to actually be able to go buy a gun. Because now you got to go through a whole nother process to actually go buy a gun. So Gorsuch read all of it in a concurrence. It was like, and essentially was like, my God, please let this come out of the Supreme Court, because this is the most restrictive thing on gun ownership ever. Just imagine you had to go through all those steps to have free speech, to do your religion. That's
right. Exactly so.
Yeah.
Well, we're definitely going to have to discuss this more later, but I've really enjoyed this brief hit. So you do your thing, I'll do my thing, and we'll talk some more later about this. But it's a great day for the Constitution, a great day for these cases.
Oh my God, it's a great day for cases. But we will definitely talk, brother. Thank you for inviting me Take care, chat. Hopefully you guys learned something. I know I did.
All right,
Peace,
guys.
brother.
Peace for now. Bye.